No.
My lord, may I have your lordship's kind leave, my lord, for release of the matter, my lord, item
no.
221.
Sorry, no.
My lord, for release.
Call on the list. No mentioning, please. No.
To be mentioned item
Call on the list.
to be mentioned item number 1 for
May
withdrawal.
I be permitted to mention item 130, my lord, 2 days rest, my lord.
One. Huh? Ki eta?
May it please your lordship.
You mention one eta. Eta two.
My lord,
One who is appeal.
my lord, I am for the petition.
Yes.
I am for the state one. This is for the,
This is regarding which determination. What is the matter about?
my lord, the matter is,
Non-prosecution.
no, it is
No,
not.
no.
No, not withdrawal.
Not even withdrawal.
Jail
Determination.
transfer.
Lack of determination. Yes.
Jail transfer, my lord. The present petitioners,
Yes.
my lord, are languishing in as an under.
My lord, in this matter, Mr. Gali is
Let me hear him.
My lord, the present petitioners are under trial prisoners. And my lord, they are in behind the custody when the trial is going on.
Achha.
Now, my lord, the problem is that these present petitioners are being kept in a solitary cell for more than 6 months, over 6 months. And my lord, this is absolute flagrant.
Tomorrow at the top.
Tomorrow.
Tomorrow at the top, ask Mr. Galip to come.
Most obliged.
Thank you.
Item to be mentioned item number 2.
This is my application, my lordship.
So they're not appearing today also.
I have served once more in terms
I
of
am
your
appearing on behalf of respondent number 124.
I've heard the matter at length on the last occasion. What is your reply?
My lord, we have no objections if the hold is lifted. However, I strongly object to statements made in paragraph 35 in the writ petition. I may be allowed. It is evident that the business of the respondent number 1 is being conducted with the intent to defraud its account holder. Your Honor, we are not defrauding. It's merely a instruction given by the police authority to us, and we are abiding by it. And in fact, it is putting a dent on my business because the petitioner is a very valuable customer to us. The transactions have been stopped. We have no objection if the hold is lifted.
I have recorded my reasons for the order which will pass today, but I'll make it an order of the court. I'll put it as for orders tomorrow. I'll record your submission. Heard learned counsel for the petitioners as well as the respondent was 1 to 4. Full learned counsel for the respondent was 1 to 4 contents that the said respondents do not have any objection to removal of the lien on principle, however, the said respondents strongly deny the allegations made in the writ petition, in particular paragraph number 34.
35.
Paragraph number 35 thereof. Full next para. Since the matter pertains to a question of law, no affidavits are invited. Full it is deemed that none of the allegations made in the writ petition are admitted by the respondents. Full the matter is closed. The hearing in the matter is closed. Judgment is reserved in the matter. I'll set aside the lien. I'll pass my order tomorrow. Because they are appearing today, I'll make those changes.
I'm grateful.
I'll give my reasons and set aside the lien.
I'm grateful.
Tomorrow to for orders the first matter.
Very grateful. Very grateful.
Thank you. এটা চেম্বারে পাঠিয়ে দিই। হ্যাঁ, এটা একটু কিছু চেঞ্জ করবো যেহেতু আজ ঘোরা। এই অর্ডারটা পাস হবে। তন্ময় যে অর্ডারটা আমি পাস করলাম তার সঙ্গে আচ্ছা বাকিটা তো ফরওয়ার্ডার্স আমার পল্লব এখন নেই, আমি তো কালকে ফরওয়ার্ডার্সে রাখলাম, বাকিটা চলে যেও আমার মোটামুটি অর্ডারটা করা আছে, বুঝলে তো? জাস্ট একটুখানি কসমেটিক চেঞ্জ হবে, আমি তোমাকে বলে দেবো, তুমি এই অর্ডারটা নিয়ে চলে যাও। থ্যাংক ইউ। ইয়েস প্লিজ কল।
Top item 3.
My lord, for the petition.
Yes.
May I file the report, my lord?
Yes, please.
Copy? Yeah. Oh, sorry. They're being shifted out of the correctional home. My lord, they're, my lord, in a women's home, my lord. My lord, the documents have been annexed.
So I'll dispose of the
My lord, I have instruction that the children lodged in different homes have not been united. My lord, my only
That
place,
is probably beyond the scope of this court to direct.
my lord, it is one of my prayers, my lord.
Reuniting, whether we can direct, I have my
My lord,
reservations on that.
my lord, it's been since 2016 they are lodged in different
I
homes.
appreciate,
They are-
but since these people were there in a particular shelter which was Dihorjala, that is the reason for the court interfering. They cannot be kept like that. So the state has taken steps and removed them to a women's home. Could not be better for, I mean, in the circumstances, could not be better.
My lord, we are
Reuniting is something which the administration has to look into.
My lord, most of them have even reached majority, my lord. They are lodged in juvenile homes, my lord.
There are so many people pining in juvenile homes just because the advocates do not appear in time. And the juvenile home, the heads of the juvenile homes do not coordinate properly. Now, not all homes, most of the homes. I'm speaking from personal experience, I've seen the homes. So we cannot rectify that by way of a court order in a particular matter. This matter can be resolved only by keeping this on record and giving you liberty probably to apply. I mean, I don't know where you will apply. There is no forum for this.
My
To
lord,
unite you.
my lord, I have instruction that the learned court below had directed if the state government want, they can be reunited with their parents.
I'll give you liberty to approach the state government with appropriate applications. Let them consider.
My lord, it is one of the prayers, my lord, in the writ
That I
petition.
cannot grant. I'm sorry.
My lord, we will be just praying, my lord, so that they can be reunited with their husband also, my lord.
I'll
They're
record your
living in,
prayer, but I cannot.
my lord, in Hyderabad.
Now, after
My lord,
uniting, you will become anti-socials now.
My lord,
You are social till now, but after reuniting, you will become anti-social. No, I can't take the risk.
my lord, we are extremely grateful, my lord.
A report in the form of an affidavit is filed by learned advocate general on behalf of the state as per previous direction. Full stop, the same be kept on record. Stop. There were two components to the present challenge. Full stop. The first is that the petitioner has been languishing within the precincts of the correctional home, despite the statute providing otherwise. The second component is that the petitioner seeks to be reunited with her family, particularly her husband, who is who has been incarcerated elsewhere, who is located elsewhere. Next para. As far as the first component is concerned, the state has taken care to redress the situation, since, as per the report filed today, the petitioner has been placed in a women's home, which is a safe home stroke shelter beyond the precincts of the correctional home. Next para. However, insofar as the component of reuniting is concerned, it is beyond the scope of this court, sitting in writ jurisdiction, to so direct the administration. However, the petitioner and or her husband will be at liberty to make a proper application before the appropriate authorities seeking such reuniting and placement in the same location. If such an application is made, the respondent authorities shall consider the same and, only if considered safe otherwise and in accordance with law, the said request for reuniting will be adhered to, will be acceded to. Next para. However, the writ court cannot pass the second prayer as made by the petitioner. In view of the matter being resolved with regard to shifting of the petitioner outside the correctional home precincts and placement in a safe home, WPA 1609 of 2022 is disposed of without any orders to cause.
My lord, may I pray for one indulgence? My lord, on last occasion, my lord had indicated when the state files a report, we may file an exception to it. So, my lord, kindly keeps
No.
it pending for one day,
No.
one more day, my lord. My lord, kindly indicates that the children.
Pass my order, I'm sorry.
My lord, so that we can file an for the children.
Call on the
also,
matter.
My lord, I
Item
apologize.
four.
My lord, I came late. My lord has allowed the safe.
I've directed union to reunite. They are placed in a safe home and the union will reunite.
I'm indebted. My lord.
Indicated the husband and the petitioners. to be-
Whatever I've indicated, please find it in the order. Yes, call on this.
I'm
Item,
grateful, my lord.
item 4,
My lord, I am appearing on behalf of the petitioner, my lord.
Yes.
Here, the petitioner is in custody for 22 years, my lord.
Hmm.
And my lord, in the year 2021, I preferred a writ application. There, my lord, the order was given to dispose of the prayer within 3 months. Subsequently, my prayer was rejected without assigning any reason. But my lord, 22 years I'm in the custody, my lord. A report was called for probably, my lord. Kindly seize the report. Why my prayer was rejected?
Lordship, I am appearing for
The
the
report
state.
was not called by this court.
আগের দিন report চাওয়া হয়েছিল?
No, no.
Oh, sorry, my lord. No, no, no.
Previous matter maybe.
No, no, no.
Yes, please,
Sorry.
yes.
Lordship, I am appearing for the state. The reasons have been duly given. Annexure 8, page 28, the reasons have been given. And there has been subsequent development also, Your Lordship, in this matter. The subsequent development being that his case has been again shortlisted again for consideration in the next meeting of the State Sentence Review Board.
When is it scheduled?
The letter states 15 March 2023. It will be in short, shortly it will be held. Your Lordship, I have specific date. Can I?
Page 25.
I'll direct you to then reconsider his case without being influenced by your previous rejection. I'll
Your
do that,
Lordship.
and I'll put in an expectation that it will be done within, say, 1 month. Sentence review.
Whatever falls from Your Lordship, because a specific date has not been given. of
My lord,
instruction.
may I humbly state one thing?
Yes,
Kindly
Mr.
comes to
Chairman.
page 25, my lord. A report was filed on 2021 in my previous read, my lord. Page 25, I am reading, my lord, kindly allows me. A report has been filed by Mr. Banerjee Lanet, Senior Standing Counsel to the Superintendent Presidency Correctional Home, which has indicated there is nothing adverse against the petitioner and
That
his
is the
conduct-
superintendent. There are several components, several people involved. So jail gives a report, police gives a report, everybody gives a report. Except this person, your client, everybody will be giving a report. So those will be considered by the state
My
level.
lord-
You know the system.
My lord, then within 1 month, as it has fallen from your
Preferably within 1 month, without being prejudiced by a previous
and my lord,
rejection.
following the NHRC guidelines, your lord,
Following everything
Yes,
under
my
the
lord.
sun. Yes. I'll not say that under the sun, but all the relevant guidelines, and I'll put it vague because there are several guidelines.
my lord.
Mostly the guidelines you are referring to, the National Human Rights Commission. There are several judgments also, Mr.
Yes, my lord, it has fallen from your lordship also.
Not me, Supreme Court, several
Yes, yes,
judgments,
yes.
several judgments
My
of
lord-
several high courts. Yes.
Only one humble prayer will be there, my lord. If within 1 month they do not pass any order, my lord, liberty may be given to come before your lordships once again, my lord. My lord, each and every time they are saying no adverse report is against me. Thereafter, my lord, they are rejecting my prayer without
That
assigning
liberty
any
is always there. Give you that liberty.
Always it's inherent, Your
All,
Lordship.
if it is rejected also, you have always a liberty to come.
My lord, that is true. that
Because
true,
this
my
is on the anvil, Mr. Chatterjee, I don't want to prejudice that.
lord. Grateful, my lord. If
That
it
is the only reason. I'll record that.
done,
in
my
my-
lord. I'm grateful to your lordship.
The petitioner is aggrieved by the rejection of the respondent authorities of the petitioner's request for premature release. First up, it is contended by learned counsel for the petitioner that he is in custody for more than 22 years now. Full stop, next para. It is contended that on the last occasion, comma, pursuant to a direction of a coordinate bench of this court, comma, the petitioner's case had been considered, but it was rejected again by the respondent authorities without giving any valid reasons for such rejection. Full stop, learned counsel submits that there is a guideline of the National Human Rights Commission in place, comma, apart from several judgments of different high courts and the Supreme Court, comma, which stipulate the exact criteria which are to be taken into consideration in such cases. Full stop, it is submitted that those were not adhered to by the respondent authorities while rejecting the petitioner's request. Full stop, next para. Learned counsel appearing for the state files a report, files a written instruction, comma, where it is indicated that further assembly of the State Sentence Review Board is on the anvil. Full stop. It is submitted that the petitioner's case is one of those which have been shortlisted for consideration in the said meeting as well, afresh. Full stop, next para. Since the state takes a stand that the petitioner's case has been shortlisted and shall be placed very soon before the oncoming SSRB meeting, comma, this court is not inclined to prejudice the outcome of such consideration by passing orders either way. Full stop, next para. The written instruction filed by learned counsel for the state today be kept on record. Full stop. WPA 1797 of 2022 is thus, disposed of by directing the respondent authorities to convene a fresh meeting of the State Sentence Review Board within bracket SSRB at the earliest, positively within 1 month from date, wherein the other cases, along with the case of the petitioner for premature release shall be considered afresh, without being prejudiced in any manner by any of the observations made in the previous rejection of the same and or the previous rejection itself. Full stop. Liberty is granted to the petitioner to move this court, in the event the petitioner is not satisfied with the decision taken therein. No order is to cause certain setting.
My lord, a copy may be given to us. So that, my lord, if it can be perused for our.
It's written instruction, your lordship.
So since I've kept it on record, you can give a copy to him.
Grateful,
Please give
my
a
lord.
copy by tomorrow. Do you have an extra copy?
I
Can you
don't
take
have
out a printout?
I don't have. I
Take out a
will,
printout, give it
I will
during the
send it
course
to
of the
him.
day. একটা line add করে দিন, a copy of the report filed today be handed over to the learned counsel for the
Lordship, the only problem,
petitioner by tomorrow.
I seek your apologies. Lordship, the only problem is that it's a written instruction for your lordship's eyes. So I don't know whether
If your
it will be in a good
lordship
sense.
My
to-
eyes are public eyes now. Yes.
If your lordship.
No, that's why I've put it in my order. Otherwise, it would be embarrassing for you.
Much of
That is not mere instruction. That's why you have a report basically.
report basically.
So I put it as instruction because it's not captioned as a report. It's a report for all practical purposes.
Okay.
Because that's why I put it in my order.
To
So
hide
that-
your lordship, but for your eyes.
Nothing to hide, I know that.
Ah.
Yes.
Grateful, my
This is not privileged instruction. The moment I say that give a copy to him and I take it on record, so it becomes public knowledge. They can take out a certified copy also.
Grateful, my lord.
But don't compel them to take out a certified copy. Give a copy.
Item 5 and 6.
Yes.
My lord.
Yes, Mr. Bandavadde.
I'm waiting for the WPA.
My lord, it was the replacement of the poll, my lord. Thereafter the modification application filed by the private respondent, and it was after amid resistance by the private respondent, the state respondent has carried out the with slight modification, but I can.
This has become infractious.
Yes,
Give the
No,
good news.
the writ petition modification has been complied with, my lord. But the contempt application, my lord, still I have against the private respondent, I still have a case, my lord.
Poll has been.
No.
And my instruction on poll has been erected.
Electricity collection has been.
He was running from pillar to pole. So the modification sought by you.
Modification sought by me and the private respondent. Modification sought by the private respondent has been rejected by the.
You are not the private respondent in the main writ petition.
No, I am for the petitioner in the main writ petition and also in the subsequent writ
Acha.
petition.
So
I
your
filed-
contempt remains, you say.
My contempt remains
What was the
against the
contempt?
private.
What was
Since, my lord, because of their physical obstruction, the state of the ACDCL failed.
So my lord, my work has been completed, my lord.
No, I have no grievance against ACDCL, my lord. My only grievance is that due to the resistance given by the private respondents, ACDCL failed to carry out the
Contempt, I directed you to serve a copy of the contempt application.
contempt application on the private respondent.
I'll drop it. Learned counsel for the WBACDCL files a compliance report whereby it is indicated that the order passed in the writ petition, that is WPA 11239 of 2023, has been complied with. Full stop, next para. Hence, the modification application becomes infructuous. Full stop. Accordingly, what is the number of the modification application?
Can 1 of 2023.
What is 2?
2 is by the private respondent, which has already been rejected by your lordship.
Accordingly, 1 of 2023 is disposed of by keeping the said report on record. তাহলে এটা কি? তাহলে accordingly ওটা dispose of না বলে last sentence টা হবে accordingly no further order need be passed in that regard. Full stop. এবার contempt টা নিচ্ছি. The allegation in the contempt application is that due to resistance of the alleged contemners, the work as directed in the writ petition could not be carried out, full stop. In view of the same having been carried out in the meantime, the extreme measures contemplated in a contempt action are not required to be taken. Full stop. Accordingly, CPN 762 of 2023 is disposed of accordingly. Accordingly, বোধ হয় দুবার হয়ে গেল, একবার দিয়ে দেব।
The report filed on behalf of the state is taken up.
Reports করে দিন, reports filed.
Grateful, my lord.
Item 7.
7, yes.
Lord 7, my lord, I am for the petitioner in this
Right.
matter.
Right.
I am for the
state, your lordship.
Yes.
This is my evidence of service. On 19 July, your lordship take up.
Means that's the state is the only the main.
No, my lord, the corporation is there, my lord. There's a money claim.
Oh, acha.
My lord, there was a direction to file a report indicating, my lord, the reasons for non-disbursal. And my lord, in the event the said respondents have any dispute with regard to the bills, the same shall be indicated in the said report, my lord. For that report, my lord, I am seeking a short extension, my lord. But because there are certain disputes, my lord, we
We are
wish to
lucky at least the corporation is represented.
but this
I'm
one
telling you,
is
really. I mean, I've been seeing in several matters that
But-
was there an upheaval in the panel?
well, this corporation will be represented, my lord, as and when the matter comes, my lord.
Kolkata Corporation.
This is not
I guess
KMC.
so. I guess so now. Yes.
It's not KMC, my lord.
K.
It is BMC.
Oh, not KB.
Vidhannagar
We are on MCs totally. So this is BMC already.
PMC.
My lord, on the last occasion for that matter in this,
When should I keep it?
kindly give me 1 week.
Yes, what? On the prayer of the this is Bidhannagar.
Vidhannagar Municipal
On the
Corporation.
prayer of the Bidhannagar Municipal Corporation, comma, the time for filing report is extended for a further week. Full stop. Let the matter stand adjourned till August 11, 2023, when the report shall be filed upon circulation of an advance copy of the same to the learned advocate for the petitioner. Grateful, my lord. I'm not giving you liberty to file an exception. If necessary, only then I'll give you that liberty. Otherwise, we'll dispose of them.
আমার নামটা একটু, Lord, one thing, Lord, my name is wrongly recorded in the list. Ruchira Chatterjee, I am not the Ruchira
No,
Chatterjee.
you're not Ruchika Chatterjee. That I also.
But all time,
কোন লিস্টে কিসে এতে
yes, yes.
তা কেটে ঠিক করে দাও কম্পিউটারে ঠিকঠাক এন্ট্রি হয়
Grateful.
I
Thank
did,
you.
Item 8.
State petition.
The state, basically the answering respondent is a private dispute.
What?
Well,
Yes,
state is
item-
one of the parties, the police. We have the report with us.
All right, all right. Yes.
My lord, item number 8, my lord, I am led by Mr. Shoktinath Mukherjee, learned senior advocate, my lord.
So Bashar is there, but Mr. Mukherjee is not there.
Mr. Mukherjee is not there, my lord. If your lordship, my lord, kindly passes over the matter, my lord, subject to your lordship's convenience, my lord.
Not my convenience, Mr. Mukherjee's convenience and your learned friend's convenience. He's in difficulty today.
Yes, my lord, there is some difficulty with the.
Technical,
Yes,
appreciable. When should I keep it? Tell me.
my lord, any day, my lord, tomorrow, my lord, any time, my lord, subject. to-
Tomorrow I'm keeping it fairly at the top of the list. That bracket will be there. On the prayer of the petitioner, the matter is adjourned for the day and shall be listed fairly at the top tomorrow.
Item 9.
9, yes.
I am
Yes,
for the
Mr. Halder. Yes.
My lord, I appear on behalf of the CS,
Usual order, Mr. Halder and Mr. Mukherjee.
more or less.
Combination is usual. So
Petitioner is the owner of a shop room and duly mutated in the Bhojpur municipality.
the most crucial factor in these matters, Mr. Halder, is service on the private respondent.
No private respondent.
No private respondent, then it's over.
For new service connection for the said shop room, mutation has been done in favor of the petitioner.
Why not being given, Mr.
My lord, there is already a service connection, there is already, he is enjoying a meter, my lord. So we have rejected that, my lord, let it be referred to the GRO.
Lordship.
No, tell
that-
me.
That is okay, Lordship, but kindly comes to paragraph 9 of the writ petition, once, Lordship. I have said that the service connection exists in 161 Mahatma Gandhi Road. And my shop is 160 Mahatma Gandhi Road. I have applied for the said shop room.
If it's just separate connections.
My lord, my specific instruction is, my lord, in that premises, there is a service. And my lord, he is
Instead of asking for a report, I'll refer it to the GRO, it will be easier.
deriving
because
supply
You
from.
lose a forum otherwise. Learned counsel for the petitioner contends that the petitioner sought for a new electricity connection, which was refused, comma, primarily on the ground that there is an existing service connection enjoyed by the petitioner in the same premises. Full stop, next para. However, comma, learned counsel for the petitioner submits that the service connection which is existing is in respect of a different premises from where the connection is now sought. Full stop, such proposition, however, is disputed by the CSA Limited. Full stop, next para. Since factual dispute has arisen on such score, an adjudication by the writ court would prematurely deprive the parties of a forum. Full stop, since under the governing regulations, the grievance redressal officer is the appropriate authority to decide such disputes, WPA 18025 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned GRO for resolution of the issue. Full stop, if so approached, the GRO shall decide the issues between the parties in accordance with law as expeditiously as possible and on giving opportunity of hearing to all concerned, preferably within 6 weeks from the date of such approach. No address to cause urgency.
I'm grateful. Grateful.
Upgraded matter, item 10.
For state lordship.
State Union, obviously, Mr. If you're not appearing for the Union of India, then tell me.
I cannot.
Nowadays, at least.
I cannot appear in any other matter except.
No, you cannot. That's why I'm telling.
Terms of our rules framed by the.
At least not in a writ matter, probably.
No, not any matter.
In any matter.
Yes, without the permission of the law ministry. Now, this is a matter
Yes.
where direction for affidavit was given.
Okay.
Affidavit is ready, but there is some technical difficulty. It has to be.
Can you file it by tomorrow?
Well, I am serving today the advance copy.
Very well. Please serve an advance copy.
I should apprise your lordship. This was appearing at the bottom. This has been brought to the upgraded matter
I mentioned
without any notice to us.
Give a notice. Why don't you give a notice?
Since June, it was there.
Then you just giving
I
a notice
mentioned-
won't do any harm to. This is expected in any adversarial system.
I admit.
Give a notice to
Nobody
the-
should mention.
We
without-
should also exchange. We should also exchange the citations if we want to rely on any prior to coming.
Ma-
to court. That would make matters easier for the
My
court, for you, and
instruction
for
is-
everyone.
My instruction is, though written letter has not been given, but it was duly informed to the clerk of my learned friend. Who? By the junior, Mr. Bhattacharya's clerk has been informed.
Maybe, may not be. Why go into that? Give a written notice always, please. So I'll extend it till tomorrow. The time for filing opposition. Reply will extend for a further week. I'll take it up.
The affidavit has to be sent anew to the Home Ministry.
Oh, achha. So what?
Technical defect in the
Very well.
affidavit.
What period should I give to you? Tell me.
3 weeks. 3 weeks.
Not 3 weeks, Mr. Bhattacharya. 2 is more reasonable.
It has to be again resent to them.
Send
Their
it
signature
today.
is
Send it today.
No, today I itself am sending, that means it will come back from there, madam. That is why 2 weeks your lordship, even.
This is
So
a
it
freedom
has been
fighter.
prepared copy will be given to us, not 2 weeks time will be to have the only appointment.
You have waited till
I am Mr.
1947.
Laway.
You have waited till 1947. Wait for a few
Bargain is there.
months.
I will not never bargain. I will not.
The prayer of learned counsel for the Union of India, the time for filing the state is not
No, lordship, we
Very
don't have any function.
on the prayer made by the learned additional solicitor general, the time for filing affidavit in opposition is extended for 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. The matter shall be listed for hearing on September 11, 2023. September.
No, can
11 some difficulty.
Given. Because in the 16, my learned friend is appearing. I will take same direction. For
I'll pass same direction when it is called on.
Because one matter is calling, I have to go.
No,
there.
not haphazardly. That
Sorry,
creates
no,
difficulty.
no,
Let it be called on. Ask your juniors to remain, both of you, please. I'll just pass it.
top in Aslew, my junior is saying, pay for to appear at the top. I'm saying, even upon mentioning it will.
Let your junior remain, wait for the rest of the day. You go. Yes.
No, but last minute, item 10.
Oh. Anyway, let us not be on those.
Item 11.
11. Yes, Mr. Vandod.
Kindly see the last
Private
order on
respondent.
16th June 2023.
Yes.
Wherever your lordships directed the executive magistrate to file a report. Yes, my lord. I am available.
You are for the Finance Limited.
Yes, I'm for that. The matter is short, my lord. There was an
You can
order
vote it.
passed under section 14 by the district magistrate, authorizing the respondent number 2, the executive magistrate, to take the physical positions. My lord, the
But
order
already
was
the
of 25th
physical-
of October 2022. Now, since then we are waiting, the executive magistrate is not giving us that because it requires my lord the presence of police. Now, the executive magistrate will first give a date.
I sought for a direction from the executive magistrate.
Yes, my lord.
Yes. What is your stand?
Already the.
Let me hear them first. Yes. What have you taken?
Already,
My lord, kindly.
You are not for the executive magistrate.
Milord, I am for the
So
private.
let him argue first. Yes. What is your point here? What is the reason for the delay?
Kindly see the report, my lord.
You have not gone through your own report.
Last two paragraphs of first page.
Panchayat election. For this also. Panchayat election is a panacea for every. Anyway, what is your stand?
Already-
Your stand, I know. What is your argument?
Already, the position has been taken. And
Let it be taken again then.
Milord,
They are
already,
fancy.
Milord,
Finance company, let them spend again and
Milord,
let them take
already
possession again.
DRT is.
You cannot be
pending.
affected if it is taken already.
We have to challenge the said DM order before the DRT being SA case number 752 of 2022.
Did you obtain an interim order there?
No, Milord.
Then
The
they'll
next date is fixed on 9th August.
9th August.
Yes, Milord. For interim order.
I'll give them a chance till then, Mr. Bandyopadhyay, to obtain an interim order. I'll keep it on 10th at the top. Learned counsel for the petitioners submits that the petitioners made an application under section 14 of the Surface Act 2002 as long back as on October 25, 2022. However, till date, the executive magistrate has not given adequate.
One addition. My lord,
Yes.
probably they are wrong, my lord, in saying, my lord, there is no application so far as this property and this loan account is concerned.
Yes, Milord.
Because they
There are
have, my lord.
Milord, there are three.
Mr. Bandyopadhyay, 25th of October, section 14 order was passed or application was made?
Section 14 order was passed.
Oh, I'm sorry. Tanmay, ওটা কেটে দাও। Very well. I'll say that it is disputed. In any event, I'll keep it on that date to give them benefit of doubt. Learned counsel for Learned counsel for the petitioner submits that the petitioners stroke financial company, obtained an order under section 14 of the Surface Act 2002 as long back as on October 25, 2022.
My lord, 20th October, 20. Sorry, my lord.
No,
I'm
no, it's
extremely sorry.
October 20, 2022, pursuant to which the executive magistrate was to give police assistance for the purpose, police corona. Executive magistrate was to give assistance for the purpose of taking possession of the secured assets. Full stop. However, till date, nothing has been done in that regard. Full stop. A report is filed on behalf of the state, indicating that due to the recently concluded Panchayat elections, it was difficult for the executive magistrate to extend such assistance. Full stop. However, there was no deliberate or willful inaction on the part of the magistrate. Full stop. Next para, keeping on record the said report, it transpires that there cannot be any impediment in implementing the order of the magistrate. Full stop. Next para, however, at this juncture, learned counsel for the private respondent submits that SA number 752 of 2022 is pending before the concerned debts recovery tribunal with regard to the order of the magistrate. Full stop. Next para, learned counsel for the petitioners opposes such contention and submits that the said essay is in regard to some other matter. Full stop. Next para, be that as it may, to give a last chance to the private respondent to bring an appropriate order of stay, if so passed, the matter is adjourned till August 10, 2023, when it will be listed at the when it will be placed at the top of the list for passing orders. Full stop. In the event any order is obtained by the private respondent in the meantime, the learned advocate on record for the private respondent shall produce a written instruction and or copy of the order on the next returnable date in that regard.
Grateful, my lord.
Thank you.
10.
No, it is.
Reported copy
Item 12.
Yes.
My lord, this is my application, your lordship.
I am for the state lordship.
My lord, before entering into the, my lord, merit. My lord, before entering the merit, my lord, this is my two affidavit service. First one is, my lord, prior service, and then, my lord, after mentioning when it was upgraded, that service. The second service, my lord, I did not found that the my lord service has completed, but the first service is completed. If your lordship permit me, then I will place the matter.
No, second service, why was the
Second service, my lord, because after upgradation mentioning, I intimated them. So that service is not been.
That is regarding the notice of upgradation.
Yes.
The private respondent is not appearing.
Private respondent is not here, my lord. My learned friend is appearing for WBC and state.
You are for?
Oh,
You are for private respondent.
then my lord,
I take up the matter. Please
Yes.
come this side.
yes.
Lordship, I want to
Stand
file
within
public,
the range of action of Mr. Ghosh. Yes.
Lordship, I want to file my report, Lordship.
Yes, Mr.
My
Ghosh.
lord, kindly come to lordship page 30 first. It starts from 32 lordship's order.
What was the order?
In-
Tell me. Yes.
In respect of my lord, electric connection, my lord.
You wanted to approach magistrate. Yes.
Yes.
You
magistrate
wanted wanted electricity connection
my lord.
opposed by the magistrate. What
Magistrate.
is the order of the magistrate?
My lord, magistrate order is my lord. It's page 38.
You are challenging that.
Yes.
Yes.
Pendency of the partition suit, my lord, magistrate declined to.
সময় আগে আমাকে বলতে হবে ইলেকট্রিসিটি বোর্ড আমি তো পাঠিয়েছি
And
Have you produced anything to show that you are in occupation?
yes, my lord, kindly come to page 25 once. In the top, my lord, the order of my lord, interim order. My lord, kindly see the nature of interim order. It's a partition suit, HON'BLE property, both are in possession. And my lord, the order is that the defendants, that is me, are hereby restrained from disputing the share of the plaintiffs over the civil part. I am not disputing, I am not claiming any equity, I am only want the electricity. They are enjoying, I am also want the electricity. Nothing more, nothing less, my lord.
What happened after the commissioner gave a report? Inspection was directed.
Inspection was
Where is
that.
the inspection report?
My lord, report was not with me, my lord. My lord, that is, my lord, before the, my lord, district magistrate, they have submitted, my lord. I made my submission, my lord, that is page 35 before the magistrate, that is 35 and 36. And my lord, I submitted all the relevant documents, and I am humbly saying that, my lord, I am not claiming any equity, nothing, my lord, no determination of share. This is an HON'BLE property. Let me enjoy the electricity. If after determination that portion belongs to them, my lord, record my submission. I will not claim any equity. Only getting the electricity, my lord. This is my application. I am a bona fide occupier, my lord, by virtue of my lord, HON'BLE property. Inherit that.
So you have made a one-storied construction and a meter room also.
My lord. Meter room as per requirement of the, my lord, the
Very well. Let me
license.
hear them. Yes. What is
One.
your objection? Mere pendency of partition suit cannot be an issue.
Yes, my lord. The only instruction, my lord, I'm having that the electricity connection, my lord, is taking over my property. Being
Every inch of the property is of both.
Yes, my lord, that's-
So they'll maintain the safety requirements and give the connection. Why not?
as your
But
lordship-
that will be without prejudice to both of your rights in the suit.
as your lordship
Definitely.
directs, my lord.
I
We
think
are
that will be easiest.
Yes,
Yes.
my lord.
I'll do that.
And my lord, police, if required, police, my lord, after this order, if they have, my lord, again, my lord, can you?
I'll direct the learned advocate on records for the private respondent to give help if necessary, not the police. They'll be present and they'll give you help. The report filed by the state be kept on record. Push-up. The petitioner has challenged an order passed by the district magistrate, which was decided on the basis of a previous direction of court. Push-up next para. Before the district magistrate, a dispute arose regarding the petitioner seeking a new electricity connection in a joint property belonging to the petitioner as well as the private respondents. First up, a partition suit is pending between the parties, where an order of injunction has been passed restraining the defendant stroke present petitioner from disputing the title
share, page
sorry,
25.
disputing the share of the plaintiff stroke private respondents over the suit property. Full stop. An inspection was also held regarding the property. Full stop. Next para. The district magistrate, comma, while observing that the writ petitioner has raised a one-storied construction over the property as well as a meter room, comma, observed that since a partition suit was pending, comma, it was beyond the authority of the magistrate to pass any direction. Full stop. Next para. However, comma, such stand of the district magistrate is disputed by the petitioner. Full stop. Next para. Learned counsel for the private respondent submits that the private respondents are prejudiced since the electricity line is sought to be given over the property in possession of the private respondents, which could create difficulties for the private respondents. Full stop. Next para. Heard learned counsel for all the parties. Full stop. It is cardinal that in respect of a joint property, comma, it is deemed that each and every inch of the property is in occupation of all the co-sharers. Full stop. However, comma, even without proceeding on the premise of bare theory, comma, in the present case, the petitioner, comma, being co-owner, comma, has raised a one-storied construction as well as a meter room. Full stop. As such, comma, the petitioner is in settled possession of the property. Full stop. Next para. Even without disturbing or disputing the share of the private respondents in the property, comma, there cannot be any bar in giving electricity connection to the petitioner, comma, pursuant to section 43 of the Electricity Act 2003. Full stop. Next para. Insofar as the objection of the private respondents is concerned, comma, the law mandates that a distribution licensee shall take care of the safety and security issues while giving a new connection. Full stop. As such, comma, it is expected that such stipulation of law shall be abided by the distribution licensee in any event. Full stop. Hence, comma, WPA 14204 of 2023 is disposed of by directing the WBACDCL to give a new connection to the new electricity connection to the petitioner at the meter room constructed by the petitioner, comma, as expeditiously as possible, comma, positively within a fortnight from date or from compliance of formalities, comma, whichever is later. Full stop. Next para. If any obstruction is raised from any quarter, comma, the WBACDCL personnel shall be at liberty to approach respondent number 6, the inspector in charge of the Chonditola police station, who will act on a server copy of this order and grant such assistance at the cost of the petitioner, comma, if necessary by removing any padlock, comma, if and when put up by any person to prevent the access of the WBACDCL personnel. Full stop. Next para. However, comma, the WBACDCL, comma, while giving such connection, comma, shall ensure that the safety and security measures required in law are maintained. Full stop. Moreover, comma, nothing in this order and dot the electricity connection as and when given to the petitioner, comma, shall create any special right or equity in favor of the petitioner and shall be without prejudice to the rights and contentions of the private parties in the pending partition suit. No address to cause urgent certified copy.
And if cost, if any cost.
At the
Yes,
cost
yes,
of the
at the cost
petitioner.
of the
That I have stated in police.
No, mention
I have stated on the basis of urgent copy at the cost of the petition. যদি না বলে থাকি on the basis of most probably আমি বলেছি. Anyway, that will be there. Thanks.
New motion, item 13.
Yes. You offer the state. None appears for the petitioner, although the respondent state is represented through counsel. Full stop. Let them attest and adjourn till the monthly list of September. উপরের দিকের ম্যাটার সব সেপ্টেম্বর পাঠাবো যদি না থাকে।
Item 14.
Yes, please.
I'm for the respondent number 2, 3, and 4, madam.
Right.
My lord, I'm for the state.
State. Yes.
Deputy with service, my lord.
What is the matter, please?
My lord, petitioner is a widow.
Please take the microphone. Please take. Yes.
My lord, petitioner
Widow,
applied,
yes.
matlab, husband of the petitioner expired on 27 January 2013. Thereafter, petitioner the file application for family pension. They are made several representation. Lastly, my lord, petitioner filed a writ petition. They are disposed on, my lord, 9 September 2019. Thereafter, 25th September 2019, the respondent 4 started the family pension, but not giving the area pension 2013 to 2019.
From the death to,
My lord.
My lord,
you are for the bank.
for the bank. my
What
lord.
is your stand in the matter?
Yes, my lord. My
Please
lord,
take the microphone, ma'am.
Yes,
Please take the mic. Yes.
as because my lord, bank is the pension disbursing authority. So my lord, we have received this last letter from the AG Bengal, my lord. My lord, I'm placing this before your lordship.
I'll
for
direct
a
the
kind
state,
perusal.
Mr. Prasad.
For a kind
But
perusal and
my lord, only
consideration.
one thing, AG Bengal has been represented by separate set of lawyers.
My lord,
We are not representing the.
my lord, bank need only the sanction order, my lord, to pay the area.
So you have done that. You have to give a sanction, put in a sanction.
Sanction order, my lord. We need only the.
So have you
sanction
done
order.
that?
No, my lord.
Do that
Unless
within a week. Do that within a week. I'll direct you.
My lord, we have communicated them that we only.
Here,
need
I'll
the
direct you
sanction
to communicate to the AG Bengal upon granting a sanction order within not a week, within a fortnight.
order. Yes, my lord.
We do that within a fortnight, and I'll direct the state to act on it after they do it.
My lord.
My lord, only one thing,
I'll direct the state to the principal secretary to ensure that the AG Bengal does it,
only
so that the contempt is on the principal secretary.
my lord, perhaps AG Bengal is not coming under our control, my lord. But finance is not taking care of the AG Bengal. AG Bengal is completely by the central government.
We will do this. I'll not relegate you to another writ petition in view of your financial condition. I'll keep the writ petition pending. I'll give this direction all the same on the bank. I'll direct you to impute the AG Bengal so that the AG Bengal is also a party. Serve on the AG Bengal, come back on the next returnable date with AG Bengal and with their communication on board. Let us see what the AG Bengal does.
My lord, only one thing, my lord, I have been, my lord, intimated that Mr. Shondip Bhattacharya is appearing in this matter for AG Bengal. My lord, he has been hospitalized. Yesterday, he has released.
No, before they communicate and serve a copy, he will come out of the hospital. Let us hope for the best.
My lord, I have.
Learned counsel for the petitioner contends that the petitioner is a widow of the deceased Ramjan Ali Bagani and applied for family pension. Although pension was disbursed from a subsequent date, the arrear pensions from the date of demise of her husband till the date of first disbursement has not been paid to her. Next parallel and counsel for the bank submits that the bank is ready to ensure that all the dues are paid to the petitioner. However, the bank is not the disbursing authority. However, learned counsel for the bank, in her usual fairness, submits that the bank is required to put in a sanction order for disbursal of such additional amount of arrears to the petitioner. Next para. Learned counsel for the state points out that the AG Bengal is not a party to the present writ petition, but is the relevant disbursing authority. Next para, in such view of the matter, to cut short the matter, the petitioner is directed to implead the AG Bengal as a party to the present writ petition, and the learned advocate on record for the petitioner to carry out the necessary consequential amendments to the cause title of the writ petition by tomorrow. The petitioner shall serve a copy of the amended writ petition to the AG impleaded party as expeditiously as possible and file an affidavit of service on the next date of hearing. The State Bank of India shall, within a fortnight from date, pass a necessary sanction order for disbursal of the entire amount of arrear family pension for the period from the demise of the petitioner's husband till the date when the first disbursal was made, and to communicate the same to the AG Bengal for disbursal of the amount. Next para. Short report of compliance in that regard, annexing the necessary sanction order and the communication to the AG Bengal shall be filed by the bank on the next returnable date as well. Next para.
AG Bengal is a party, it's number 6, my lord, account general, my lord.
Now you have discovered. I should have seen also.
6.
Yes.
Respondent number 6, my lord.
আচ্ছা এই অর্ডারটা কমপ্লিট করে নিন দ্য ম্যাটার শ্যাল নেক্সট বি লিস্টেড অন August 22 2023 fairly at the top of the list for final hearing. Full stop, next para. Next para না আপনি একবার আসুন আমি কয়েকটা কারেকশন করে দিচ্ছি আপনি একটু প্রথম থেকে পড়ে দিন আমি বলে দিচ্ছি
শর্টে তো বুঝতে পেনশন
The learned counsel from the state submits থেকে শুরু করুন এই জায়গাটা এটা আচ্ছা তারপর বলুন হ্যাঁ এখান থেকে কাটাটা শুরু হবে learned counsel from the state চলছে বলুন হ্যাঁ সার্ভিস করবে তারপর এফিডেভিট সার্ভিস ফাইল করবে and file a fresh affidavit service এই পর্যন্ত ব্র্যাকেট করুন লার্নেড কাউন্সিল ফর দ্য স্টেট থেকে এটা পুরোটা কেটে দিন আর লাস্টে একটা দিয়ে দিন I've scored through the section entire section regarding your submission they are not a party and fresh service and all everything goes that portion goes I'll add learned counsel for the learned advocate in record for the petitioner shall intimate the respondent number 6 the next date of hearing to ensure the appearance of the said respondent on the next returnable date. Thank you. No need to carry out any correction, etc. Everything remains. Give a notice to the and file a receipt on the next day. Thank you. Next matter.
Item 15.
May I file the affidavit?
Yes, Mr. Kormakar.
May I file the affidavit of service? Lord, I was granted a work order to install, my lord.
All have been served.
Yes,
I'm for the state led by Tanmoy Chakraborty.
Very good. Yes.
Lord, I had been granted a work order, Lord, for installation of a water ATM with, my lord, solar plant.
You are specializing in solar power. Yes, Mr. Kormakar. Anyway, good.
Yes, now, my lord, then the work order was issued on, my lord, 7th of November.
Achha, all have been served. BDO and these.
My lord, Pradhan is a main answering respondent.
And you are appearing for one.
No, I am for the state. I'm not appealing for the
Lord,
Pradhan.
I am told, my lord, all have been served.
Just check up once so that if I pass an order, yes.
Definitely.
In the meantime, check up and you continue arguing.
Yes. Thank you. Now, my lord, I had completed the work on 28th of December. On 4th of January, my lord, the Nirman Shahayok, my lord, comes for holding inspection. Now, my lord, inspection was held. And my lord,
this is under the Panchayat or what?
Lord, Panchayat had Gram Panchayat issued the tender. Now, my lord, the Gram Panchayat is also, my lord, a party that's
Yes,
responsible.
everybody is a party. Yes.
Now, my lord, on 4th of January, they came out for holding inspection. They found that everything is satisfactory, but some more, my lord, works were to be executed for completion of the entire thing, which was not a part of, my lord, the original work order. Now, my lord, they wanted me to do that. I said, yes, I'll do that, but you float a supplemental work order so that it's formal. I'll do it and complete everything. Now, my lord, they did not do. Lord, I completed my work, completed the trial run also.
Additional work also.
Yes, no, not the additional work.
That's very well. Yes.
I completed my part of the
Right,
work
right,
order,
right.
and my lord, completed the trial run also, and wanted, my lord, submitted the bills and wanted the payment of the bills. Lord, the amount is about 6
Mr.
lakh.
Kormakar, all this request to you and your counter request, all these are on in writing or everything orally?
Lord, with respect to this additional work, that was never in writing. But I had recorded that, my lord, in my all the communications that I've made. I'll indicate that. It's a part of the.
You have recorded what?
That the additional work was directed to be done.
But you did not do it.
I did not do it
Very
because no work order was issued.
Now what happened?
Whatever
They're withholding your payment.
Yes, Lord, 6 lakh and 14,000 and odd. This is the payment to be made. That's
Tell me
just a
something,
short
Mr.
time.
Kormakar, that additional work, can that be done now? I mean, in view of the nature of the work,
They
if
give
they,
us the work order, I'll do
you
that.
can do it now.
I'm here to do the work.
Let us hear them. Yes,
My lord, I'm for the appealing for the state, but
you cannot have any say. Yes.
yes, my lord.
Yes, checked up.
And
It
my
has
lord,
not been served.
বললো সব হয়ে গেছে। কেন এইসব বাজে কথা
Not
বলবেন?
affirmed or who has not been served? The main
Not,
respondent.
কে service হয়নি? Lord, the BDO has not been served, Lord, I'm told, Gram Panchayat served.
Who has to pay?
Gram Panchayat has to pay, Gram Panchayat has been
Who
served.
has to pay, Mr. Kormukar?
Lord, Gram Panchayat has to pay. Gram
Let me see
Panchayat
your
has been
prayer.
served. Yes, Lord, I'll
Let us
just
see your prayer.
indicate.
My lord, Pradhan issue the
Pradhan.
notice, page 38.
Lord, kindly straight away comes to the work order. That is at page 20. The work order is being issued by Pradhan Mahanath Gram Panchayat. So, Lord, that is the, they will pay me. They have issued the work order, they will pay me. And Pradhan is 4499.
Please come to page 38 once, as rightly pointed out by.
Fine. 38. Yes.
Mr.
Fine.
Kormukar, why shouldn't an affidavit be directed? Because they may have something, because they say their work has not been completed. There is a dispute regarding whether you have completed the original work. I'll record something in my order that additional, I'll record your submission.
Lord, I'll indicate my, Lord, what I had submitted just now. I had recorded that. Kindly comes, my Lord.
No, that you have recorded, but they are saying that no, that's
With
page
respect
38
to that.
disputes it. He's correct. Your
Lord,
Lordship.
38 is the only portion that is with respect to, my Lord, that the dispute is created purposely. That
Every
is
dispute is created
definitely,
purposely.
definitely. Lord, kindly comes to page 39. This is my reply.
Then I'll direct a short affidavit, Mr.
Yes, my lord.
I cannot decide them. How can I? If that is, there is a dispute on fact whether you have completed the original work, how can I direct them to pay?
Lord, let the Panchayat appear, my Lord, on the next occasion. Let them have a say, my Lord, whatever they have to. If ultimately they have to go for the affidavit, they will. Things can be sorted out. It's a matter of not even 6.5 lakhs.
So Panchayat has not been served.
Yes, Panchayat have not been served. Lord, they have been sent, but it's pending, Lord.
So
Kindly
we'll
keeps
wait
it
for
up.
another week. Let us hope for the best for you if they appear.
Lord, may I file this so that I can.
Affidavit of service filed today be kept on record. Full stop.
Achha,
However,
copy
comma,
achhe.
all the contesting respondents have not been served. Full stop. Accordingly, let the matter stand adjourned till August 17, 2023. 2 weeks have.
I'm grateful.
Thank you for pointing out page 38. Yes.
Great.
Next.
16.
Yes.
This is
Freedom fighter.
This matter, I am for the petitioner. That question of integrity of my certificate has been.
Why do you take it from the same certified every time? This person has been castigated again and again and again.
Pending in the Supreme Court. My learned friend may take that point.
He will take that point, obviously. I am taking that point, Mr. Chakravarti.
On the same, for that reason, my lord passed an order with directing for exchange of affidavit. I am also praying that order for exchange of affidavit.
So you are citing a judgment for affidavit direction. Is Mr. Mondal the architect of this?
Like he was.
Obviously he was.
He was late.
He was, he still is. So I'll direct affidavits, Mr. Chakravarti.
Yeah. Well, he is competent enough to do the case.
His competence, let me assess that. Yes.
Only for why I am wanting this on 22nd
Affidavit, you need not say anything. I'll direct affidavits gladly.
of this month. That question is going to be settled by the Honorable Supreme Court.
Acha, affidavit.
For that reason, let the affidavit be extended. Let it be hard. Decide.
I'll record this and direct affidavits, Mr. Chakravarti. Learned counsel for the petitioner contends that the petitioner claims freedom fighters pension which has not been disbursed by the respondent authorities. Full stop. However, comma, it is pointed out by learned counsel for the petitioner in his usual fairness, comma, that an issue relating to the authenticity of the certifier in question is pending before the Supreme Court and may be resolved soon. Full stop. Next para. Hence, comma, to await the outcome of the said decision of the Supreme Court, the matter is, comma, in any event, comma, to be adjourned for some time. Full stop. However, comma, to cut short the matter, comma, the respondents are directed to file their affidavits in the meantime within 3 weeks from date.
No, in that order, it is 4 weeks.
Very well. Within 4 weeks from date, full stop, reply finish shall be filed within 1 week thereafter. The matter shall be listed for hearing on September 25, 2023.
It is 5th. So if it is appear.
Whether, no, need not. He will just keep several copies of the Supreme Court order, whichever either you will keep or Mr. Chakravarti will keep.
Apart from the certificate of R.N. Giri,
There are other points also. In every matter, there are other issues also I've seen, yes. The same issues are cropping up in every matter, naturally.
The issues which my landed friend is saying, raising, well, that has been decided.
No.
They have not accepted RNG.
No. It has.
Arengiri is one of the components. There are other objections also.
Even the my lord's decision, they have challenged. Supreme Court has decided
Rightly
that
challenged, Mr.
personally have to ask. Yes.
I was in doubt regarding my decision also. Because you have not, the state is not producing any papers, anything. How long will they be paying? Anybody and everybody will be coming. And tomorrow I may grow older and ask for freedom fighter pension. I was a part of the freedom fight.
My memory,
Because I have been fighting for freedom of my country while sitting on chair. Everybody and anybody comes up. No.
that decision
This cannot be.
was upheld by the Supreme Court. In the
Supreme
current
Court
decision-
probably, yes, views change. After a plethora of cases on the same, yes.
That decision has not been upheld by the Supreme Court.
Not only that, Mr.
The Punjab
Chakraborty,
and Haryana High Court passed an order. SLP was preferred. That was dismissed.
and Mr. Chakraborty, quality of mercy can be twice strained, but not more than that.
That is possibly your lordship is referring to.
Yes, I am referring to
Shakespeare.
what you were saying. Yes.
Yes.
At best twice.
It always falls from heaven.
Always.
That is
Channelized.
exactly what Shakespeare said.
Yes. Thank you, sir. Yes. Next one.
17.
17, who is appearing?
I'm for the
Shalal.
petitioner.
I'm for the state.
I'm for the petitioner.
Now you resemble Hercule Poirot.
I'm for the.
You're waxing your mustache.
No, it's a natural, quite natural.
No,
Nothing-
mustache is
not-
natural.
Nothing.
I'll not fool that.
No, nothing. Nothing. No
Yes.
chemical, nothing.
No question of any chemical.
I'm lost in
Wax
the
is not
wax.
chemical exactly. It's
Wax is
it's
exact.
an element problem. Anyway,
Now I tell you, Samal, I have very innocuous prayer before. You lost in
all your prayers in innocuous, Mr. Sanal, they take 2 days to hear.
No. This is not hearing. I tell your losses, I just apprise your losses the facts. Lord, I'm a businessman. I have a fishery and aquaculture. Lord, I have obtained my Lord, supply of electricity from my Lalenson's client in 2021. Now, my Lord, thrice the connection was disconnected on the ground. They are very soft to me, I tell your lordships. On the ground, that there is overdraw. My load is 40 kilowatt. I have drawn over, almost double. Now, my Lord, they have raised a bill of 5 lakhs. My Lord, I paid 2.5. And then, my Lord, they said, go to RGRO. I have certain grievances. And they said also, we will not disconnect until the dispute is resolved. My Lord, RGRO has passed an order against me. My Lord, I have an option to go to Ombudsman. That's another aspect. Now, the second aspect, they have advised me, please apply for correction of the load and overdraw.
Leave something for Mr. Kohli to argue also.
No, that's your lordship. Now, they have, my Lord, paid for. Now, I have applied for, my Lord, enhancement of load also to the station manager that has to be made to the regional manager. That's a technical aspect. Now, line has been disconnected that this is, my Lord, meter has burned. And they have raised, my Lord, initially 5 lakhs. I have paid 2.5. Disconnection notice refers to 3.5. And lastly, they say 4 and odd. Now, whatever, my Lord, I am not sure whether they have accounted for my payment or not. I am just asking them to give me the details of accounts.
So you will prefer a challenge before the ombudsman?
Ombudsman. My Lord, I will pay the entire amount.
You have preferred a challenge before?
No, not yet.
You want
to. My Lord, without prejudice to my right, my Lord, I will pay the entire amount. This is my first, your Lord. That kindly
Try to
put,
come to court.
I'm done. My line is disconnected.
No, it is not
I'm-
disconnected.
Anyhow, my meter is burned.
Yes.
That. Now, my Lord,
You have
let-
burnt your own meter. Yes.
my Lord, I tell you, Lord,
Every time you are doing this, you are overdrawing.
my Lord, that's my Lord,
Rightly none.
my Lord, I-
Poetic justice.
my Lord, I tell you, Lord, my Lord, I will pay, my Lord, kindly restore my, direct them to restore my supply.
An act of God now.
My Lord, I tell you, Lord, kindly direct the restore supply. I am giving an undertaking. I will not overdraw till, this is the allegation, till the enhancement of load is granted. I will apply within 3 days.
After the enhancement is granted, you will overdraw.
No. That's the need, my Lord, they say. These are my 3 pairs.
So why did you come to court at all?
Because your losses
You
are
have gone before them. Right.
I tell you, Lord,
If
my
these
Lord,
are
they say,
submissions of my landed estate, Lord, I have nothing to say.
Yeah, cannot have anything.
they say, my Lord, first get the load enhanced.
No, that
That
is
I'm
the-
saying via media.
Otherwise, this is.
Because I'm a businessman. it
Achha,
will
very
be-
well. I'll record that. They will not. Fair
Otherwise,
enough.
Lord, this will endanger to the installations also.
No, Mr. Sanal is right on that.
Yes.
If they give an undertaking, they'll not overdraw till he's right.
These are
Learned counsel for the petitioner submits that the petitioner's electricity connection for running a pisciculture and aquaculture was disconnected several times for overdrawal of load, full stop. However, comma, on each and every such occasion, comma, the the electricity connection was not severed by the WBACTCL, full stop. This time, comma, apparently for such overdrawal, comma, the meter itself has burnt, full stop. The petitioner approached the grievance redressal officer and being aggrieved by the order passed by the said authority, comma, seeks to move before the ombudsman, full stop. Next para. However, comma, the petitioner prays that the electricity distribution, the WBACTCL restores the electricity connection upon taking necessary measures for supplying a new meter to the petitioner, comma, subject to the undertaking that the petitioner shall not overdraw till the application for overdrawal, which is also pending at the
Enhancement of lot.
till the application for enhancement of load, comma, which is also pending at
That is not pending, that is wrongly they have submitted. The
I have
station
submitted
manager has no
wrong
authority.
which will also be filed by the petitioner, comma, is disposed of. Full stop. Next para, learned counsel for the WBACTCL submits in his usual fairness, comma, that the WBACTCL has no objection to the proposal now made by the petitioner, comma, subject to the petitioner filing an application for enhancement and of load and not overdrawing the load from the meter. Full stop. Next para. Since such fair submissions have come on record, comma, there cannot be any further reason to keep the writ petition pending. Full stop. Next para. Accordingly, WPA 17970 of 2023 is disposed of by directing the petitioner to prefer a challenge against the order of the grievance redressal officer before the ombudsman within a week from date. Full stop. The petitioner shall also
within a 3 weeks, because 60 days time is there.
within 3 weeks from date, within a week now, within 3 weeks from date, full stop. The petitioner shall also file a proper application before the WBACTCL for enhancement of load also within 3 weeks, full stop.
I will file within a week that. It's not matter. That I will file within a week.
Also within 3 weeks, full
How will I
stop.
do that?
Next para. The petitioner shall, comma, further, comma, file an undertaking in court on the next returnable date, that is on August 7, 2023, when the August 9, 2023, when the matter shall be placed at the top of the list, comma, to the effect that the petitioner shall not overdraw the load, comma, till the application for enhancement of load of the petitioner is disposed of by the WBACTCL. Full stop. Next para. That apart, comma, the WBACTCL shall take immediate steps for supplying for affixing a new electricity meter for electricity supply to the petitioner, comma, within a fortnight from date, comma, subject to costs in such regard being paid by the petitioner, comma, in accordance with law, full stop. Immediately thereafter, comma, the WBACTCL shall also restore the electricity supply of the petitioner, full stop. No, comma, you will also pay the entire
Yes, I have said that.
Installment holder, right?
comma,
That's very good.
subject to the petitioner also depositing the entire assessed amount,
Not, this is not assessed amount. This is the billing which during period meter could
the
not record.
entire
Outstanding.
entire outstanding dues in respect of the meter, comma, which will be subject to the outcome of the decision of the ombudsman. Full stop. Next para. The matter shall next be listed on August 9, 2023 at the top of the list only for the purpose of filing the affidavit of undertaking as directed herein above. Full stop. For all or for all practical purposes otherwise, comma, the matter is deemed to stand disposed of.
Only two indulgence I am paying. So far they are claiming the amount my lord, let them furnish a my lord, a breakup of that, how they reaches to the figure.
Oh, yes, of course.
Because my lord, I have
And
not,
what
because I
else?
have paid 2.5.
What else, Mr.
And the other thing is restoration within 3 days. So I will immediately pay because this is a seasonal business, my lord. And the rainy season is the top, my lord.
My lord,
That's-
kindly make it 7 days. We shall try to.
What did I say?
15 days, your losses. Fortnight.
Fortnight টা আপনি 7 days within a
okay.
week from date করুন,
Much.
within a week from date.
Much.
Thank you. একটা লাইন অ্যাড করে দিন, Mr. Kole, if you furnish the breakup
Yes,
in
yes,
the
yes,
meantime,
of
I'll
course,
not
of course.
record
Yes,
anything.
my lord, yes, yes, my lord.
If it is not furnished, then point out to me. I'll put that in
Immediately
my
I shall
order.
convey the officers to.
Thank you so much.
Yes,
Yes.
grateful.
To be mentioned দিয়ে দিও পরে। To be mentioned on the next. আর আমাকে মনে করিয়ে দিও অরিত্র, মনে করিয়ে দিও পরের দিন যে এটা হচ্ছে শুধু আন্ডারটেকিং ফাইল করার জন্য। আমি ডিসপোজ অফ রেকর্ড করবো, আন্ডারটেকিংটা রেকর্ডে নিই। চল।
18. But I am appearing on behalf of the petitioner, but I am praying for adjournment for at least 2 weeks. But
I'll give you more than that. Service not affected.
no, my lord.
Service has not been affected on the respondents. Let the matter stand adjourned till the monthly list of September. Thank you.
Good. Nineteen.
19, yes.
My lord, I appear on behalf of the.
You're for the respondent, Mr. Banerjee.
I'm for the respondent.
Yes,
This one was 6.
Right. Yes. What is the matter?
My lord, according to the provisions of the Bengal Excise Act and the rules framed thereto,
Yes.
my lord, prior to a brand being manufactured, sold, and or marketed within the state of West Bengal, there is a provision under the foreign liquor rules that the said brand has to be registered, the trademark has to be registered, and the label with which it is to be sold, that is to be registered according to the rules. My lord, so far as the petitioner is concerned, petitioner company is concerned, we have been manufacturing, marketing, and selling our product.
The rest of
under
you,
the
please take your seats. Yes, I'll just. If there are seats behind you. I'm sorry. Yes. Please continue, Mr. Shorter. I'm sorry.
Yes.
So trademark. After that,
I'm also led by I'm led by Mr. Joydeep Kaur also in this matter.
let him also take his seat wherever he is.
That my lord, I cannot.
Yes, Mr. Shorter.
He would want to be here, my lord. He would.
No, wherever he is. If he was here, then Mr. Shorter would have. Yes.
Well, regulated service. My lord,
There's a risk
From
of the matter being disposed of before he comes, but I'm telling you.
no,
No, let us hear out. Yes.
My
I'll
lord,
record his name.
from 2007, I'm in this state. I am manufacturing
Right.
and selling and marketing my product, and the brand name is Mansion House. There are various products. It is brandy. The main selling which we sell over here is brandy, and then it is whiskey. It is gin, rum, and everything under the same brand name, Mansion House, and then there is another brand, Savoy Club.
Right.
My lord, the moot question over
Yes.
here before this honorable court is the excise authorities, they have given registration to another company having the same brand name, Mansion House. Whereas irrespective of considering the provision mentioned in Rule 122 of the Foreign Liquor Rules, and more specifically 122C of the Foreign Liquor Rules, wherein it is explicitly provided that in case of considering an application for registration, the authority first has to see whether the proposed mark which wants to be registered before this authority is distinct from the another mark which is already registered in this state, or it is proceeded for registration prior to the application.
This is
which
not
being
trademark
taken.
violation. I mean,
Yes, ma'am. I'm coming to
simpliciter.
that. I'm
Yes.
coming to that. My lord, so far as the dispute is concerned, I've just placed before your honorable court. Now, so far as this mark is concerned, this trademark Mansion House, it was, my lord, in 1967 that originally this mark was registered in Netherlands by UTO Netherlands BV, which is the company. And then it was in 1983 that the plaintiffs, the respondent number 6 herein, they had conferred a license upon the defendant to use the trademark upon certain conditions which were given. Well, in 1987,
The defendant is you.
yes.
Right.
Well, in 1987, the plaintiff ceded the said marks to the defendant, that is the respondent, the predecessor of the respondent number 6. They had ceded the marks to the petitioner herein. And by these documents, there are 3 documents. The mark was transferred and assigned to the petitioner herein. Thereafter, we applied for trademark registration. In 1993, the registration of the trademark as well as the copyright has been done.
Yes.
And pursuant to that, in 2007, I'm over here, and there are, though excise is a state law, it's a state subject, but more or less there are similar provisions in all states. And since after getting my mark registered under the Trademarks Act and the Copyright Act, I have been marketing, manufacturing, and selling this product in various states within India.
What happened in 2007? You entered West Bengal.
Yes, in 2007, I entered West Bengal.
Right.
Well, in 2009, UTO Netherlands, that is the predecessor of the respondent number 6, well, they initiated a proceedings before the Bombay High Court. A notice of motion was taken out. The suit was filed.
Initiated against you.
Yes.
Respondent number 6 was a party there.
No.
Very well.
At that point of time, no.
Did they admit that it was transferred to respondent number 6?
Yes, I'll come to that. They are detailed documents
Anyway,
where those things have been gone into. Now, UTO Netherlands BV, they proceeded in 2009 with this action that there is an infringement of the copyright, and passing off, the suit was filed. In 2010, a notice of motion was taken out for an ad interim injunction restraining me to do business. Well, there is a detailed order.
Ad interim injunction was granted?
No.
Only notice of motion.
Notice of motion was filed, and upon hearing, the said ad interim order was refused. A detailed order is there. I have annexed that order also.
Can you give me the page number, Mr. Sharkar,
Yes,
just
ma'am.
while referring to it?
Well,
You need not place it now.
105. It starts from page 105 and it ends at page 190.
Very. Thank you.
194. 194 it ends.
Very well. Ad interim refused. Then
Refused.
Yes.
Thereafter, my lord, in 2014, UTO Netherlands BV, that is the parent, they, my lord, assigned the rights which they had in the trademark to the present respondent number 6, that is Allied Blenders and Distributors. In 2014.
No, they had done that previously also.
No, they had not done. It is in 2014 that they have assigned.
All right.
So far as the earlier one which I have referred,
Yes.
that was done to me in 1987.
Achha.
That was done to me in 1987. Thereafter,
83.
1983, they conferred a license upon me to use the trademark on certain conditions.
UTO will confront the license.
Yes.
Oh, achha. Very well. Yes.
UTO conferred the license to me in 1983.
So prior to that, it was independent according to independent of respondent number 6. For the first time, they assigned. What was the date? In 2014, they did that. That assignment
Yes,
to
to the present respondent number 6 in 2014.
Suit was still pending.
Yes, it was pending.
Very good. Yes.
My lord, after it was
transferred. Now the respondent number 6 takes out another notice of motion before the Bombay High Court.
They were not implemented in that order 20 rule 10
No,
in the UTO suit.
No.
This
Yes,
was
they
accept-
were impleted.
They must come in under
Yes,
10.
they have come in. And thereafter,
fresh.
Yes, they again preferred another application. By taking out a notice of motion, they pleaded
Right.
for another ad interim order. My lord, this time also, the Bombay High Court, after considering the things, they have passed an order, which I will place, not an ad interim order, whereby I have never been injunct or restrained from doing my business anywhere in India before by any courts, be it Bombay High Court, be it Delhi High Court. They also went up before the Honorable Supreme Court. Till to date, there is no order from any legal forum whatsoever.
No, this suit was pending where?
This is pending in Bombay High Court. This is still pending.
Yes. Now that an injunction was granted now by the Bombay
No,
High
no,
Court on
no.
their motion.
No. If your honor kindly comes to page 266, the order which I am referring to now. It starts from page 266. The relevant order is at page 270. Relevant portion may I take. This is the order of the Bombay High Court referred to in the proceedings taken out in 2014 by the respondent number 6.
They have taken out this proceeding where?
Before the Bombay High Court, they have again filed.
Obviously, yes.
Yes. They have again filed a new notice of motion in the pending
Mr.
suit.
Sarkar, I'll presently come to this, but just tell me what is your present cause of action. We'll go back then.
My
So that it is easier for me to orient.
My lord.
Yes.
Kindly comes for once, kindly comes to the impugned order.
And what happened now? Just tell me that.
Yes. Now, I am aggrieved by this decision of the state excise authorities to register their mark. And the sole ground which they have given is that since they also have a registered mark before the Trademark and the Copyright Act, their mark is also registered. Since it is registered, I will register this mark with the observations made by the Bombay High Court that they cannot use this mark without leave of the Honorable Court, that is Bombay High Court. So the authority says there is no provision under the State Excise Act and the rules framed thereto where I can come to an independent finding. Since
you will have to satisfy me on the the effect of the Bombay High Court orders in conjunction with the law.
With the law.
Very well. Let us see the Bombay High Court order now, 270.
First, may I show the first order of 2010?
Let us start with last order of Justice Patel. Yes. I mean the page 270.
Page 270 is the ordering portion.
Right.
I believe that.
Yes.
May I, if your lordship kindly allows me to take your lordship to page 269.
Very well. Yes. Justice Wazifdar's order was the previous order.
Previous order of
that is referred to here.
Yes, that is referred to.
Right.
If your lordship wants, I can refer to Justice Wazifdar's
We'll go back to that, Mr. Sarkar, because let us start backwards. I mean.
Well. Yeah, the order, well, this order, this starts at page 266. It starts Justice Patel's order, which I am now referring to.
Yes.
Well, at page 269, from the bottom paragraph, I am placing.
Right.
I am not at this stage considering any of the contentions on merits. It seems to me that Dr. Tal so-and-so is correct in saying that the reliefs Tilaknagar seeks are very wide indeed, and for an ad interim order, perhaps it is entitled to them. Possibly it is not. That is to be decided after UTO is given an opportunity of being heard. Even on the footing that Justice Wazifdar's decision concludes the issue of any rights continuing to vest in UTO. There is a specific finding to that effect in the earlier order, and is a factor that will undoubtedly have considerable bearing. I do not see why I should pass an order that would have the effect of disposing of the notice of motion at the ad interim stage. The notice of motion, one that has been pending for 4 years already, that was in 2010, that order, can itself be decided a few days hence, once UTO has had a reasonable, though not extended, opportunity to respond to the present application by filing a further affidavit.
What was your counterclaim here?
Yes.
You sought for a
Yes, I also sought
for cancellation of their assignment and trademark.
Because my mark is registered.
Yes.
So I have claimed that. And
so between you and Mr. Kaur, I have seen the order. So no injunction was basically granted, but it was said that yes, at their own peril they can do whatever.
at their own peril, and then see if my lord has
place it, and then I'll go on to
Yes.
Mr. Kaur if you want. Yes.
the defendants to the counterclaim shall file their affidavit in response to the further affidavit on or before 19 September. This is this.
That is A.
And then I'll come to B. If the defendants to the counterclaim, that is mine, proceed with the obtaining of licenses. This is my counterclaim and they are defendant over there.
So they can make application for license at their
or other point in that time, they will do so at their risk and peril and subject to the result of this notice of motion.
So what prevents the license from being granted at their own peril, and they'll comply with C?
Yes, that is what their contention is.
Yes, obviously.
Yes. Now, if
That's the obvious contention. I mean,
and if your lordship kindly considers 122, your lordship will see that power is vested upon the authority. These are all interim orders which has been granted by different courts, which are going on in different courts, but that does not bind the authority to come to an independent conclusion.
all right.
So rather, it is the applicability of Rule 122C, which is coming up for consideration before this honorable court.
So even if they apply at their own risk or peril or otherwise, the authorities have to consider whether they're entitled.
They are entitled.
That has
This
to-
is
Yes. Okay. Yes, Mr. Court, satisfy me on section 122 now.
I just would run through the facts once for my satisfaction, if your lordship permits.
Yes, yes.
Lord, from 1983, April 1983, Lord, the petitioner has been
Mr.
marketing.
Court, can we then start after the 10 minutes?
Yes, yes, of
I'll
course.
take a break and
Of
come
course.
back. And in the meantime, please have a talk with Mr. Shorka, because mostly I have been apprised of the facts. If it's something is left out, Mr. Kaur, you can definitely point. Thank you.
May I just take, Lord, 5 minutes to run through the facts?
Please do. Yes.
Lord, I have a registered trademark, and Lord, also my label marks are registered. This is, Lord, under the Trademarks Act and Copyrights Act. Now, Lord, I have been in this business, running, Lord, this trade, Lord, since 68, and from 1983, I have been using this brand Mansion House. And Lord, some of the label marks which are, Lord, registered will appear from page 45, 44 to 47. Now, Lord, this protects, Lord, in law, my exclusive user right, common law rights, and Lord, also passing off. My rights, Lord, with vis-a-vis passing off. Now, Lord, with this, Lord, the problem started, Lord, sometimes in 1987. Lord, there is a foreign company which initially, Lord, ceded their rights, Lord, in favor of my client. Ceded in the sense, Lord, they assigned their right. There is a letter by which, Lord, they had assigned on 23rd of February 1987. Now, Lord, subsequently, they applied for registration of the trademark. And Lord, the trademark was also registered in their name. Lord, before the trademark authorities, Lord, the parties, Lord, applied for cancellation of trademark. I applied for their cancellation of trademark. They also applied for our trademark to be cancelled. Now, Lord, this initiated a proceedings, Lord, before the Bombay High Court in 2011. Now, Lord, the contention raised by the foreign company was that, Lord, the ceding was actually a license and not an assignment. This contention that it is ceding is a license was rejected by the Bombay High Court in the interlocutory motion. And Lord, accepting the contention that this is an assignment, Lord, their motion was dismissed. The suit is still pending. Now, Lord, your lordships, I just wanted to show the first Bombay High Court order of 2011, which starts, Lord, at page 105. But Lord, please come to page 191 and 192. I would just concentrate on these two pages for the time being. I want, Lord, before I come to the issue of Rule 122, I just wanted to give your lordships an overview of the whole matter.
Yes.
Kindly, Lord, take paragraph 100.
Yes.
Dr. Tulsapurkar contended that due to the defendant's breach of terms and conditions of the document dated 23rd February 1987, this is the document by which, Lord, the controversy is whether it is a license or assignment. The transfer of the marks to the defendant came to an end, and that thereafter the defendant was only a licensee, and that thereafter the use of the said mark by the defendant was only as a licensee. The submission is erroneous. This approach was adopted, obviously, as a preface of a detailed argument before me on the basis that the marks had been licensed by the plaintiff to the defendant. The mere use of a trademark does not pose as a license by the proprietor to the user. The creation of a license requires an officer by the proprietor to another to use the mark as a licensee, and that other to accept the license. A license does not come into existence by merely the use of trademark. If it were so, acting for infringement and passing off would not exist, for the cause of action in suit for infringement of passing off is the unauthorized use of the trademark by the defendant. Assuming that the marks reverted to the plaintiffs or the defendant's breach of the documents dated 23rd February 1987, it does not follow that the defendants continued to use thereof was as a licensee. In fact, defendant continued using the marks adverse to the plaintiff's right, asserting that it was entitled to do so irrespective of the plaintiff's consent. It is not the plaintiff's case that upon the marks reverting to them, they created a fresh license in the defendant's favor. Considering the view I have taken, it is not necessary to deal with Dr. Tulsapurkar's argument on the assumption that the plaintiff had created a license in favor of the defendant, and the effect of the termination thereof by the plaintiff. A substantial part of the hearing in this notice of motion was based on the presumption that at all times, or in any event, at the material, a license was granted by the plaintiffs to the defendants to use the trademark. Several authorities were cited in this regard. I had the benefit of a detailed and well-stretched argument in the perfect and incidence of license of a trademark and a termination thereof. I refrain from dealing with the same, as considering the view that I have taken, it would be an academic exercise. This leaves for the consideration of infringement of copyright. And Lord, ultimately, paragraph 107. Yes. This leaves for consideration at Exhibit X4 up to the plaintiff, which is the defendant's brandy label. The learned advocate general made a statement that defendant has discontinued the use of HON'BLE Janssen logo. The statement is accepted. Pending the hearing and final disposal of the suit, defendant shall not use the said logo on any of its products. No injunction is warranted as regards the rest of the label. The literature on the two levels is different. There is indeed some similarity in the manner in which the bunches of grapes are depicted. There is, however, nothing unusual about depicting bunches of grapes. Then, Lord, the notice on motion is therefore dismissed. So, Lord, the entire controversy vis-a-vis the interim order was finally decided.
But it was also observed in para 106, there is no similarity between the levels.
No similarity.
It was one of the grounds also.
Correct. There no similarity between the labels. But Lord, these labels are registered in my name. These labels, as of today, is registered also in West Bengal. All over India, it is registered because, Lord, question today is that if the trademark belongs to me, then, Lord, question of registering any label, dehors, Lord, the trademark would not arise. The issue is pending before the Bombay High Court. This is the main issue. Now, Lord, in 2014, post this order, the foreign company, Lord, transferred 50% of their holding in favor of the respondent number 6. Now, Lord, this prompted my client to move the Bombay High Court in the second motion, which order your Lordship has seen in 2014. My learned friend was placing that order of...
You moved that. You moved that motion?
Yes. It was my motion. And Lord, the court, Lord, said, your Lordships may kindly, Lord...
that counterclaim, yes.
Yes.
The
kindly,
defendant
Lord,
did the counterclaim.
In support of my counterclaim, I had moved that motion.
Right.
Your Lordships may kindly have a look at that order that is starts at page 272. But Lord, please take 287. Sorry. I made a mistake. 266 it starts.
Yes.
266 it starts. Referring 270 and 71. Yes. Lord, defendants to the counterclaim is the Lord foreign company and or Lord its transferee whose interest is now devolved in that transferee. And B is the one which says if the defendants to the counterclaim proceed with the obtaining of license or other permission in that time, they will do so at their risk and peril and subject to the result of this notice of motion.
The defendants to the counterclaim are
the foreign company and Lord the
50-50. Yes.
50. Till 30th September, defendants to the counterclaim shall not introduce any product with the subject trademark into the market without leave of the court. This interim order has been continued. I think this matter is fixed next on 5th of September. Now, Lord, bereft of this, in 2019, Lord, the respondent number 6, Lord, filed a suit in the Delhi High Court. Now, Lord, very interesting. Your Lordships will see the order of the Delhi High Court, which starts at page 272.
Page 2, I'm sorry.
272. Please come to page 287. Paragraph 29.
Yes.
The facts of the present case are glaring. The parties to the suit in Bombay and the present
I'll
suit
take half a minute, Mr. Kaur. UTO and you both are parties here.
YouTube
UTO is not
a party. We have not implemented.
At least you are a party. Where will you let us proceed on that?
Respondent number 6 is a party.
Respondent number 6 is the plaintiff.
Is the applicant before the excise commissioner.
No, in this suit,
Oh,
if a
in
Delhi
this
suit,
Suit
in the
is
Delhi
their
suit,
This is their suit.
This is a
They kindly
their
see,
suit is UTO also a pro forma
No,
defendant
no.
or something?
YouTube is there in that suit.
Anyway, we'll check.
I'll just check
Yes,
up.
yes.
and
In
let
the
you
meantime,
watch.
please proceed.
Because my lord, from the cost title of the order, it does not
It will not appear.
Now just check up. Just check up, and it's a query from the court. Please
Very
check
well.
up.
Yes.
Please come to my lord, page 287, paragraph 29. The facts of the present case are glaring. The parties to the suit in Bombay and the present suit are virtually identical, have a commonality of interest. The said suit in Bombay was filed in 2009. Interim injunction application was dismissed in 2011, and clear prima facie finding of fact were recorded in favor of the defendants and against the plaintiffs. It is thereafter that the present suit has been filed on 10th October 2014. The plaintiff seeks interim orders from this court despite being declined relief by the Bombay High Court. Then, Lord, keeping in view the legal position, it is manifest that this court has to give due deference to the enunciation made by another court, especially when the litigants are the same. In my opinion, the above legal proposition squarely applies to the facts of the case. The plaintiffs filed suit based on identical facts. I need not trouble your lordships. Please
So
come.
deference was paid to the hilt.
Absolutely.
Rejected. Yes.
Absolutely.
Right.
Ultimately, my lord, what they could have claimed here with regard to, my lord, provisional registration of labels, etc., nothing was allowed. Lock, stock, and barrel dismissed.
Literally.
Literally.
Barrel also is involved. But I am glad to see that Bombay and Delhi stenographers also commit the same mistake on latches. I'm very glad to see that. Yes. So delay and latches and on merits also rejected. Right.
Correct. So now, my lord, with these three orders in the background,
right,
Lord, let us see, my lord, what happens here before the excise commission.
Right.
Now, my lord, first, my lord, a subsidiary of respondent number 6, my lord, applies to the excise commissioner seeking registration of label. Now, my lord, that was declined. So, my lord, they filed a writ petition. Please come to page 300.
Justice Shamadhar's order. That one.
Yes.
Yes.
Justice Shamadhar held that there are no reasons given. Therefore, my lord, this is a short point on which the writ petition was allowed. Your lordships may kindly come to page 301.
Yes.
A plain reading of the order as reproduced herein above provides a clear answer which is in the negative. The reason is that the concerned authority has not applied its own independent mind, but has merely relied upon an opinion of the legal remembrance. Because, my lord, it recorded that legal remembrancer has opined that since the matter is pending in the high courts in 3 different states, and since there is
good music, Mr. Background music.
sorry. But since there is no clear-cut order in this regard from any of the apex bodies, at present it will not be judicious to consider your request.
Yes.
And Lord, this is what was held, that it is not his opinion. He has relied upon the legal remembrancer opinion. There is no application of mine. Therefore, Lord, the order was set aside, sent back.
Right. This was by a subsidiary of the respondent.
Subsidiary of the respondent. Now, Lord, what happens is, so far as our label is concerned, renewal was rejected. That was the first step. Then, Lord, we got an order from the excise commissioner, page 302. Kindly, my lord, come to 302.
Renewal of your license here.
Renewal of my labels.
Your labels.
My labels, my lord, because excise year is from year to year. It's
Right.
April to March. So, my lord, every year.
So that's a renewal of the license to use the labels, or
the renewal of my lord,
of the labels themselves.
Labels, license, of course, we have to seek.
If it's the registered label, I mean, you need
registered label, but Lord, we have to show that Lord, this has not been deregistered, or Lord, so far as the trademark is concerned, I still hold the trademark.
Right.
This is a process, Lord, that we follow. That was rejected. We came up, Lord, in an appeal. 302, Lord. I just hand over, Lord, legible copy, Lord. I couldn't read this these pages.
302 is always legible. 02 has to be legible. Yes. I can read my copy also. So এটা দেওয়ার দরকার নেই। They're complicated basic document.
Lord, please come to the last page. I don't have to,
Yes, sir.
kindly see the last page.
Right.
Says,
Observation.
Lord, the suit filed 304, your lordships will find. It says, the suit number such and such notified by parent company, etc. The finding of fact recorded by the Honorable Court are as follows. This is recorded. Then the most crucial finding of the court, that's not the last page. Sorry, I'm looking at the wrong page.
Yes, sir.
Lord, please kindly see that last paragraph. Therefore, it is only in the fitness of things. Has your lordship found that? Page 306.
Yes, found it.
Therefore, it is only in the fitness of things that there shall be no adjudication of the dispute at this appellate forum. However, considering the fact that the preliminary findings of the Bombay High Court, which was not disturbed by Delhi High Court, was, sorry, this is repeated in favor of TI, that is Mr. Tilak Nagar, the petitioner, and the latter has been granted registration of MH and SC under the Trademarks Act. MH means?
MH means a mansion house.
Oh, Mansion House, yes.
SC is Savoy Club.
Savoy Club. These are the two brands.
Yes, two brands.
Under the Trademarks Act, which is valid till 2023, a temporary registration of the brand names in question under West Bengal Excise Foreign Record Rules 1998 is allowed in favor of TI up to 31st March 2023 or till disposal of the pending appeal in the High Court, whichever is earlier. With these observations and order, the appeal is disposed of. Now, my lord, this has been renewed. So therefore, my lord, we are having a renewed, my lord, license, the levels, everything. There is no difficulty. Now, my lord, the problem starts. Lord, if your lordships, my lord, kindly take page 300 and sorry. Where is the order? Impugned order?
314 is the impugned order?
40.
Yes.
340. May I just read the order?
Please.
This is not the reasoned order which was communicated to us on the 16th of May 2023. I have heard the appeal petition filed by Tilak Nagar Industries, etc. Hearing was held. Then present appeal petition assails an order of 6 January 23 of to
This was an appeal by you against grant of license?
Appeal by them against the order of Excise Commissioner. Excise
But
Commissioner.
you are Tilak Nagar?
No.
Your appeal.
Sorry.
Your appeal against grant of license to them.
It's so many facts, my lord.
Yes, naturally, sir.
Lord, Excise Commissioner had allowed them to have the label registered.
Right.
Against that, Lord, we had come up in appeal. That's right. Excise Commissioner West Bengal hearing the prayer for grant of registration of labels in the name of Mansion House preferred by the respondent 4 has been allowed till the validity of the trademark registration in their favor, subject, however, to the condition that the product will only be manufactured, imported, and offered for sale in West Bengal after obtaining due leave of the Honorable Bombay High Court, suit number such and such. Based on this order, they have applied before the Bombay High Court. I have heard the parties had gone through the appeal petition and counter affidavit filed against them, etc. You to Netherlands. Ultimately, my lord, please come to the finding. Page 316, paragraph 7. Having gone through the documents on record, I am of the opinion that the main point of contention centers around the ownership of the brand name Mansion House. Now, since the matter of such adjudication is pending before the honorable courts, the same may not be looked into at this forum. However, as far as the Bengal Excise Act 1909 of the rules framed thereunder are concerned, there exists nothing that prevents the respondent number 4 from applying for registration of labels under the extant rules till the validity of their trademark registration. They are, however, precluded from manufacturing, importing, and offering for sale in West Bengal any product without leave of the Honorable Bombay High Court. Since all these points have been adequately addressed by the Excise Commissioner, I find no reason to interfere with the said order. Now, Lord.
But Mr. Court, this stipulation is also there, precluded from manufacturing, importing in tune with the Bombay High Court order.
They obviously they can't. But Lord, kindly consider this. What is the effect of rejection of their suit in the Delhi High Court?
How are you affected then?
I am affected for simple reason. This brand and the label
Because in
This-
trademark, you can only be affected if they use your trademark to do something,
No,
to sell.
that is the material affectation.
All
I
right.
am saying that the right, I'm talking about a right. Because Lord, they must have a right to have their brand registered.
Unless your right is infringed, Mr. Court, you don't have a
No,
cause of
the
action.
question is, Lord, a person who is, Lord, seeking to, they have now filed an application before the Bombay High Court based on this. For
Right.
the purpose of seeking permission
I mean,
to,
Mr. Court, let us be very frank. What can they do with this registration
they
now?
can't do anything. They can't do anything.
That be so, how is your cause of action? How does your cause of action arise in
I'll
that?
tell your lordship, my cause of action is based on
You,
the rules.
you have a legal right.
Yes,
There has to be an infringement to that also.
but I have a legal right also.
Yes.
When, Lord, the authority, statutory authority, exercising power under a statute, Lord, violates the provisions of the law. That is my right. Kindly, Lord, have a look at Rule 122 of the Bengal Excise Act, West Bengal Excise Foreign Liquor Rules 1998. This, I think, Lord, the book that your lordship has, my lord will please come to page 385.
Thank you.
Where chapter 7 starts.
Yes, absolutely. Yes.
Lord, your lordships may kindly come to Rule 122. At page 388, kindly.
Yes, got it.
Says the commissioner may refuse registration if he is not satisfied. Please come to C. In the case of foreign liquor brought into India from Bhutan or any foreign liquor, foreign country, or manufactured in India, that the brand name under which or the label with which it is proposed to be sold is distinguishable from other brand names or labels which have already been registered or whose registration has already been applied for. So, my lord, this is the only criteria under which, my lord, any label registration can be allowed. Now, my lord, kindly have a look at the order impugned. Is there any discussion on Rule 122? In fact, please come to page 311.
It's the other way around, actually, Mr. Court, that it will be allowed. Registration will be allowed
No, it
unless one of these are satisfied.
But if the
That's the
level-
language here.
level is not distinguishable,
May refuse registration if he is not satisfied on these three.
C is clearly, my lord, a positive finding has to be there. That the label that is registered and the label of which the registration is sought are distinguishable. Even it be in the same brand name.
Mr. Kaur, why is it not the other way around? He has to give a reason finding if he refuses registration. And if he say, then he has to say, I'm not satisfied on this. You say the other way around. Let us consider your prospect. Yes.
No, Lord, I am saying that in any event,
he can only refuse registration if he is not satisfied on any of these.
Correct.
So if he refuses registration, he definitely has to say that I am not satisfied on this.
Correct.
If he does not refuse registration,
then Lord, he has to say that this is distinguishable.
Very
Lord, at least Lord, a finding that it is distinguishable has to be.
Consideration has to be reflected.
His mind,
has to
application
be-
of mind has to be there.
Very well.
Lord, he does not refer to Rule 122 at all in the whole order. Your Lordships may kindly, my Lord, see our objection once at page 311. Please come to page 312. 311 is our objection before the authority. Kindly, my Lord, have a look at.
Sir, according these matters, a notice has to be put up.
No,
before-
I think we were served with a notice.
How did you get the opportunity to object?
No, I think they had served us with it.
Copy of appeal was served.
Copy of the appeal was, no, copy of the order was served,
Ah,
against which we had preferred an appeal.
Must be, yes.
Copy of the order was served. Please come to, my lord, page 312. It says, most importantly, in the submissions of Rule 123C, such and such rules, 1988 was placed before your authority. And that as our brand is registered with the brand name Mansion House, is not distinguishable from the brand name of Allied Blenders and Distillers Private Limited, was submitted for your kind consideration. At that point of time, your authority was pleased to also take up the rule 122C as mentioned by your learned counsel. And Lord, this objection, Lord, your lordships will also find from the first page of the letter. Now, Lord, if your lordships, Lord, kindly have a look at the order once. In fact, it's my duty to point out to your lordship. Kindly, Lord, see page 315.
Yes.
Where this objection, Lord, paragraph 4, if your lordship sees, he says, I have heard the parties and gone through the appeal petition and counter affidavit filed on the same. Petitioner has stated in paragraph 2 to 5 petition that something in the air, etc. The facts are stated. And then, Lord, paragraph 5, he notices counter affidavit. Then paragraph 6, respondent number 4 applied for registration under IFL brand Mansion House Deluxe brand Bandy in response to the tender notification dated such and such. However, the said application was objected to by the corporation on the ground of brand dispute prevailing between the petitioner company and the respondent number 4. The respondent number 4 herein preferred an appeal, etc., etc. My objection is not even noted. And Lord, rule 122 is not even referred to in Lord rejecting the appeal. He only sees that, Lord, the order of Bombay High Court has been complied with. That's the sum and substance.
Yes.
But Lord, the subsequent fact that the rejection of their suit in the Delhi High Court is also not noticed. And my objection based on rule 122 is also not considered. So, Lord, I say, Lord, this registration can't stand, and this has to go. He can consider it afresh on the parameters, Lord, of the statute. That's another question. But Lord, this can't.
Going back to how you are affected, Mr. Court, if they don't sell,
Lord,
investment.
Kindly consider two aspects of the matter.
Yes.
Lord, this issue with regard to the registration of the trademark was taken up by the Bombay High Court.
Yes.
This is registration of a label, Lord, flows from that. Basically, Lord, it's an exercise of right under that. Lord, when the Bombay High Court observed in the second order in 2014, that, Lord, if they do it at their own peril, Lord, it's obviously, Lord, it can't be a mandate overlooking the prevalent law insofar as the state is concerned. This is an excise law which has to be followed, Lord, for the purpose of granting registration of a label.
But they are doing it at their own peril, in fact.
Lord,
Aren't they?
question-
Why are they not?
Question is that whether rule 122 permits them to do it at their peril. Lord, if they have submitted a label which is, Lord, akin to the label that I use.
So at least a consideration on 122C had to be there.
Had to be there. Had to be there. And Lord, after all, it is a statutory power which is being exercised.
Suppose that was exercised. Whether we also have to see whether this objection of yours is academic in this circumstances. Suppose that objection that was considered. Now the labels are identical. Then also the rest of it applies.
Lord,
let us proceed on the premise it's identical.
Right.
Then also the other ratio given therein applies. Bombay High Court, Delhi High Court, these things are, Delhi High Court has not been taken into consideration. Bombay High Court took into consideration all aspects and passed that order.
Lord, Bombay High Court's consideration was that, Lord, it is the first principle was that
So you see, irrespective of Bombay High Court and all, they have to look into 122
Correct.
also, which they have not done.
Which they have not
Which is their business under 122.
Absolutely.
Under 122 for license.
Bombay High Court, Lord, does not govern the excise authorities here.
Correct.
In fact, Lord,
No.
this exercise
Yes.
was done, Lord, by them in by obtaining, Lord, same, Lord, approval with the excise department of Uttarakhand and the excise department of Himachal Pradesh. Both have been cancelled. Both have been cancelled.
So as of today, what is the situation? They have a registration of the brand name. You also have a registration.
Lord, the trademark registration is subject matter, registration of trademark and brand name is the subject matter of the suit.
But both of you have those, which are subject matter.
Both are there, but cancellation in respect of both are there. Bombay High Court has rejected.
But then as of today, Mr. Kaur, they have a trademark. So they are entitled to have a license otherwise. Subject to Bombay High Court riders. So they are precisely, they have been
I tell your lordship, there is a underlying
that is sub judice, definitely.
underlying situation there. Because my lord, Bombay High Court prima facie held that there was an assignment of the trademark in my favor.
Right.
And their contention that it was a mere license has been rejected on the prima facie view. This is a subject matter of the suit.
Yes.
And at the first motion, the Bombay High Court did not give them any right whatsoever.
Mr. Kaur, you have to take in your mind, the license authority, the excise authorities also cannot say that they won't be selling liquor on the basis of the license. That also is a peculiarity in the order. The license authority, the excise authorities cannot also say that you will be having a license, but you cannot sell. That is in terms of Bombay High Court. Now, similarly here, they have a valid registration. Just see the scenario. You also have a brand name. They also have a registration of a brand name. Both of you. That is sub judice. You have a favorable ad interim order before the Bombay High Court as well as the Delhi High Court. Let us proceed on that premise. But now, as of today, your license is also renewed. Their license is also renewed. You are permitted to sell liquor in West Bengal, but they are not.
There is an identity so far as the level is concerned. Lord, that
proceeding on the premise that those are identical and she has been considered.
Lord, question is, Lord, whether
how could it make a difference?
Difference is based on Rule 122. Lord,
yes.
there are two differences.
Even if 122 goes in your favor, I mean against them,
Yes.
that yes, it is identical.
Yes.
But that there is a cloud on the trademarks of both of you. A suit is pending. Although there are favorable findings in your favor in an identity stage, but that does not win the suit for you.
Lord, my most humble submission would be
yes,
that Lord, one should survive, not both. On principle
at this stage,
but
this both have brand name registrations.
Correct, but not in spite of that, Bombay High Court has not permitted them to trade. They have not
Neither has the excise license in Dehorse's jurisdiction.
No right to trade as of now.
I mean, they could have challenged this, saying that you cannot pass this order, excise authority. You are not bound by the High Court, the Bombay High Court order. They have not challenged.
That's another question whether they could have or not, because I think they can't ask to challenge it
because they had a last moment conference with Mr. Banerjee.
Possibly. The issue therefore is that there are two issues. First is not right. The right has not culminated at all. The Bombay High Court has not permitted them to carry on the trade or commerce on the basis of the
right is only on the registration of the brand name, not anything else. For the excise authority, and 122 has to be considered.
Correct.
122, let us suppose that is considered, it's identical. Now what happens?
He can't.
But they have a registered brand name in
He
there.
can't.
Then you also can't.
He can't.
On the same ground, you also can't.
On the same ground, I can. Because, Lord, I have been a user of this brand in India from 1983. That is the ground on which, Lord, my rights have been sustained.
That is relevant for the trademark case.
It is
Your prior user is relevant for the trademark litigation.
This is a case of, Lord, registration of brand name is in aid of the trademark. I am carrying on business. My right to carry on business has been permitted by the Bombay High Court. Lord, today, under 122, if there is a similarity in so far as the labels are concerned, he cannot allow. It doesn't permit, the act does not permit him to allow. Unless he comes to a finding that
you are taking a risk, Mr. Kaur. If it is remanded today, then the exercise has to be, he has a similarity with your trademark, then both trademarks have to be scrutinized.
But they have no authority to scrutinize the trademark, luckily for me. Because
Why not? Why they should do it? Because there is an identity. Now, if there is an identity presupposes there are two trademarks at least.
No, not trademark. Lord, this is
brand
label.
names. I'm sorry.
Label. We are at the level of a label.
Yes, it presupposes there are two labels, Mr. Kaur. So if there is an identity, it has to scrutinize which one should be permitted to function, operate. So that exercise has to be undergone there.
But he has already permitted the function of a label under which the brands are sold in
That
West
comes
Bengal.
under the scanner, if I remember it.
That cannot, with the greatest of respect, Lord, that cannot,
Hmm.
because my right to carry on trade has not been curtailed by the Bombay High Court. It cannot be
Again,
curtailed.
you are drawing support from Bombay High Court. Either you distinguish Bombay High Court, the High Courts have nothing to do with it because this is an independent
No,
exercise.
I say the,
Or you say yes.
no, when
There-
it, when
there
it
is a-
touches my right, then Lord, I have to look at Bombay High Court. Because Lord, if it, your lordships,
And when it curtails your right, you look away.
no, I don't. I say that if they are exercising their right, it is the respondent number 6 who are exercising their right under the Bengal Excise Act. They are not falling back upon the,
No, but can you compartmentalize in this case the subsistence of the suit, the orders of the Bombay and Delhi High Courts, and the exercise by the excise
yes,
authorities?
yes, because my Lord, each
To
state,
compartmentalize, then this is a straitjacket separate exercise.
I'll compartmentalize. I'll say each state has an excise law.
True. Yes.
Each state has to, Lord, exercise their jurisdiction and authority
Hmm.
in terms of their state law. They cannot not exercise power as a civil court looking
Cannot,
at anything
definitely
else.
cannot. No.
They have to go by, strictly go by the statute. Now, Lord, when a statutory authority exercises his power, allowing certain things, he has to, Lord, strictly comply with the provisions of the statute.
No doubt. So
And-
you say we have to keep our eyes limited to this exercise. If you do that, as of today, they have approached the authorities for their license to operate this brand name, the label, and the authorities have to see if whether 122 ABC is complied with, C is not complied with. So just get refused, irrespective of whatever order has been passed by whichever court.
Correct.
So that is your contention.
Absolutely.
And
In-
you have already got that license. That has nothing to do with this
No,
exercise.
it's also says, kindly see, 122C,
Yes.
from other brand names or labels which have already been registered and whose registration has already been applied for. So, Lord, if there is an existing registration, kindly see 122 towards the end.
Yes.
It says, Bhutan, etc., under which or the label with which it is proposed to be sold is distinguishable from other brand names or labels which have already been registered or whose registration has already been applied for. So, Lord, he has to distinguish between the registered labels and, Lord, the labels for which the registration is applied for.
And your registration is prior to this.
Prior, much prior. And I'm carrying on business for 20 years, last 20
That is there. Yes.
20 years. There is no dispute with regard to that. Here also, my Lord, the issue of prior user is one of the aspects that, Lord, the authority has to look into.
Right. So that already also comes into play. Already registered.
Yes.
Very. So I'll hear Mr. Banerjee now.
Lord, there is a division
Judgment?
bench
Yes, please say.
judgment of our High Court,
Yes.
which has considered this aspect, if your lordship's kind enough. Judge Sahib ke copy? Other side ke dini?
So that is more important, Mr. Court.
আমি আমারটা দিই। Lord, please take the second paragraph at internal page, first page, my Lord, of the judgment.
Yes.
The Excise Commissioner, on an application being made, refused to grant registration under Rule 122(3) of the West Bengal Excise Foreign Liquor Rules 1998, hereinafter referred to as the said rules. The Excise Commissioner, on fact finding, found that there is a similarity and confusion likely to arise. Therefore, he was satisfied with the precondition for granting registration under 122 are not fulfilled and satisfied. Then on appeal, government had upset the said order. Of course, the appellate authority came to the finding that there is no similarity, however, did not give detailed finding where the conditions contained in Rule 122 of the said rules are satisfied, fulfilled or not. Then, Lord, please come to the second page, last paragraph, according to us. Has your lordship got?
Yes, yes.
Registration under the said rules is required to be granted upon satisfaction and fulfillment of the conditions mentioned in Rule 122 of the said rules. In the said rule, there is no adoption of the finding of the registry of trademark. We fail to understand why the learned tribunal did not consider these matters, etc.
satisfaction and fulfillment of 120.
These are my submissions.
Thank you. Yes, Mr. Banerjee, you have anything to add?
To subtract really, my lord.
Yes.
My lord, very important, my lord, what fell from my lord, my lord, two things, my lord, very important. First, my lord, my trademark is registered. His trademark is also registered. My lord, under the Trademarks Act, my lord knows label is also mark. So there is no distinction, my lord, between that's my lord section 2M. I think my lord mark is.
Yes, please cite that also. I mean, the
Yes,
language,
yes,
exact
my lord, I'll
language.
just, my lord. 2M.
ট্রেডমার্কস একটা একবার আনিয়ে নেবো তো আছে ওখানে আমার তো দেখে নি একবার কোটা আনিয়ে নে থাকার কথা এখানে yes yes
2M, my lord, is, and which is, my lord, I
yes,
don't think, my lord, there's any.
right,
And then, my lord, section 29 also, my lord, will kindly see. Sorry, 28.
এটা ফেরত দিয়ে দাও
28(1). Which again, my lord,
same
remembers, yes, my lord, it says that we have both exclusive rights. Now, my lord, the accepted position has to be, my lord, that the excise commissioner is not to, my lord, really, and there are also, my lord, judgments. I don't think, my lord, I need to, he doesn't have the power, my lord, to decide whether, my lord, one registration is better, one registration is not better, or someone has prior registration, someone has no registration. So, my lord, he has no power.
your hurdle is already registered that expression
Yes. No, I'll just tell.
very well let us go.
Yes, yes. My lord, already registered also, my lord, won't matter because, my lord, every year the label has to register to see, my lord, whether. So, my lord, that is no. So, again, my lord, he would also have to again
as
see.
on that date at least both were registered. I mean,
No, my lord, kindly see, my lord, what is the position of, my lord, the proceedings which are pending. In the Bombay High Court, I'm, my lord, now 100% owner of the mark according to me. He says, my lord, I say he has a license. He says, no, it has been ceded to me. Now, my lord, at the interrogatory stage, ad interim stage or interim stage, in 2011, in the suit, when, my lord, now I say we, my lord, because my predecessor interest had applied for an order of injunction restraining him from carrying on business with the mark, we were not successful. And an appeal is pending from that. From the 2011 order, my lord, an appeal is pending. In 2014, my lord, we got assignment. That's why, my lord, we now are, my lord, 100. B, my lord, means, my lord, the respondent was 6 here. Then he applied for an order of injunction. That's, my lord, the 2014 order. He applied for an order of injunction. He also failed in the sense of he did not get an order of injunction. The court said, and that 2014 order, my lord, that's why it becomes very important. This is on his application, my lord, to stop me from using the mark. So what, my lord, principle applies to him, as they say, my lord, what is sauce, my lord, for the goose is also sauce for the gander. If, my lord, kindly comes to, my lord, 10th September 2014 at page 266.
yes
Let's see, this is an application for urgent ad interim reliefs. The application is moved by original defendants to the suit. So he moved in 2014. The defendant has filed counterclaim number 6 of 2010. Present notice of motion is filed in the counterclaim. For ease of reference, I will refer to the parties by the names Tilak Nagar Industries Limited in the counterclaimant. The original defendant numbers 1 and 2. Well, these are the original U2, well, the Dutch company, have now been joined by 2 additional defendants. Well, we. They are collectively referred to as U2. Then suit number 632 of 2009 was filed by U2O seeking protective rights in respect of its trademark and also seeking reliefs restraining copyright infringement for the artistic work relating to the depiction of marks. Marks is question included mention on and Savoy Club. This is our application which we made. By an order of injunction dated, by an order and judgment dated 22nd November 2011, report in U2O and such, Mr. Judge dismissed U2O's motion for interim relief. Findings the judgment including intelligent that U2O had ceded or assigned and transferred its trademark to Tilak Nagar. Detailed in elaborate judgment, Justice Vasudha considers all the arguments. I am informed that this judgment was challenged in appeal and the appeal was admitted
Admission again, my lord, means, my lord, that everything, my lord, really is at large, but we are not on that. And that is yet pending final disposal. In the meantime, Tilak Nagar filed the present counterclaim. In that counterclaim, also filed present notice of motion which seeks to restrain U2O from passing of its products. Under Tilak Nagar's mark, Mansion House and Savai Clause, this matter has been pending since no application appears to be made for identity. So, my lord, what I fail, he also fails. It is not that, my lord, he's right, my lord, because I fail doesn't, my lord, mean, my lord, that his right is established.
So basically, if you are passing off, you may pass off, but at your peril.
Yes.
I mean, what happens at the end?
No, and what the Bombay High Court then does, my lord, has seen that.
Yes.
Not passing off, my lord, this is kindly see, my lord, then notes, my lord, at 268, my lord, it is noted, my lord, my rights. And, my lord, we made an argument that, my lord, if my lord looks at the argument of the apprehension that we will, my lord, now, my lord, use the mark, and then paragraph 7 comes.
Yes, 7.
I'm not at this stage considering any of the contentions or merits. It seems to me Dr. Tuldapur is correct in saying reliefs are very wide indeed for an Sorry, my lord.
It's continuing to vest in you.
Yes. Decided by UTOs given an opportunity being heard, even on the footing that Mr. Jazzy was with, concludes the issue of any right. Yes, continue vesting in UTO, and the factor that will undoubtedly have considerable hearing. I do not see why I should pass an order that would have the effect of disposing of the notice of motion at the ad interim stage. Notice of motion, one that has been pending for 4 years already, can itself be decided a few days hence. Once UTO has had a reasonable, though not extended opportunity to respond to the present application by filing a further affidavit. Then, my lord, now kindly see, my lord, what is given. The defendants to the account file affidavit, then B. If the defendants to the counterclaim, me, proceed with the obtaining of licenses or other permissions in that time, they will do so at their risk and peril and subject to the result of this notice of motion. They have also, my lord, accepted this order. It gives me a positive right at my risk and cost to do what I want to do. But because, my lord, it is not that, my lord, today what has happened, my lord, it is only a registration of the label by the excise commissioner. In fact, my lord, what fell from my lord, I would not have, my lord, dared to say that also, my lord, in that sense. My lord, the excise commissioner has been very careful. He has, my lord, given, my lord, importance and credence to the Bombay High Court order, saying that, look, I am giving here, that doesn't mean you can go ahead. Actually, my lord, we could have gone ahead and we would have been in contempt of the Bombay High Court order. Because then C says, till 30th September 2014, all of this has been extended. The defendants to the counterclaim shall not introduce any products with the subject into the market without leave of the court. Now, my lord, what happened, my lord, this order was passed, my lord, on the 16th of May. My lord, the impugned order which my lord has is, sorry, my lord, 10th of May. Passed on the 10th of May. Which, my lord, what is impugned, my lord, the appellate, the secretary here, my lord, in the appellate, 10th of May. My lord, we filed our application, my lord, before the Bombay High Court on, my lord, seeking leave in terms of that order. In terms of the Bombay High Court order, my lord, we have filed seeking leave on the 23rd of June. Now, my lord, that matter, my lord, has been heard on 1st August and now, my lord, fixed for hearing on the 5th of September at 2:30 p.m. And, my lord, they filed the writ petition, my lord, on 19th of July.
So this is to preempt that. All right.
My lord, that is, my lord, the intention. Now, my lord, very interesting. My lord, this 122C, my lord, let me also, my lord, analyze it. First, my lord, submission. I'll show that, my lord, immediately. 122C, they never thought this was an objection. They were never raised that objection also. But if, my lord, I'll show, my lord, kindly, my lord, look at, my lord, page 309, my lord, is the order of, my lord, the first, the excise commissioner.
In their appeal, they have taken this objection. 11th
Yes,
January.
in the appeal, my lord, they have. Initially, my lord, they had not, because they also know, because, my lord, we are both registered. And in the same logic, my lord, their registration has been permitted. Their level stands, my lord, registered today. Now, if the excise commissioner cannot decide on the validity of the registration then my lord, he also cannot then my lord say with the greatest of respect that I will consider him to be registered and not registered me. Because I'm on the exactly same footing. We both have registered marks. We both are fighting, my lord, in Bombay High Court, my lord, with regard to, my lord, having, my lord, trying to establish our right. We both have failed to obtain, my lord, injunction orders against each other.
You have a better base in Delhi, probably.
No, my lord, Delhi also, my lord, we tried, my lord,
You have a
after.
better base in Bombay, apparently. Yes.
My lord, no, Delhi also, my lord, we failed because, my lord, what we went to Delhi, my lord, we said they're infringing. But naturally, they couldn't have, but Delhi said, if it is pending before Bombay, you can't come to Delhi and ask for an order of injunction. We were, my lord, thrown out there. Quite naturally. Now, my lord, now what has happened? The Bombay High Court, my lord, order which I showed in 20 has specifically said the mandate is you go ahead at your risk and peril. But thereafter, if you want to launch, you will have to come and take our leave.
Independent of all these, Mr. Banerjee, what is your answer to the authority being duty bound to consider and reflect on Rule 122 ABC?
My lord,
I mean, that is also there.
First thing, my lord, in fact, my lord, if
And they have taken a specific objection in the appeal at least.
yes, my lord, will kindly, my lord, may I just first show, my lord, the 6th January order, then I'll come to the appellate, because that's the Excise Commission order, my lord, which is really, my lord, affirmed there. My lord, at least, my lord, before 6th January, my lord, this is what I find. I'm sorry, my lord, this is at page, I have a tight copy, my lord, because ours was completely, my lord,
No, my copy is all right.
illegible. 309, my lord, is the in fact, my lord, if my lord looks at 302, where my lord, their registration, my lord, of the labels were allowed. Because we also objected. That is, my lord, the first order, my lord, 14 December 2022.
Yes.
There we had objected saying you don't register the label.
The date is not there at page 302. That's 14 December.
At the top, my lord, 14 December 2022, first slide.
Yes, yes.
And there, my lord, their concern was that, my lord, kindly, my lord, may I just show that order at page 303. This is, my lord, their submission. Contention of, my lord, Tilak Nagar. And kindly see, my lord, submission 4 at the top, last line. All they say, my lord, Bombay High Court, then they say there is no restraining order on TI.
In TI, this
TI is Tilak Nagar, my lord.
No, Tilak Nagar. In the TI matter at page 306, TI was given. They were given the license.
Yes.
There also you had appeared and
yes. So, my lord, they were given. Now, my lord, when it comes to me, then, my lord, kindly now see, my lord, 309, 309, and my lord sees my lord at 310. My lord, I'm sorry, my lord, 309, my lord, will find, my lord, all the, my lord, contention, the first page is recorded, our contention, and then kindly see 4, my lord.
Yes.
Last, my lord, on that, I don't know whether my lord can read that, my lord, my lord can read that.
Copies of, yes.
My lord, 4, that Messrs. ABDL submits that there's no legal impediment to their company to apply and seek excise label approval for the Mansion House brand before excise authorities, and their company in any event will be launching the product in market only after taking leave of the Honorable Court as per order date 10 September 2014 passed by the Honorable Bombay High Court.
That has been accepted basically.
Yes. And then, my lord, kindly see, my lord, next page. The learned advocate appearing on behalf of Tilak Nagar Industries Limited submits that they have gone through the submission of Mr. ABDL and have nothing to object except for the statement made at point 3 of their submission claiming exclusive license to use the brand that is mentioned out. Objection is noted.
That is the only objection.
Now, my lord, I'm told, my lord, they've also given a further objection, my lord, with this, my lord, at page 311, my lord, there. So, my lord, at
that
this
is subsequent, post facto. That is in the appeal.
Appeal. I will also deal with my lord 122C. Oh, my lord, I'm told, my lord,
This is January 11, 2020.
yes.
After the order was served, we responded by protesting that these arguments have not been taken into consideration by the excise commissioner. That is that protest.
6 January, the order was passed.
And then 11, my lord, they have.
11,
After 11 January 2023, after the order was served, we immediately, my lord, recorded that these arguments that we made in course of submissions have not been recorded. Your lordship takes the
Correct.
first paragraph, your lordship will understand. Then we preferred the appeal.
My lord, let us assume, my lord, they took that point. My lord, let us, my lord, assume, my lord, I don't find, my lord, in the 6th January, my lord, and I don't think that was a point because even in the 14th December, my lord, this was never a
Order
point.
been passed on this, 11 January?
No, none. Then we preferred the appeal.
My lord, now, my lord,
Preferred appeal against this.
Against the
You
order,
preferred that appeal, actually. Very good.
against the order of
no,
the excise.
now, my lord, the order which is. Now, my lord, I just want to, my lord, can you look at the observation now? As already observed in an order dated 14 December 2022, I'm sorry, my lord, this is page.
Yes, yes, I'm
Three.
reading there.
As already observed in an order dated 14 December 2022, parties involved in this appeal are relying substantially on same set of facts. Documents which were before the High Court at Bombay and Delhi, departmental appeal being a quasi-judicial proceedings, adjudication of a sub judice matter by the Excise Commissioner will not be proper, as it may disturb the findings arrived at by Honorable High Court and will only add to the multiplicity of proceedings already set into motion by rival parties. However, in consideration, this is very important, of the fact that Messrs. ABDL is holding the trademark right for Mansion House till 4th April 2023. This has also been extended. I find no reason for restraining ABDL from applying for registration of labels till the validity of the trademark registration. However, the product will only be manufactured, imported and offered for sale in West Bengal only after obtaining due leave of the Honorable Bombay High Court in suit number 62, counterclaim number 6 of 2020. With this option, or appeal is disposed of. So, my lord, suit and counterclaim. Because there, my lord, I am asking quite naturally, my lord, if I succeed, then, my lord, their right, my lord, to manufacture or, my lord, sell goes. If they succeed, similarly, my lord, my right goes.
Yes, obvious. Yes.
So today, my lord, in that situation, my lord, my submission is, my lord, Excise Commissioner, my lord, has done no wrong by really, my lord, not venturing into the controversy and looking at both the trademarks registration. Because if, my lord, 122C, my lord, it talks about, my lord, that, I'm sorry, my lord, before I come to that, and, my lord, the impugned order at, my lord, page 314. I'm sorry, I'll just, my lord, come to that also. My lord, paragraph 4 is, my lord, recording, my lord, all those facts. Then kindly see paragraph 5. In the counter affidavit filed by respondent 4, which is me, it has been claimed that they are the registered trademark holder of the mark Mansion House and have the exclusive privilege to use the brand in India. In respect of the litigation referred to by the petitioner, counter affidavit, something like the same. Then respondent 4 applied for registration of IMFL brand Mansion House Deluxe Brandy in response to the tender notification number such of West Bengal State Beverage Corporation Limited. However, the said application was objected by the corporation on the grounds of brand disputes prevailing between the petitioner company and respondent 4. Respondent 4 herein preferred an appeal before the Excise Commission of West Bengal against such order of the corporation. Such appeal was disposed in terms noted in para 3 above. Then, having gone through the documents on record, I am of the opinion main point of contention centers on ownership of the brand name Mansion House. Now, since the matter of such adjudication is pending before the honorable courts, same may not be looked into at this forum. However, as far as the Bengal Excise Act 19 rules framed thereunder under concern, there exists nothing that prevents respondent number 4 from applying for registration of labels under the exact extant excise rule till the validity of the trademark registration. They are, however, precluded from manufacturing, importing, or offering for sale in West Bengal any products without the leave of the Bombay High Court. Since all these points have been adequately addressed by this order, then I find no merit in selling.
Mr. Banerjee, this is, although this is not directly German, what is your stand in the suit? I mean, how do you?
I'll tell my lord.
Yes.
My lord, we say, my lord, the original, my lord, UTO has, my lord, now, my lord, assigned, my lord, given, my lord, everything to me.
What about the prior?
Yes, my lord, that was a license which was given. So we say, my lord, we have a superior right. At the addendum stage, my lord, we were not quite naturally, my lord, we could not obtain an order of injunction because they say on the two grounds, my lord, of acquiescence and that, my lord, they have ceded, but that's, my lord, in appeal. So my case is, my lord, I have a superior right. And that is, my lord, what we are really, my lord, contesting, my lord, before, my lord, the Bombay High Court. So, my lord, my submission is, my lord, and if, my lord, now looks at, my lord, the excise 122, the commissioner may refuse registration if he is not satisfied. First of all, it's some kind of, I would submit some kind of discretion left to the excise commissioner as well. As to whether the label should be registered or not. Because label registration would have meant, because what had happened, I had applied to BEVCO. BEVCO said, sorry, I'm not accepting it.
You are seeking the license for the label.
Yes.
Obviously.
Here, only the label will be registered. Right. Which means only when freed from.
But label is a subset in your case of the main.
Yes, yes. It's the mark. It's the label means.
Label is basically.
Yes, yes. Because we are both, the labels are registered. The word mark is registered.
Everything goes.
Everything
goes in.
Yes. Then see, in the case of foreign liquor brand brought into India from Bhutan or any foreign country or manufactured in India, that the brand name under which or the label with which it is proposed to be sold is distinguishable from other brand names or labels which have been. Now, this distinguishable, if you see two trademarks, it means both have exclusive rights. Then there's no question, unless there's again a finding. Today, if there was an injunction restraining me, I understand. And very interestingly, my learned friend has not disclosed. They had also filed this not on record here, but this they had filed a suit in Hyderabad also. They also filed, saying that these two labels and trademarks are completely separate, different.
That was because Mr. Banerjee, north, east, and west have been covered. So Hyderabad is south. So that was the only direction.
Then when they understood what they have,
between yourselves, you have covered the entire India.
I find this.
It's a pan-India thing.
Lock, stock, and barrel.
Actually, in all parts of India, we are litigating and all that.
I wasn't involved, but what I'm saying, there,
if it was not distinguishable, that is, I mean, that is not the sole consideration. That cannot be.
That and they say, in that suit, their stand wish to withdraw. Their suit was because they wanted a right. They filed a suit saying that it is totally distinguishable. Because all along, they have been quite naturally, when we filed an order of injunction, we didn't get. So all along, they have been apprehensive that they will be stopped.
Definitely, yes.
I've seen, it is not the case, as if they did nothing because we were trying to stop them.
It's a preemption game now. Yes.
It is now fixed on 5th September. And the excise commissioner is really
that I don't know. That may be relegated with for hearing. With
yes, yes. But label, the label only has been registered. It's not that I can also I'm also taking Q I was thinking whether that because cause of action also has to arise as of today with regard to what you're going to stop, because I still don't have the right.
Yes, you don't have that.
I still don't have the right to manufacture. The excise commissioner has also imposed that condition.
You are for the state.
Yes, my lord.
What do you say?
Those and just one this one the judgment the division bench. I'm sorry, just take.
I'll hear the state and the reply officer call after this.
Here just in fact, I find that this division bench, there's kindly similar page 2. Second paragraph, it appears from the records that the parties are fighting. I'm sorry, Malad.
Yes, yes. Second page.
Second page, Malad.
Yes, fighting.
It appears from the records that the parties are fighting not only before the civil court, but before the trademark registry, before whom an application for cancellation registration of respondent has been made. In the civil court, petitioner before us was unsuccessful, right division to obtain an interim leave. Their primary phase final observation division in civil courts. Civil suit. Then
no, they're on the last paragraph probably.
So, next paragraph, not important. Very good. From the impugned judgment and order of the learned tribe, we do not find that the aforesaid judgment of the civil court was examined, or that the learned tribe made any effort to see the implication of the said matter. No doubt interlocutory of the court cannot be having, and this is exactly what the Excise Commission has done here. He has looked at the Bombay High Court order, my lord, and then said that both trademark registered, that's why I'm registering your level, but sorry, you cannot manufacture. So I do not know, my lord, with the greatest respect, my lord, to my
That was
learned.
one of the components because penultimate paragraph court says we fail to understand why the learned tribunal did not consider these matters.
Yes.
One of the matters is civil.
Yes.
The other is this 122. So that component also remains.
But here, my lord, no question of, my lord, both trademarks being registered.
Yes, yes.
Because that shows, my lord, prima facie, or my lord, in the sense, my lord, under the Trademarks Act, my lord, exclusive, or my lord, not prima facie, but my lord, evidence that, my lord, I can also use it.
Yes.
Because it would have been then, my lord, discrimination to say that just because you have it, you will use it, but I can't use it.
You can't use it still.
But
That
sorry,
is
my lord,
because of the
registered.
civil court.
Yes, yes.
You can have it, but I can't have it.
Yes,
That's
my lord, that's my lord, the correct.
you can have the cake, Mr. Manage, but can't eat it. So we'll come back after recess, Mr. Court. Yes.
Writing or rather completely circumstantial. Next matter will kindly password the matter for the day. My appointment is eye checkup at 1:30 p.m.
Eye checkup, definitely. Not
that,
today, Guru.
password the matter for the day.
Let's inform your other side.
Yes.
He may not have an eye
Consider
checkup.
it, inform only matter.
Yes, well.
I'm
Come back.
I'm grateful.
Thank you. We'll continue after this.
আমি তো থাকতে পারবো না।
matter. Yes. Yes, Mr. Vanas. Sorry. You want to add something?
One line to say, my lord, I just, this 122, my lord, since when I.
1 minute, Mr. Vanas. Hey, what?
Sorry, I'll just.
Yes, yes.
Yes, Mr. Vanas, please continue.
I'm sorry, my lord, I'm just, this is a lunch break, my lord, which I thought, my lord, I just
Yes, yes.
look at 120. My lord, I find, my lord, 122A, my lord, says, talks about hold the valid license or permit or certificate of registration from the government or authority. So I'm not, now I'm not sure whether C refers to, my lord, the registration before him or, my lord, any other registration. Kindly see, my lord, I find, my lord, this is the only 122A. Because if my lord, C, we were to, my lord, look at it that way, then C would mean, my lord, even if I succeed in the Bombay court, then also I can't come and, my lord, dislodge him.
A and C has to be read together also. Then.
Because, my lord, if I succeed in Bombay, my lord, then I can't be then, my lord, refused because I'll come and say that.
Yes.
Yes.
Exactly.
And my lord, that's why, my lord, I did not want to make, and I'm not so making, my lord, I also have, my lord, the labels which are quite different, I found. But, my lord, I don't want to make submission because, my lord, it will, that is exactly what they want. They want, my lord, my Bombay application, my lord, to be affected.
Yes.
Because that is, my lord, my, if I succeed there, then only, my lord, I'm really successful. Otherwise, my lord, I'm not successful because that will always.
They will say distinguishable, Mr. Banerjee. There wouldn't be any litigation in the first place then. Anyway, let us not go into that.
Yes.
That is the domain of this suits.
Yes. Because
Right.
name and label. My lord.
Right. Thank you.
Because it's a different, my lord.
Yes.
My lord, the main ground of the challenge by the petitioner is that in terms of Rule 122.
Yes.
My lord, we are relying on Mumbai High Court judgment as well as Mumbai Suit Court judgment, as well as we are relying on the Trademarks Act, Section 28 and 29. My lord.
Mumbai judgment has been placed before.
Yes, my
so
lord.
that is there.
Yes, 28, 29. Any brand name is under intellectual property, my lord.
True.
And exclusive proprietary right of any entity over particular brand name is dealt under the Trademark Act. My lord, 28 rights conferred by registration. 3, clause 3, my lord.
Right.
Yes, my lord, where 2 or more persons are registered proprietors of trademarks which are identical with or nearly resemble each other, the exclusive right to the use of any of those trademarks shall not, bracket, except so far as their respective rights are subject to any conditions or limitations entered on the register, be deemed to have been acquired by any one of those persons as against any other of those persons merely by registrations of the trademarks, but each of those persons has otherwise the same rights as against other persons not being registered users using by way of permitted use, as he would have if he were the sole registered proprietor.
This is the best justification of your judgment. Very good.
My lord, and as well as 29 section.
Right.
Relying upon these 2 sections,
right,
we have passed these orders, my lord.
Very good. Thank you very much.
My lord, this is the instructions what we have received from our department.
Instruction.
There is no
This is virtually an affidavit in operation.
Yes, my lord.
I'm not directing affidavits in the matter, purely
Yes,
question.
yes, ma'am.
You cannot improve the situation by way of an
Yes, yes,
affidavit.
my
with
lord,
the
only
single-
we can
Yes, you know in the single and all. So So let us
Yes,
stop
my
there
lord.
and thank
My
you.
lord, my.
But
Yes.
very short reply.
Yes.
Lord, if your lordships kindly take the second Bombay High Court's judgment once more. Because my learned friend has been harping, Lord, on this,
Yes.
Mr. Banerjee. Your lordships may kindly come to page 270.
270, yes.
Lord, I'll just read the operative part.
Right.
Once again. Says, the defendants to the counterclaim shall file their affidavit in response to the further affidavit on or before 19 September. Affidavit in rejoinder, if any, to be filed and served on or before 25th September. Notice of motion to be listed on 30th September on the supplementary board for hearing and final disposal. Next, B. If the defendants to the counterclaim proceed with the obtaining of licenses or other permission in that time, they will do so at their risk and peril and subject to the result of this notice of motion. C. Till 30th September 2014, the defendants to the counterclaim shall not introduce any product with the subject trademark into the market without leave of court. Now, Lord, my reading of this judgment is that, Lord, so far as grant of licenses and permissions are concerned, that was not the subject matter before the Bombay High Court. So, my Lord, Bombay High Court specifically said that if you at all obtain the license or permission, then that will be at your risk and peril. Because, Lord, the issue before the Bombay High Court was the proprietary right. Now, Lord, in this context, so far as Bombay High Court is concerned, apart from the proprietary right, the trademarks, etc., there is no other issue. So, therefore, obtaining of licenses, etc., the Bombay High Court left it to the wisdom of the respective states or, Lord, the laws that governs the grant of license and permission. Now, Lord, with this background, your lordships may kindly, Lord, come to Rule 122 once again. Because now, Lord, the excise authorities have clearly said they have not considered Rule 122. They have gone by 28 and 29 of the Trademarks Act. The relevant provisions of 122 has not been considered. That is, Lord, the submission of the excise authorities. Now, Lord, your lordships may kindly see, my learned friend has relied on A. So, Lord, I start from 122A. The commissioner may refuse registration if he is not satisfied. In the case of any foreign liquor brought into bottles in India from Bhutan or any foreign country, that the distiller, compounder, blender, or brewer whose name is stated in the application holds a valid license or permit or certificate or registration from the government of the country of origin of the said liquor to distill, compound, or blend spirits or brew beer. Now, Lord, this is in respect of a foreign company whose license is relating to manufacture of a foreign liquor, is in a different country, but he wants, Lord, that product to be marketed in India or, Lord, say in West Bengal. So, Lord, this 122A has no manner of application where, Lord, the production of the liquor is in India. Now, Lord, with this, Lord, please come to C. In the case of foreign liquor brought into India from Bhutan or any foreign country or manufactured in India, this is what we are, Lord, concerned with. That the brand name under which or the label with which it is proposed to be sold is distinguishable from other brands. So, Lord, unless if he is not satisfied that it is distinguishable from the other brand names or label which have already been registered, whose registration has already been applied.
Can it override section 23?
Now, Lord, so far as 28.3 is concerned, if your lordships kindly, Lord, come to 28.3. Subject to the other provisions of this Act, the registration of a trademark shall, if valid, give to the registered proprietor of the trademark the exclusive right to use of the trademark in relation to the goods or services in respect of which the trademark is registered, and to obtain relief in respect of infringement of the trademark in the manner provided by this Act. This is 28.1. Then 28.2, the exclusive right to use a trademark given under subsection 1 shall be subject to any conditions of limitations to which the registration is subject. Then 3, where two or more persons are registered proprietors of trademarks which are identical with or nearly resemble each other, the exclusive right to use of any of these trademarks shall not, except so far as their respective rights are subject to any condition, limitations entered on the register, be deemed to have been acquired by any one of these persons as against any other of those persons merely by registration of the trademark, but each of these persons has otherwise the same right as against other persons not being registered user, using by way of permitted use as he would have if he were the sole registered proprietor.
Does not operate against each other, but against the world at large.
Right. But Lord, provided
Precisely your case.
Bombay High Court's order, Lord, paragraph 8C was not there. This they could rely upon.
You started with Bombay High Court order has no nexus.
No, nexus with regard to grant of license. Lord, I say that so far as the proprietary, my learned friends is harping on the proprietary right. 28, Lord, he talks about an exclusive proprietary right. I am, Lord, only on the right. I am saying that, Lord, vis-a-vis my right.
Mr. Kaur, 122C, that in conjunction with 28C, because 122C also speaks of registration, which is the proprietary right.
Right.
So there is a link between the two in the sense the term registration is there in both. So that's the proprietary right. So C establishes a link with 28.3 via this term registration. You cannot deny that.
Let us, Lord, consider that the proprietary, let us concede to the argument of my learned friend with regard to 28.3. Both have rights.
Yes.
Both have rights.
Yes.
But Lord, when he is registering a label, can he overlook 122C?
Let us read 122C in the light of 28.3 now.
Correct. Correct.
Both of you have rights. Both
Correct.
of you have registrations.
Both of us have right. Both of us have both don't have registration. Both of us have rights. Registration. I have registration. He doesn't have.
No, I have registration. No, his registration
In the
is
West
also,
Bengal.
not West Bengal, proprietary. We are mixing up the two.
Let us Lord, consider trademark.
He has a registered trademark. You also have a registered trademark.
Yes.
So you are on equal footing as far as 28.3 goes.
Lord, 28.3
Yes.
is the registration before the trademark authorities.
Obviously.
Now that issue is pending in the High Court. That's what I said.
Be pending in the High Court, but as of today, both of you have registered trademarks.
Right.
And 28.3 is squarely applicable, Mr.
Lord, right with regard to trademark is subject matter of adjudication in the Bombay High Court. But right with regard to obtaining of license based on that trademark is at the risk and cost.
So first, let us proceed one by one. What is your take on the issue? 28.3 is not applicable in your case, in both of your cases.
28.3,
whether it is applicable here.
It is applicable in respect of the Bombay High Court suit.
No,
whether
in respect of the registration between you two.
Registration
We
between
are not going into any suit or any other non-pendency.
registration between the two of us. I have a registration in West Bengal. He doesn't have. Excise registration I am talking about.
Excise
registration I am talking about.
Register you.
Lord,
trademark cannot be registered by the excise authority.
No. I am not talking about the trademark. Trademark, both of us are
28.3 is entirely nothing on excise. 28.3 is entirely on trademarks.
Trademark.
So 28.3, my first question to you, Mr. Kaur, whether 28.3 is applicable to you, which operates entirely in the domain of trademark registration. No question of West Bengal.
Absolutely.
So as of today, both of you have trademarks registered in your favor, both of you. Maybe sub judice, but you have trademarks.
Correct.
So 28.3 is applicable to both of you.
28.3 is applicable.
If that is so, let us see. CC, yes.
Now, Lord, before you come to C,
yes,
if your Lordship kindly, Lord, takes paragraph 8C in the context of 28.3. 28.3 in the context of 28.3 paragraph C of the order of the Bombay High Court. Because, Lord, when there is two aspects. One is the permission and license. The other is respect of the rights flowing from the trademark, registration of trademark.
28C has nothing to do with the grant of license. 28C.
No.
8C, I'm sorry, 8C.
8C says if the defendants to the counterclaim
proceed
with the obtaining of licenses or other permission
that is
in
B, yes.
B. I'm sorry, B.
Yes.
If the defendants to the counterclaim proceed with the obtaining of licenses or other permissions in that time, they will do so at their risk and peril and subject to the result of the notice of motion.
Mr. Kaur, this risk and peril is equivalent to without prejudice to rights and contentions, shall not create any special equity, subject to result.
Yes.
Ultimately, what happens?
Absolutely.
All these
Therefore-
are synonymous. in
Therefore,
courts of law.
that question restricted to obtaining of license and permission.
This risk and peril is being subject to the notice of motion. Only to that extent. No other risk, no other peril.
Therefore, Lord, right under 28(3)
Hmm.
can't be, Lord, adjudicated by an excise authority. 28(3) is a right, Lord, which is the subject.
No, it cannot. That is what I am precisely saying, Mr. Court. It cannot be reopened or decided by any excise authority. So 28(3) operation is independent and irrespective of whatever the excise authority says.
Perfect.
So when it comes before the excise authority with 122C, 28(3) operation remains. That is in force when the excise authority looks into it.
On 122C, he has to only see that, Lord, a similar mark, whether, Lord, that or level is already, Lord, registered with the
trademark authority.
No, with the excise authorities. If your lordships will not kindly sees.
Achha, where is the scope of registration before an excise authority? Show me that also. Yes.
Kindly come to 118.
118, right?
Bengal Excise Act,
Yes,
the foreign exchange
yes,
rule.
yes.
Subject to the provisions of rules such and such, shall be manufactured or sold or offered for sale in bottles or in aluminum packages or approved measures in West Bengal by the manufacturer or wholesaler in West Bengal, unless and until the brand names under which and the label with which it is to be manufactured or sold.
Yes.
So
this is a different registration.
absolutely different, which has got no connectivity with 28(3).
The rest fall in place. If that be so, they don't have this, you have this. And 122C is applicable.
Has to be applied. And Lord, it is considered, Lord, at the bar, Lord, that 122C was not applied. They looked at 28(3).
That has
28(3).
not been considered. You are putting something into your license.
Rather,
They have not dealt with it here before in the argument before.
The
me.
argument was
They
that
are relying on something else also. Yes.
no, the argument is that
122C, there is no reflection in the order also.
nothing. And Lord, the point is, my learned friend said that we had not raised this point. We had raised this point from day one, before the excise commissioner, before the appellate authority.
Since you are citing 118 for the first time in reply, Mr. Court, I'll ask Mr. Banerjee to give a limited reply on the effect of 118.
Right.
Because all along I was proceeding on the premise of this registration being trademark registration.
Absolutely, Lord.
118 registration is a completely different aspect of the matter.
Completely different.
So we'll have to hear Mr.
It is
Banerjee.
nothing to do with the trademark act. That is the reason, Lord, I drew your lordship's attention to the second order of the Bombay High Court to point out that these issues, grant of license.
No, Bombay High Court is on a separate footing.
No,
Here we
Bombay-
are only on 118. The nexus between 118, we have to read 118 into 122C together.
Correct.
If that be so, that consideration was not there in the impugn order. That you are justified.
But Lord, in fact,
Bombay High Court is on a different footing. That also does not
I
contemplate anything.
just wanted to say
Yes.
that because Lord 28 and 29 of the Trademarks Act and the various other provisions of the Trademark Act was referred to, that's why I said that so far as trademark is concerned, the excise authorities have no concern with the trademark. They are to only go by their relevant provisions in the Excise Act and the rules for the purpose of Lord registering the brand or the level. And that is what I'm saying, that 122 has to be followed, because he has to take into consideration that the same level or the brand is already registered, and I'm using it for the past
118 opens a different front altogether.
Altogether. And I am only harping on that. I don't want to go into there, Lord, so far as the Trademarks Act is concerned. So, Lord, these are my submissions, Lord. My argument is absolutely, Lord. I gave your lordship the background just to show your lordship that the parties have been litigating.
And 118 registration they don't have.
They don't have. This is what is granted. This is what is granted. Then that is what we are aggrieved by.
As Mr. Kaur, have you stated anywhere in your application that you have a registration under 118 and
Yes,
they don't
yes.
have? Just a hint to that. Even that will do.
Petition.
In the writ petition, yes. Or anywhere in the annexures. Because then the ground of your ground becomes connected with your having a similar registration on a similar.
But kindly come to paragraph 37.
37, yes.
Kindly see, my lord, paragraph 37, page 21.
Yes, I'm there.
The petitioner submits that rule 122 lays down the ground on which commissioner may refuse to registration. It is specifically provided that for a brand to be registered under the authority, the brand name under which the label with which it is proposed to be sold should be distinguishable from the other names, labels which have already been registered in the instant case as the name of the brand mansion house, which is already registered by the petitioner company since long, can in no way be distinguished from the brand name which is being sought to be applied for registration. The impugned order is unreasonable, illogical, etc. This is clearly, my lord, one place where at least we are saying that we have long registration. And Lord, paragraph 38, 39, where we say that if our brand name is going to be affected.
Different, Mr. Court.
But in fact, at the beginning of the petition.
Beginning is what I'm looking at. Because there you might have said it.
Para 2, para 3, para 4.
Yes.
Para 7, Lord, we say that
Photocopies have also been annexed. Let us see.
These are all, Lord, annexed. I can give your lordship the page. Page 64. Page 64, Lord. This is one of such document in West Bengal. Current one. And page 44 onwards, your lordships will find
For this year.
Lord,
44 onwards are in 2 dimensions, Mr.
That's right. But
Only in 2
for
dimensions.
this year also, Lord, this is what is
If these are in 3 dimensions, then we could have considered.
Lord, for this year also, Lord, I have the approvals with me.
No, but 64 is sufficient. You have alleged. Yes. Yes, Mr. Banerjee. What about that? That registration you don't have probably.
No, that is, my lord, it is not the case, my lord, that
No, we are only on, they are only on 122C non-consideration.
Yes.
So that registration acquires a different dimension if you take into account 118.
My lord, I'm on the question, my lord, absolutely correct. It doesn't take into a different, my lord, account because today, my lord, the excise commissioner, my lord, cannot decide on the question of, my lord, validity of, my lord, registration under the trademark.
No.
Nor can it, my lord, decide whether, my lord, my mark is valid or not valid. Because what the registrar today, the excise commissioner is seeing today is 2 marks which are both registered. And he does not have, my lord, a superior right than me. This is what is important. That is what I said, my lord, that 122C, if, my lord, given the meaning what, my lord, Mr. Kaur is saying, read with 118, that means I can never get onto the register. My label can never be registered. Even, my lord, if I get, my lord, an order from the Bombay High Court, or if I have not got an order of injunction, I can, my lord, today never have my label registered with the excise authorities. Because he will always say, sorry, I am there from before. Kindly, my lord, look at, my lord, 120. That's why, my lord, I showed 122A, my lord, is also exactly similarly worded, except, my lord, manufactured here. Kindly see, my lord, 122A also. It may refuse registration if it is not satisfied. In the case of any foreign liquor brought in bottles into India, same, my lord, as in C. From Bhutan or any foreign country, same, my lord, as in C. Only what is C is different is or manufactured in India. So 122 C will also have to take its color, my lord, from 122A. Otherwise, what is the meaning of, my lord, my having a trademark registration? My lord, I have a trademark registration, my lord, so that means I can, my lord, carry on my business. Let us understand, my lord, there was no Bombay suit.
You don't have a registration under 118. There is no doubt of
No,
that.
that is, my lord, what I'm applied for. I want my label to be registered with the excise authority so that, my lord, I can continue. And that is what I've got. That is also what they have got. At page, my lord, that I showed, my lord, 12th December 2022 is the order at page 302. My lord, is, my lord, 14th. My lord, is when I opposed. And he said, there is nothing prohibiting me. He, my lord, looks at the other order also, where, my lord, he got his, my lord, registration.
So as per their argument, there may be a scenario where both of you have valid trademarks, but you will be refused trademark registration
with
brand name
Yes.
registration.
My lord, with the greatest respect, my lord, how can, with the greatest respect, if I put an argument, my lord, in a question, how can that be? Because he has a valid registration, I have a valid registration. Just because, my lord, he beat me to the race to go and, my lord, quickly have, my lord, a label registered, my lord, with the excise authorities, can he, my lord, forever stop me from, my lord, having my name registered? No, my lord, I am permitted by the law of India to, my lord, carry on, my lord, with that name. So this argument, my lord, that's why I showed, my lord, 122A, my lord, will see exactly same. It talks about, my lord, a certificate of registration. And this is, my lord, not from, my lord, the registering authority, the excise commissioner. This is merely, my lord, a label registration for me to then, my lord, because what happened, my lord, when I went to BEFCO, this is sorry. We are not going to register your brand. And my lord, Duk said, my lord, I'm just sorry, my lord, I'm just because Mr. Kaur, my lord, brought up this point in 302 also, and that is the argument, my lord, which I showed.
No, Mr. Banerjee, you need not. That will be a reply to a reply to a reply.
Kaur, my lord, doesn't want any further
Only
clarification.
on
my lord, on that.
189.
My lord, so
Any
I say, my lord, that's, my lord, what I say, my lord, 118, my lord, has to be, my lord, read with, because 118, if my lord looks at 69, 70, 71, 220, no foreign liquor shall be manufactured or sold or offered for sale in bottles and annual bags and such by the manufacturer wholesaler unless until the brand names under which and the label with which manufacturer sold have been registered with the commissioner. And a permit has been granted by him authorizing manufacturer sale under such brand name and such label for each measure.
Yes, anything to add on 118? You have made your arguments, I suppose.
Only we are relying on this because we are considering this is the brand name, is a proprietary right. And it is under intellectual property right, and so we are relying on these sections, my lord.
My lord, I also have, my lord, if the Delhi High Court division bench judgment saying, my lord, and which I think, my lord, is very clear, that so far as, my lord, trademark, my lord, so far as dispute, my lord, under the trademark is concerned, my lord, they don't have, my lord, any, the excise commissioner doesn't have, my lord, any authority, my lord, to even decide that.
Obviously, they don't have. Yes.
My lord, just, my lord, took that out, my lord, my lord.
I think Mr. Banerjee should rely on his own suit and it order passed in his own suit.
Yes, and my lord, also the order passed in my suit, in not in his favor.
Arguments concluded, judgment reserved. Yes.
Much obliged. I'm really sorry. Yesterday also, I was
why sorry?
Because I detained your lordship yesterday. whole.
Thank you very much.
I'm grateful, my lord. It's only, my lord, Mr. Kaur, my lord, who's detained. I'm not detained. So, my lord, since he's
raised by him, not by me. We are here in court because of him. Him means his class.
We are in confusion.
Yes, you're in the.
That will be cleared now.
I'm grateful.
Item 21.
The last. এটা অ্যাপিলেট সেটের লাস্ট মানে 3টে থেকে তো অরিজিনাল সেট yes move the petition yes no difficulty till he comes
well probably this application has become infructuous my lord I have got instruction my lord just
see the expression at your left yes
that the meter has already been installed yesterday.
I do not have any such instructions, my lord. To be mentioned tomorrow, take instruction, come back. My lord, counsel for the distribution license submits that In all probability, the matter has been rendered infructuous in view of connection having already been given, which of since learned counsel for the petitioners is not aware of such a scenario up to now, comma, to enable learned counsel for the petitioners to take instructions, comma, let the matter stand over till tomorrow when it will be listed under the heading to be mentioned for passing orders. To be mentioned, kalke diye debe.
The only thing, let it be upon instruction, my lord.
You have to take some responsibility.
As a lordship. I'm grateful, man. Much.
Urgency ডাকতে হবে। বাকি ম্যাটার রিলিজ করেছি কি না করিনি তো? কোথায় ডাকবো?
22.
Lordship.
Yes, petitioner.
Yeah, I am for the petitioner.
Mr. Lahiri, why are you ominously hanging over him?
24. That is why I thought that Lordship is going to original set.
I'm happy on behalf of the petitioner.
Yes.
Lordship.
Mr. Lahiri, your matter won't be taken up because I'll take up. Oh, I'm sorry, 2:30. Yes. I was thinking, yes. Or to তুমি মাথা নেড়ে দিলাম তুমি বললাম জরুরি আছে এরপর। ইনি কি?
Sir, I am Dr. A.K. Ghoda.
আপনি পার্সোনালি you are appearing personally?
Yes, sir. I am international court chairman ছিলাম।
হ্যাঁ।
তো
আপনার লয়ার নেই কোনো?
লয়ার আমি ন্যাশনাল জাজ ছিলাম কলকাতা হাইকোর্টের এবং চেয়ারম্যান ছিলাম। তো I am very shocking upon digesting all covered. I am up to what something to hard it.
আপনার কি কোনো অ্যাডভোকেট আছে? আপনার কোনো অ্যাডভোকেট আছেন? এখানে কোনো অ্যাডভোকেট দিয়েছেন?
হ্যাঁ, 1478 মামলা ছিল সেটা হাইকোর্ট রায়
বাংলায় তো জিজ্ঞেস করছি কোনো অ্যাডভোকেট দিয়েছেন কিনা হাইকোর্টে? হ্যাঁ না না?
ইয়েস, দিয়েছে, মামলাটা দিয়েছিল এবং
কোথায় আপনার অ্যাডভোকেট?
পীযূষ ভট্টাচার্য এখন ছিলেন উনি এবং সেই
এখন আপনার অ্যাডভোকেট কে?
এখন আমি ন্যাশনাল জাজ, আমি নিজে
আপনি ন্যাশনাল জাজ মানে?
ইন্টারন্যাশনাল পার্লামেন্ট কোর্টের থেকে আমাকে ইন্ডিয়া গভর্নমেন্টের ইলেকশন কমিশনের চেয়ারম্যান।
আপনার সার্টিফিকেটটা দেখি ইন্টারন্যাশনাল পার্লামেন্ট কোর্ট থেকে। Yes, Mr. Halda scrutinized for me the certificate.
All documents copy first in this area.
আপনার credentials এর document দেখি আগে। Yes, Mr. Halda, I am appointing you amicus curiae. Yes. বাংলায় লিখে দিয়েছি ইন্টারন্যাশনাল পার্লামেন্ট থেকে।
ইন্টারন্যাশনাল পার্লামেন্টের সুপ্রিম কোর্ট থেকে আমার ইলেকশন কমিশনের চেয়ারম্যান দিয়েছিল। ওখানে বাড়ির ভিতর থেকে সমস্ত অ্যাকাউন্ট বুক।
কিসের চেয়ারম্যান?
ইলেকশন কমিশনার বোর্ডের চেয়ারম্যান।
ইলেকশন কমিশনার বোর্ড কোন অ্যাক্টে হয়? কোন আইনে? ইলেকশন কমিশনার বোর্ড বলে কোনো বোর্ডের কথা আমি শুনিনি। কোন আইনে?
দিচ্ছি আপনাদের পেপারটা দেখাচ্ছি। প্রথমে ইন্ডিয়ান জেনারেল ছিলাম।
আরে আমাকে না
Yes.
My lord, I am not aware whether he is in my case in person.
No, his name is there, respondent number 5. Your name is? এটা কি?
আপনার নাম কি?
ডক্টর অলোক কুমার ঘোড়া।
না না, এ তো আলাদা।
তা আপনি এখানে কি করছেন এই মামলায়? আপনি কার হয়ে করছেন?
এই মামলায়
হ্যাঁ,
মানে আমার যে 1478 এবং 1995 এবং 70-10 এই মামলা করেছিলাম, ওয়ার্ল্ড পার্লামেন্ট করতে আমি জিতেছিলাম। তো এখন সিকিউরিটি আমাকে আমার সমস্ত কিছু ডকুমেন্টস থাকা সত্ত্বেও তারা আমাকে এই।
আপনি এই মামলায় পার্টি?
না, এটা কত মামলা চলছে সেটা আমি বলতে পারছি না।
আপনি এখানে, আপনি আপনার জায়গা ওখানে না, আপনার জায়গা তো আমার জায়গা এখানে। আমি সরে যাচ্ছি, আপনি এখানে বসুন। আপনি
না, সেটা বলছি না। আমার এই অ্যাপ্লিকেশন,
আপনি আসুন
না আমি অ্যাপ্লিকেশনটা দিচ্ছি তো ওই জন্য 70-10 মামলার অ্যাপ্লিকেশনটা দিয়ে যাচ্ছি।
আপনি ডাইরেক্ট চিফ জাস্টিসের কাছে দিন, 1 নম্বর কোর্টে উনি বসছেন।
আচ্ছা,
এটা চিফ জাস্টিসের কাছে হবে ডাইরেক্ট।
ওকে স্যার, থ্যাংক ইউ।
থ্যাংক ইউ।
Spend a lot the spirit of the general flavor of the gentle opening of your minor intellectual power. That's to lying about substance that was there wings to travel stage or so. But such episode are only knowledge about question person the equal.
No, Mr. Ghosh, let him speak. He's before a court of law. Yes, কি বলছেন বলুন। হ্যাঁ।
For this life full of grey, oh, have no time to stand, no time to stand and another both and stay along sleep, no time to sin, but realize, scores marks in case, no time to how conduct, no time to see full star arena. International commandant push, in continuous to us, there uncountable is the running between government, state government and central government. আইন ঠিক মতো চলছে না, ইলেকশন কমিশন বোর্ডের চেয়ারম্যানের গায়ে হাত দিল, এখানে প্রশাসন কিছু করছে না, আইনজীবী ডিএমএসপি তাহলে করবে কে? আমার হাতে তো হাইকোর্টে অর্ডার আছে,
আপনাকে হাত
পার্সেল টু দি নোটিফিকেশন নাম্বার হাইকোর্ট।
হাত কে তুলেছে আপনাকে?
পলিটিক্যাল সমর্থক যারা ছিল, যারা পলিটিক্যাল লিডার ছিল, তারা আমার গায়ে হাত বাঁধিয়ে মারামারি করে ওরা আমাকে হসপিটালে ভর্তি করে দিয়েছে, এবং আমার বাড়ি থেকে ট্যাং আনচেস্ট যা ছিল পলিটিক্যাল লিডাররা চুরি করে নিয়ে চলে
হাসপাতাল
গেছে।
থেকে ছাড়া পেলেন কবে?
আমি গত পরশুদিন ছাড়া পেয়েছি। ছাড়া পাওয়ার পরে ওরা আমাকে বললো যে আপনি হাইকোর্টের মামলাটা ছিল 1478 মামলা ছিল।
কোন হাসপাতালে ছিলেন আপনি? পার্ক সার্কাসের
না,
দিকে?
পূর্ব মেদিনীপুর ডিস্ট্রিক্ট হসপিটাল।
কোথায়?
পূর্ব মেদিনীপুর ডিস্ট্রিক্ট হসপিটালে। এখন আমার রান্নার খাবার
চিফ জাস্টিসের কাছে মেনশন করুন, আপনাকে অ্যাডভোকেটের পেছনে যারা আছেন তারা হেল্প করে দেবেন।
Okay, sir.
চিফ জাস্টিসের ঘর ডাইরেক্টলি মেনশন।
থ্যাংক ইউ স্যার, থ্যাংক ইউ।
Ponna is inclined to help her.
And what is your argument in this
আমার
case?
উপর হামলা করুন জাস্টিসের, তারপরে ইন্ডিয়ান গভর্নমেন্ট, স্টেট গভর্নমেন্ট আর অল প্রপার্টি।
আপনি চিফ জাস্টিসের ঘরে চলে যান, এই করিডোরের শেষে দেখবেন বসে আছে সুন্দর দেখতে লম্বা মতো, ওনার ঘরে মামলা।
My lord, Mrs. Ponna Rai Chaudhary has consented, she will help her. Help him.
I appoint jointly special officer Mr. Ghosh and Ms. Rachel.
Personal refund, personal account book, debit card, credit card, hag in country. I challenge my country and over my country.
চিফ জাস্টিস বসে আছেন আপনার মামলা শুনতে।
আমার অন্য মামলা আছে।
সেটা করুন।
না না, ওদের মামলা, আপনি চিফ জাস্টিসের ঘরে সোজা চলে যান, লম্বা দেখবেন, কোকড়ার চুল, খুব সুন্দর দেখতে, চলে যান।
এটা কি পসিবল? আপনি বিচার করুন।
My lord, may I first candidly
You
say?
served on the more. Let us come back to the world. Yes, have you served the other side?
I have served all the articles has been dispatched from the concert SO, but receiving endorsement has still not within me.
So no proper service as yet.
No, kindly, my lord, this is a very essential. I am residing in.
Yes, but what can you do before?
No, my lord, I am praying that kindly keep it on Monday at top.
What is the urgency?
Urgencies, I am living in total. I am living in total dark for several days. This is
Well,
for
Monday, not Monday, Tuesday. That Monday will be the combined list.
my lord, Tuesday top.
The service has not yet been effected. Footstep Learned Counsel for the petitioner submits that the matter is extremely urgent. Footstep, let the matter stand adjourned for till August 8, 2023, when it will be placed fairly at the top of the list.
Much obliged.
23.
Yes.
I am for the petition.
I am for the CS in this matter. my lord.
Lordship, petitioner is a consumer of electricity of a domestic purpose, Lordship, and paying regularly electricity bills. Lordship, on last occasion, in January, month of January, petitioner has deposited, Lordship, 3,360 rupees. Thereafter, Lordship, all on a sudden in March 2023. Yes.
Sorry. Bol, Baba, bol.
The CSC authority has all on a sudden raised a bill of rupees 1,24,000 all on a sudden. After 3,360, it has been raised to 1,24,000. Lordship, I have filed before the grievance redressal officer, no steps taken, and they are threatening to disconnect my connection.
My lord, according to my instructions, my lord, we have found a nexus between the landlord and tenant, due to which he has been served with an escalated bill. Now, my lord, if your lordship kindly comes to page 11, page 10. My lord, on 18th of July, he has already approached the GRO.
But Mr. Ghosh, you have to be transparent on that. You have to give the breakup that this is
My
the
lord, everything has been, but because his case is pending before the concerned GRO, my lord. It's in page 10.
Why should you even go before the GRO?
Lordship,
Because it was
kindly sees the
escalated.
unit in the bill.
Escalated subsequently after he went to the GRO.
No, before.
Before. And my lord, his only anxiety is that his line might be disconnected. But my lord, I can undertake with the court, my lord, unless the GRO takes any steps, his connection will not be disconnected.
Lordship.
The grievance of the petitioner is that the petitioner has challenged a billing dispute before the concerned grievance redressal officer. However, the same is not being decided as yet. The petitioner apprehends disconnection prior to the matter being decided by the grievance redressal officer. Next para, Learned Counsel for the CAC Limited on instruction submits that the CAC Limited shall not disconnect the electricity supply of the petitioner on the ground of non-payment of the disputed bill till the matter is decided by the grievance redressal officer. Next para, in view of such fair stand taken by the CAC Limited, WPA 18303 of 2023 is disposed of by directing the grievance redressal officer concerned, that is the respondent number 2, Respondent number 3, to decide the dispute raised by the petitioner in accordance with law as expeditiously as possible, comma, preferably within 4 weeks. Within 4 weeks from date. Full stop, the CAC Limited shall not disconnect the electricity supply of the petitioner in terms of the submission made in court, which has been recorded above. Till then.
Grateful.
No address to cause urgency.
Deeply.
192.
24.
My lord, I am challenging the order passed in by the National Green Tribunal, and my lord, the immediate cause of my lord.
National Green Tribunal challenge is maintainable?
Yes, yes.
Tell me on that first.
Yes, my lord, there is a Supreme Court judgment. Subsequently, my lord, it has followed L. Chandra Kumar.
Go the other side.
My lordship, I'm for the state. I'm praying for not today or on Monday, my lordship. Haven't received the report yet.
State is the main respondent here.
State would not be the main respondent in view of the fact that Mr. Subhas Datta has made this application. What has happened, my lord? Here, the state government, my lord, purportedly acting on the basis of the my lord, orders passed by the National Green Tribunal, has my lord stopped registration of all instruments in respect of 5 mojas in Malda, saying that those mojas are a wetland. The private respondent moved an application before the National Green Tribunal.
Registration of what?
Registration of any conveyances. Page 192 is my immediate cause. Kindly comes to page 192, which gives rise to everything. In compliance with the order dated such and such, my case is that there was no order to that effect. My compliance with the order dated such and such is legible,
more or less, yes.
more or less,
I can read.
yes. In compliance with the order dated such and such, National Green Tribunal is it OH such and such in the matter of Subhas Datta and such. He is hereby requested not to execute any deed as per order and known as Chatra Bill relating to the following mojas under English Bazaar PS Uttar such and such. I am in respect of serial number 2, Firozpur. And there are other mojas.
What is that order, Mr.
That order would be at page 194. There is no such directions.
The consequence?
Yes, 193 is the consequence. All malad, just before going to 194, 193 is the consequence. All the malad, the loans have been stopped. The loans which were disbursed in view of this, everything has been stopped, malad. Entire thing is in a malad doldrums. Kindly comes to page 194. This is the order which has been quoted there. Mr. Subhas Datta such and such, the present original application has been filed by the applicant alleging the Chatra Bill, which is wetland in North Bengal in the district Malda, is being encroached upon due to expansion of city Malda. It is stated that this wetland is a natural wetland and the natural water purifier of the water of such and such. It is stated that, malad, I'll just skip it, come to the malad. Paragraph number 14, page 195 is the direction. Considering the allegations made, we deem it appropriate to constitute a committee comprising of the following members. Senior scientists, everyone is there. Paragraph 15, the committee shall visit Chatra Bill and inspect the site and submit its report with regard to the encroachment alleged to have been made upon the said water body, and it shall suggest remedial measures for restoration of the said water body to its original pristine form, and as well as remedial measures to ensure that there is no further encroachment into the water body. Meantime, we direct the district magistrate Malda to ensure that no further encroachment is permitted in Chatra Bill during pendency of the present proceedings. Now, my lord, my contentions before your lordship would be first to satisfy your lordship's constraints. First, kindly comes to, because I understand, my lord, this when they came also, I first, my lord, saw this. Kindly comes to the record of rights. For your lordship, record of rights certified in 1955, page 45. Top right hand corner, kindly see Firozpur. Firozpur. 440, top, middle.
This is almost illegible. Yes.
This is, there is a type copy also, but I do not rely upon type copies. I do not rely upon. That is why. Now, kindly see the attestation on the right hand side.
I can read Rajbihari Bandyopadhyay at the top, page 45.
Yes. Kindly go further top, Firozpur, here. Subsequently, also I can show this, but I want to show this document.
Yes.
55 document.
Yes.
One is 440. In the middle, kindly see.
Yes.
Top.
Yes.
This is certified in 1955. Now kindly comes the royalties, then the names are there, kindly comes to the next page. This is the reverse side, 46. Dag number is 777. Now kindly see Sreni is Bagan.
This is the same plot number.
Yes.
This pertains to the Chatra bill.
Yes. Chatra bill is, my contention is there is no Chatra bill. That I'll be trying to substantiate. That is on merit. I'll not draw your lordship's kind attention now on merits. Now, Mala kindly comes to the present record of rights also.
Chatra bill was never a water body. That is your contention.
That is in Bangladesh. That I'll be substantiating subsequently, my lord. But let us proceed on the basis that he has made an application on the basis of water body.
So Chatra bill is as good a bill as Creek Row is a creek.
Yes. But that I'm not going, even if it is not
We cannot
Chatra
go into that.
yes, even if it is not Chatra bill, if his allegation is a water body, then also it is maintainable. Now,
Contention is on the basis of this, even on the basis of this order of the Pollution Control Board. I mean,
National Green Tribunal.
National Green Tribunal.
Yes.
The transactions cannot be stopped.
My contention is that this original application is not maintainable before the National Green Tribunal. Yes.
Why do you say that?
Yes, kindly. National Green Tribunal Act. Kindly comes to first National Green Tribunal Act.
No, just tell me, Mr. Lahiri, before going
Point.
Just indicate to me
Yes,
the
National Green Tribunal Act gives my lord the tribunal to my lord decide in respect of certain schedule acts, which is there in respect of my lord the Land Reforms Act. There is a schedule. There are certain acts. If it arises out of those acts, you can go to National Green Tribunal. In that schedule, one of the act is Environment Protection Act. Now, in that invoking powers of the Environment Protection Act, my lord, the rules have been framed for preservation of water bodies. Those are the only rules which can be said that are being violated while filling up a water body. The rules provide that until and unless a particular water body is a notified water body, those rules will not be applicable. So therefore, the remedy would be saying that you are violating the provisions of inland waterways.
In that event, Mr. Lahiri, you also have to implement Subhas Datta.
Yes, he is there. He has received. He doesn't come, my lord. He has received.
No,
we have served by hand.
He has to be implemented as a.
He is. He has been.
He's a party here.
Yes. He is a party. He is a party. He is the original applicant. He has to be a party. You have served. He has received by hand also. Respondent number 12, my lord. May I draw your lordship's kind attention to the rules?
What is Mr. Datta's stand in the matter?
Mr. Datta has filed the original application. Kindly comes to the averments, paragraph 6 in the original application, which has been annexed here. Page 147. This is the allegation of Mr. Datta. And entire petition is based on Google Maps. There is no authenticated document. Kindly comes to paragraph 9. This is his contention. The population density in Malda is rapidly increasing.
Mr. Lahiri, if you had to take a maintainability point, why not go before the tribunal itself and take the point?
That would be, my lord, admitting to the, my lord, jurisdiction.
Definitely not.
Because if I can show before your lordship, because it is admitted that this particular my lord, water body is not notified water body, is admitted from the subsequent proposal given by the committee appointed by the National Green Tribunal that this should be sent for notification.
Then, Mr. Lahiri, the others have to be heard.
Yes. Others have to. I don't say that they don't have to be heard. As of today, I am on notice. I have given notice. There is appropriate notice.
What sort of interim order are you expecting?
Interim order to the effect that this present 192 should be stayed. Because there is no order keeping these points of maintainability open, my lord. And before that, I'll be showing your lordship the Supreme Court where it says that your lordship is having jurisdiction. And second of all, that it should be before a single bench. Because previously showing that order, I had already moved a division bench. the Honorable Chief Justice, my lord, the Honorable Justice Justice Srivastava, when his lordship was the Honorable Chief Justice, had passed an order saying that if you have a personal grievance, you have to move the bench having determination. So your lordship is having determination in view of the fact that this is a personal and this is arising out of National Green Tribunal. So as of today, I'll be putting for stay of operation of this 192. This has caused havoc.
Now, Mr. Lahiri, who is the answering respondent actually?
Answering respondent will be state.
What role has the state to play?
State has issued additional district magistrate's communication is impugned before a lordship.
When can you come back? You were asking for time. Why?
My lordship report has not been served.
Pardon, I can't hear you. Yes.
My lordship, your report is not ready yet.
Okay.
I don't want a report. I want an argument on this law point.
My lordship, we have just received the brief yesterday only.
I'll keep it fairly at the top tomorrow. Please come prepared.
My lordship, on Monday, my lordship.
Monday.
Tomorrow he's also
Monday.
Yes. Monday is a combined list then.
Oh no. Then I cannot risk. Then they are on Wednesday.
Very well. An adjournment is sought. I'm tempted to say that an arguable case has been made out, but she'll be embarrassed. I mean, unnecessary.
Or your lordship may.
If it's purely on the law point, and
purely on the law point.
The state
First, because I have shown your lordship the record.
The state may say controvert your other submissions, which you are making now. You're going
that other submissions to the effect
regarding the arrest records and all these, the nature and character of the property.
Only to satisfy your lordship's conscience, I have shown. Because had this been
water body, and only then I'll have to direct affidavits. Otherwise, I'll be deciding the issue. Also.
Yes.
Learned counsel, an adjournment is sought by the state. On consent of learned counsel for the parties on the next returnable date, the matter is adjourned till August 9, 2023, when it will be placed fairly at the top of the list, under the same heading. The affidavit of service filed today be kept on record. Please keep this with you, just hand over on the next.
Yes, I have.
This and the other judgment of the.
Yes, that is quoted. You can hand over it now also, my lord. They have followed. They have basically, the challenge was thrown to section 22 of the National Green Tribunal Act, which says that from NGT, direct appeal will lie before the Supreme Court, as was in Administrative Tribunal Act. So that provision was challenged by Madras Bar Association, saying that this is ultra vires being contrary to the basic structure of Constitution. The Honorable Supreme Court, following L. Chandra Kumar, has held that this is basic structure. You cannot bypass 226, 227. So therefore, 227, 226 jurisdictions would be retained.
NGT is situated where?
Newtown.
Oh, in our Newtown.
Yes, everything within. So having jurisdiction to entertain, my lord.
Otherwise, you have made out a very good case on this circular. Probably this could not have been issued.
No,
on the basis of that order, it could not be issued.
Yes.
So on that count, yes, but you are preferring a larger challenge. Whether this lies before the NGT, that's why I think it should be adversarial to that extent.
In that case, my lord, may I pray before your lordship? No, that will be granting without hearing.
No. Let us come back on that date. If you want to restrict to that, also take instruction. Then I can do that.
No, I want to, because this has been going on for some time.
Whichever way, if you challenge the entire gamut of the matter, the jurisdiction of
jurisdiction,
then definitely
my contention is that these things will be here.
But otherwise, it's very palpable. This circular is not the natural consequence of the NGT order, definitely.
What has happened is the committee has been
anybody from encroaching upon a particular bill cannot deter the registering authority from registering and all other things which have been said.
Yes.
Come prepared on that. Yes, thank you.
25.
None appears for the parties. You are appearing for that?
Praying for a not today in this matter on behalf of the petitioner, my lord.
An adjournment is sought on behalf of the petitioner. Let the matter stand adjourned till the monthly list of September.
Yes.
My lord, I'm appearing for the petitioner, my lord.
I appear for the private respondent. My lord.
My lord, apparently I'm challenging a SARFAESI action, my lord. This writ is against a non-banking financial institution, NBFC. My lord, why I have preferred this writ? Because there is a clear violation of the RBI circular, my lord. They have classified my account as a non-performing asset. without there being a default of 90 days. My lord, I'll show it to your lordship why. My lord, may kindly come to.
Your lordship,
You are for the bank.
yes, 2 and 3, your lordship, before entering into the merits, the maintainability of the writ petition is to be decided first, your
That
lordship.
means you have nothing on merits.
Your lordship, I will come to the merits later on. First of all, your lordship, kindly see the
Not
array of,
maintainable.
array of parties and the relief sought for, your lordship. Lordship, in the recent judgment of Naveen
Matthew.
Yes, your lordship, this South Indian Bank versus Naveen Matthew, your lordship, the Honorable Apex Court has made it clear.
My lord, I admit, my lord.
I will
I'm
just
ready
kindly
to
see
go
the
before
array of
the
parties
DRT.
and the relief sought for, then I will show the judgment, your lordship.
My lord, I'm ready to go before the DRT. Had they have served the possession notice, my lord, to us
Can move the
within
DRT
due
at the
time.
13th stage.
No, my lord. 13.4 has been
13.4
issued.
has been
It was not served upon us, my lord. Rule 8.1 was not compliant.
Everything has
No, my lord.
everything within the jurisdiction of DRT, your lordship.
My lord,
All the
kindly
three,
give- my
all
lord,
the three
kindly
benches
give me
are
the
functional.
liberty because, my lord, I am
Kindly do what?
my liberty
up to
to
kindly.
approach the DRT, my lord,
There is
because
always-
I'll
I,
give you that liberty.
my lord,
Always
if
there
that
is
be so, my lord, then no issues.
At the outset, a maintainability issue is raised by the respondent numbers 2 and
2
3.
and 3.
First up, next para. Learned counsel for the respondent numbers 2 and 3 is justified, comma, since under the SARFAESI Act 2002, comma, the appropriate authority for a challenge of the present nature, comma, since the measures under section 13 within bracket 4 of the act has already been resorted to, comma, is the debts recovery tribunal. Full stop. Accordingly, WPS 17
My lord, by condoning the delay, my lord, because that part the DRT does
Your
not have.
lordship,
My
that-
lord, then on merits.
if
My lord,
under
only
How much
statute
delay?
she is
How
not
much delay?
entitled-
my lord, 10 days delay. My lord, may kindly condone the delay.
Accordingly, WPA number 17163 of 2023 is disposed of by granting liberty to the petitioner to move the debts recovery tribunal on the self-same reliefs as sought for in the present writ petition, comma, if necessary, adding further reliefs with regard to the action taken by the respondent numbers 2 and 3 under section 13 within bracket 4 of the 2002 Act. Full stop. Next para. It is made clear that since the writ petition has been kept pending for some time, comma, the debts recovery tribunal shall proceed on the premise that the challenge, comma, if preferred by the petitioner within August 7, 2023, comma, has been filed in time. Full stop. No rest to cause answer.
I'm grateful to you.
Only one point, your lordship. This should not act as a precedent, your lordship. If a party is not entitled in a statute to go beyond.
What ratio have I laid down?
No, your lordship.
It cannot be a
un-
precedent in any event.
Lordship.
What do you mean by a precedent? I have
Your
not laid
lordship,
down any
because-
law at all.
Because this is a practice going on, your lordship, that
This is also a practice going on. Even if it is not necessary, we say it is not. It will not be a precedent. How can this be a precedent?
because by this condonation of delay, if under statute a borrower is not entitled, then by taking this judgment, the can approach and take benefit even to file
No, then
beyond.
I'll have to decide why I have granted. That will be a precedent. Then I cannot say it's not a precedent.
My lord.
I can give my reasons right now. I have my reasons in my mind. I did not put that because this will so that it does not become a precedent.
No.
That's why. There are certain reasons.
As
I'm grateful to your lordship.
So many reasons are there. Anyway, 10 days delay, don't take these points.
27.
I'm for the petitioner.
I'm for the respondent number 8.
Right.
For Union of India.
Well, there is no scope for interim order. After lordship, here's my learned friend, then I
Is
will
there
ask
any
for
scope,
it.
Mr. Chandra?
Yes.
According to me,
Yes,
I may
yes.
be wrong also. According to
Yes, my lord, there is a scope for interim order.
me, at least not against me, I'm R8.
That's the different issue.
Irakar. May I file my Bakaratnama? Department.
Yes.
Onek do not, onek.
Yes, Mr. Chanel.
Now I tell you, Lordship, my lord, in a nutshell, I just give you, Lordship, the facts. My lord, I'm a owner of a particular plot and premises in New Alipur. Now, that's 37B, Block B, New Alipur, Calcutta, 53. My lord, I never mortgaged, my forefathers also, now I'm the owner, my father has died. Neither my father nor myself has never mortgaged or kept any collateral security in any financial instrument in respect of my property. My lord, in 1996, what my father did, he entered into an agreement with, my lord, the petition and a respondent numbers 12 and 13. My lord, for sale of the property, agreement for sale. What he further did, my lord, he handed over the title deed to 12 and 13 and possession of a portion of the ground floor. Now, my lord, subsequently it transpired, my lord, that someone has made a collateral security or made a mortgage with my property. It's respect of, my lord, two of the bank is ultimately found, one the erstwhile United Bank of India and the UCO Bank. My lord, since the loan was not reimbursed, they, my lord, started proceedings.
They started
Proceedings under the SABYASACHI Act. Now, my lord, so far the respondent numbers, my lord, 9 and 6. 9 is the assignee of the, my lord, present Punjab National Bank, and so far as the 6 is the, my lord, present UCO Bank assignee. They were assigned the interest, my lord, they proceeded under the SABYASACHI. Now, my lord, both these proceedings, my lord, ultimately, my lord, orders were passed. My father was placed out of the possession. My father took up the matter with the authorities, all investigating authorities, that I have never kept my property mortgage with any financial institution. Now, my lord, ultimately report came from the investigating authorities that all the deeds submitted to the banks are forged and fabricated, and the original deed was ultimately handed over to
authorities means which authority? Police.
my lord, the police authorities. Now, my lord, they filed, but curiously, my lord.
So this was not under the SABYASACHI Act.
My lord, the SABYASACHI.
You didn't approach the DRT?
No, my lord, I did approach.
Father?
I approached. I was not entertained. That's, my lord, in regard to that, I want interim protection. Now, my lord, police curiously, my lord, the CID, they did not find the person, some mitra, who took the loan. But he could not be found at all. Now, the other persons involved, they could not be found also. Now, so far, the one of the proceedings, Maladai, before the authority, Maladi, DRT, I prayed for, showing all these, that please don't proceed with the execution proceedings. Because ultimately, every authorities under the law has declared that those deeds are forged one. What the executing court said, they can't go beyond the order as the usual principle. Now, that execution proceedings, I am praying stay before your lawsuits. So for that.
Execution proceeding is the recovery officer.
Recovery. Now,
can the recovery officer go beyond the award.
That's
going to approach the 17th.
I must appellate provision, your lawsuits. But I'm on that. If a thing is fraud, it ravels everything. I cannot be restricted.
So nullity of the award on the ground of fraud.
Exactly. This is my first point. Second point, your lawsuits. If
but is that applicable, Mr. Chanel, even if the fraud was committed by a third person and not the award holder?
But every, I tell you, lawsuit. Even the bank committed fraud. The second point I'm coming to constitutional tort.
Constitutional fraud?
Constitutional tort.
Why?
I tell you, lawsuits. Two banks are the wings of the state, as well as the Reserve Bank of India. Reserve Bank is also the central government organization. So, if a person suffers his civil right under the hammer of the government and its wing, this is a civil tort. Admittedly, this has been found by the authorities that title deeds are forged one. I never entered into any mortgage or any collateral security. Now I have been forced to pay 3 crores to save my 10 crores property as of today, and those are to the assignees. Now, if it is so, my lord, the recent judgment of the Supreme Court, considering all the judgment, my lord, describing what is constitutional tort. Now, point is, your lord, if I have not mortgaged to the bank, if I'm a, my lord, guarantor or something, I have to execute certain documents as a guarantor. But I'm putting to question to myself, who executed those documents? before the statutory financial institutions. But I have paid for cancellation of their licenses also.
What interim order are you asking?
For the purpose of suspending the license. But if they go like this, any citizen, any poor citizen can be taken into tax by them by at any point of time by taking their property.
Suspending license of whom?
All the assignees. It be respond number 9 probably. From 9 and 6.
License means license of
They are the assignee of the bank. Suppose your lordship bank is a secured creditor.
Yes.
They can give their interest.
Asset is the asset reconstruction company.
Exact.
And 6 is the bank.
6 is the bank, probably 8 and 9. I'm sorry, respondent.
They are the assignees.
They are the assignees. And
bank.
these are the
Their license of functioning.
yes, still functioning.
And Mr. Sen is instigating you. Yes.
And the
Definitely not.
Charge sheet to put it. Charge sheet.
You are seriously expecting the court will suspend their licenses of operation?
This is what I was saying.
Kindly have you see the facts. I'm giving it just a bare facts. I will just one by one the order. Your losses kindly consider the first, the order at page.
If anybody of the original side is concerned why those matters are not being taken up, let them see who is responsible for that. Yes, yes, Mr. Channel. Yes.
Now your losses kindly consider the two orders, your lordships, page 250 and 256.
Were they even parties there? I mean, how are they? Why should I suspend the license at all? I mean, are they even parties to the fraud?
Yes, that's my case. They are the parties to the
fraud. If it has been assigned to them at the relevant juncture, they were not even in the picture.
But I'm coming to that. I'm also accusing the bank. They are the agent. But they are the agent of the bank.
I'm only on the interim order you asking. You asked for interim order regarding 8 and 9. Why?
8 and 9, your losses.
They were not in the picture even at the relevant point of time.
No, I tell your losses. They are the assignee of the.
Not assignee of a fraud, maybe of a fraudulent act, but not of a fraud.
But when they came to know about it, even they went on insisting on that. It became known to everybody.
How can I seriously press for this interim order?
Ask for cancellation of Punjab National Bank.
Yes,
We should all close our bank accounts now, here and now. Punjab National Bank, UCO Bank,
I'm doing that.
All banks will be closed because a fraudulent person has taken loan and eaten the money.
But
His father had given a guarantee for 50 lakhs. He entered into a settlement. Paid the amount.
Coming to that, how
I don't know. They must go for interim order. Where is the coach time?
I'm not granting that interim order
So
definitely.
for the other interim order, your losses. Everybody should be allowed.
Mr. Channel, let us come back tomorrow.
I will take it.
There is a report from the detective department, Lal Bazar.
Come back tomorrow, Mr.
Yes.
Channel. I don't want to prejudice the original senators. Yes. Very well. What should I record without making it a part?
And just your losses adjourn it for that.
Although the matter was called on for hearing, due to paucity of time, the same could not be concluded. Full stop. Let the matter be listed under the same heading as a motion tomorrow. Fairly at the top of the list. Fairly at the top of fairly at the top pore.
Fairly top 2.
Fairly top, no, 8 or 9 probably.
Well,
There is a supplementary
Like,
may I have your losses?
fairly
May I have a losses leave to file two supplementary affidavit? One.
No, we have not got copies.
If copies come back tomorrow, I'll hear them also on their objection to filing these. I'll take up lock, stock and barrel.
but before Lordship switched over.
This barrel is a different barrel.
Yes. But
Anyway,
the next matter, tomorrow I'll be in Jalpaiguri.
I'll fix it tomorrow fairly, not fairly, at the top. It'll be in Jalpaiguri, you're sure. I'll fix it at the top tomorrow. Definitely. You'll be in Jalpaiguri cannot be a ground.
In High Court. I'm not going beyond High Court.
No.
Which I don't go anywhere except High Court.
You're short circuiting the matter by going to the circuit. Tomorrow, which matter?
Next matter, very next matter.
Item?
28.
28, I am appearing for the state pilot. This is
Had it been CSC is here, WC is here, I could have asked for a report only, nothing more for the time.
পরেরটা তুমি সোমবার করো।
Somewhat. Great.
Adjourn till Monday.
সোমবার
Next matter.
মানডে মান্থলি লিস্ট
Tuesday করে দাও।
গ্রেট
What is on side mentioning? Today's list to be mentioned, item number 1.
Your lordship.
Yes, correction, yes.
Yes, your lordships.
What is the correction? Mr. Mukherjee, everything all right at the home front?
my lord
Better.
better
My lord, I have a,
You have an objection to the correction?
my lord, in this particular regard, my lord, may I respectfully submit on the last occasion, if my lord recalls, when my lord was pleased to pronounce the judgment on that particular day, my lord, we had earnestly prayed for a stay of 3 weeks for my lord's judgment because of.
No, let me hear what the correction is.
Corrections are suggested, my lord, in
Please, yes.
Also handing up suggested.
Can you give me the page numbers, please?
Yes, certainly, my lord. Let's kindly come to page 10 and 11, my lords.
Right.
My lord, my senior is appearing online.
Your lordships, may I?
Yes, I've seen you, yes.
Yes,
Page-
your lordships, it's para 41. Your lordships, on line 4 at para 41, it says communication dated June 27, 2017. That
Okay.
was RC1, your lordships.
Yes, I'll just check it.
Yes.
Yes.
Yes, your lordship, it should have been RC2, that is
Right.
December 24, 2021, that is P11, annexure P11, page 260, your lordships.
Yes,
That-
yes.
Yes, so that's the first correction, your lordships. There is one more very inadvertent typographical error. Your lordships, a para 42 of the order, line 3.
42.
Yes, your lordships, line 3. It
Right.
says from October 1, 2013. That is the date of notification of the WASIS 2013. Your lordship, we started our plant in July 2019. So therefore, maybe that can be rectified to from July 2019, and that is the date of notification can be deleted, because that is the date from which I am seeking the refund.
The notification says from when you have started. Let us once just see the notification on that.
Yes, your lordships.
Yes.
It starts at page 48, your lordships.
Right, right, yes.
Yes.
Anything has been stipulated regarding from when?
Yes, your lordships. If your lordships may just give me a name, because before that I was not even manufacturing. So it is from the date of registration when I can seek the exemption.
Oh, your date of registration was this, July 20, from
No.
July 29.
July
Yes.
2019, I started my production, your lordship. So that therefore from that date, because before that I was not producing, right? So there was no levy itself, therefore not seeking that refund.
Yes, Mr. Mukherjee, what do you say to this?
My lord, my respectful submission is that on the last occasion, my lord, we were praying for a stay because of the situation. If an appeal is being preferred from this particular judgment and order.
On this correction, what do you?
Well, on the correction, I don't have any issues, my lord, on that.
Yes, what about the stay? Yes.
My lord was pleased to grant 3 weeks time for so that my lord, the parties can, my lord, pray for an appeal before the order. My lord, if that is retained by my lord, then my lord, we are in the process of filing an appeal. My lord, another my lord's very small my lord correction was subject to my lord's kind consideration is that paragraph 42 of the judgment at page 10, my lord. My lord, in paragraph 42, page 10, if my lord kindly takes, insofar as the benefits which have already accrued to the petitioner, but have been withheld by DVC. My lord, if my lord subject to my lord's kind consideration, if my lord kindly adds after but, if any, my lord, because my instruction is that DVC has, pursuant to the Electricity Duty Act, my lord, DVC is statutorily bound to transfer all the amounts collected on ground of electricity duty to the Directorate of Electricity Duty, Government of West Bengal. So, my lord, if any is added,
before have, but if any have been withheld by DVC from the petitioner and not paid by
No, Mr.
DVC.
Mukherjee, I'll not put that in. That will create further complications. We take that point in appeal.
Yes. Your Lordship, one more submission, Your Lordships, if Your Lordships may consider, DVC on the last occasion when that order was pronounced had requested for stay on the refund and not on the waiver part of it, Your Lordships, but the portion which reads, it's a complete stay, Your Lordships. So therefore, we were requesting for the clarity because the bill for the month of July will be issued soon, Your Lordships.
My lord, humbly.
No, let this
Yeah,
remain.
deeply obliged, my lord, deeply obliged.
Learned counsel for the petitioner contends that certain corrections are required to be incorporated in the order dated in the judgment and order dated July 27, 2023. Full stop. Since learned counsel for the petitioner is justified in making such contentions, comma, let the following corrections be deemed to be incorporated in the judgment and order dated July 27, 2023, colon, next para, in paragraph 41 of the said judgment, comma, the phrase within double inverted July 27, comma, 2017, within bracket being annexure P-4 at page 134 of the present writ petition, bracket closed, double inverted close, be read as our double inverted open quote, December 24, 2021, within bracket being annexure P-11 at page 260 of the present writ petition, bracket closed, double inverted closed, full stop. Next para. In paragraph 42 of the said judgment dated July 27, 2023, comma, the phrase within double inverted October 1, 2013, comma, that is, comma, the date of notification of the WBSSIS, comma, 2013, comma, double inverted close, be read as within double inverted July, comma, 2019, double inverted close. Full stop. Next para. Let this be this order be deemed to stand corrected, incorporated in the order dated July 27, 2023 for the purpose of granting certified copies. Full stop. Next para. However, comma, the other prayers made by learned counsel for the parties would tantamount to a modification of the order and, comma, hence are not gone into at this stage, are not gone into, full stop, this much. Since the writ petition has already been disposed of previously, comma, no further order need be passed on such score. Thank you.
Obliged.
ওটা দেখি করেছি তো
Code application under Article 226, item number 2.
My lord, Mr. Shuddha Sattva Banerjee was addressing your lordship, my lord, in this matter. He's unwell, he's not come to court. My lord, he is requested if you lordship can kindly fix the matter on Tuesday.
On the prayer of the petitioner, the matter is adjourned till August 8th, 2020.
Grateful.
Grateful, man.
Appearance. Item number 3.
My lord, I beg to appear on behalf of the petitioner.
Lordship, I'm appearing for the corporation.
My lord, on the last occasion, my lord was pleased to pass an order on 24th of July.
Yes.
My lord has recorded, my lord, the 10% the security deposit pursuant to a tender been floated, but that has been paid after I completed my work. And 10% was regarding to default liability, defect liability. And that 10% has to be retained by the respondent corporation incorporated in the tender document itself for a period of 6 months interest free. Now, once the 10% has been given, but there doesn't remain any defect as per them. 10% they have given, but the balance 90%
to the bill which I have raised after.
What is your instruction? You have to take instructions?
Yes.
Your Lordship, we have sent a letter to the corporation to send us the details of the payments and whatever the payments have been made, because the petitioner has not disclosed whatever security deposit that has been claimed, that has
You
been
have
paid.
your records. You have those in your records.
Your Lordship, the corporation, the instruction that we have received is that the
You are the corporation. You
yes,
were happy. Yes.
yes, Your Lordship, the audit is going on, so they need 3 weeks time to formulate whatever payment
Madam,
has
it's
been
a-
made. Your Lordship, if I may.
2019 final bill have been raised. We are in 2023. Tender document I have shown.
I'll dispose of the
Your Lordship,
requisition. I'll
if I
direct
may-
you to pay the amount. Do that
Lordship,
after 3 weeks.
If I may draw Your Lordship's attention to the page number 31, Your Lordship, of the writ petition.
Yes.
Your Lordship, here the petitioner has annexed 2 bills for the same tender number, and one bill has been raised for with the tender being still in progress. The tender was not completed. The tender was
Very well. After 3 weeks, come prepared with the discrepancies as per you regarding this, and we'll sort out the amount payable by. On principle, are you disputing the proposition that 90% has to be paid to them?
No, Your Lordship, we are not disputing that.
Can I record that? I'll record that in principle you are not objecting to payment of the 90%, but you say that
Yes,
there are
Your
certain discrepancies in the bills annexed.
Yes, Your Lordship.
You will take your instructions on that and
Yes,
come back with a written
Yes,
note
Your
sheet.
Lordship. Yes, Your
Very well, fair enough. Learned counsel for the which respondent?
Your Lordship, respondent number.
MD have
4 onwards.
Your Lordship, 2,
3 onwards.
4,
2 onwards.
2 onwards, Your Lordship.
2 to 5.
2 to 6, Your Lordship.
Very well. Learned counsel for
7.
it is submitted by learned counsel for the respondent numbers 2 to 7. Probably.
Yes, Your Lordship.
2 to 7 that further instructions are required on the issue as to whether the said respondents are agreeable to pay the entire amount as disclosed by the petitioners in the writ petition. For so it is submitted that apparently there are certain discrepancies in the bills annexed by the writ petitioners to the present writ petition. Footstep, however, comma, learned counsel appearing for the said respondents, comma, in her usual fairness and on instruction, comma, submits that the said respondents do not have any objection in principle to disburse the balance 90% of the amount payable to the petitioner. Footstep, next para. Since it is contended on behalf of the respondent numbers 2 to 7 that due to the ongoing audits, comma, the said respondents could not arrive at a written breakup of the discrepancies which in their perception appear in the bills raised by the petitioner, comma, the matter is adjourned and shall next be listed on August 28, 2023, fairly at the top of the list, comma, when the respondent numbers 2 to 7 shall file a written breakup of the dues payable by the said respondents to the petitioner as per the said respondents. Full stop. An advance copy of the said written breakup shall also be handed over to the learned advocate for the petitioner prior to filing of the same to enable the latter to take appropriate instructions on the issue. Come back on 28th after 3 weeks, but please give a sufficiently advance copy to him so that he can take instructions.
Grateful to yours. Much obliged.
Thank you.
For hearing, item number 4. Pathat.
Yes, Mr. Thakur.
This is that matter where pursuant to amalgamation, the writ petitioner came to acquire the leasehold premises, my lord.
Yes.
This matter your lordship had heard on the last occasion, where the fee was, my lord, the normal fee is 10,000, and because I did not give notice prior to obtaining the order of amalgamation.
Mr. Thakur, can you come ready with short written notes of arguments? You are ready.
I'll come ready with the note of arguments.
Yes.
I've prepared a list of dates, my lord, uncontroversial list of dates,
Very good.
which would just show the sequence of how because there was a prior writ petition, which your lordship recollects, traveled up to the Supreme Court.
Right.
So I've given the dates here, my lord, with the orders which are there. And where the documents are already part of the writ petition, my lord, I've made mention of the page.
Thank you, sir.
I'll prepare a 1-2 page note of arguments also, my lord.
Please do that and come prepared. I'll put it in my order and come prepared on that.
Please.
I'll
Your lordship was
give
here.
another notice to the other side.
No,
We are happy for that.
I'm being led by Mr. Kaur, my lord. I'm praying for not today.
No, no.
He's addressing your lordship, my lord.
So come prepared with your written notes of arguments. Also, how soon can you do that? He can do it tomorrow.
And tomorrow then.
You won't be able to prepare a written notes. You have to have a conference.
It's more or less, we know what is to be argued. Mr. Kaur is
Very
here,
well.
my
Then
lord.
I'll put it tomorrow.
Tomorrow lordship can put it.
Tomorrow, but it will be fairly at the top of the original side list because it's only on notes of argument.
I've handed over a list of dates to my learned.
Thank you. Please come prepared with the written
Yes,
notes of
yes,
argument. Learned, the list of dates handed over by learned counsel for the petitioners today be kept on record. First up, learned counsel for both the sides are requested to come prepared with their written notes of arguments tomorrow when the matter shall next be listed under the same heading.
Grateful, my lord.
Thank you.
Deeply obliged.
Item number 5,
Yes, Mr. Ghosh.
Part
For the petitioner,
Yes.
Mr. Kaur, I believe, had completed his submissions with regard to that, well, the enhancement of rent matter. Yes, sir. But,
This is regarding that Blackburn Road rent enhancement on renewal and all. Very
my lord, Mr. Kaur has, my lord, argued, which I have, my lord, more or less summarized in, my lord. He has first argued, my lord, that a contract renewal is only valid when it is documented and does not stand validated if there is no executed document, especially in case of renewal of lease. He has cited 2015 8 SCC 655, paragraphs 34, 35, 31, 34, 35, and 37 for this purpose. But kindly takes 2015 8 SCC 655. Achha. But kindly takes paragraph 31. My lord, hopefully your lordship has a marked copy, my lord.
Yes.
But otherwise I have.
No.
But paragraph 31, if I may please.
31, yes.
Indisputably, the renewal of lease is a fresh grant where the principal lease executed between the parties containing a clause that the lease shall have to be renewed by giving a fresh grant in accordance with the said clause. In the instant case, as per clause 16A of the earlier lease deed, the lease is to be renewed for a further period of 30 years, but subject to the rules and terms and conditions of the lease, and also such other terms and conditions as the state government may from time to time consider it necessary to impose and include in such renewed lease. Clause 16A further provides that additional terms and conditions that may be considered necessary by the state government be included, but the same shall not be inconsistent with the law renewing such lease and shall not have retrospective effect. Thereafter, he has cited paragraph 34, which is most important, where Lalji Tandon's case has been quoted.
Yes.
Now, this is where I will join issue. In state of UP versus Lalji Tandon, this court, while considering the renewal clause in the lease deed, observed, in India, a lease may be in perpetuity. Neither in the Transfer of Property Act nor in the general law abhors a lease in perpetuity. Mullah is quoted, where a covenant for renewal exists. Its exercise is, of course, a unilateral act of the lessee, and the consent of the lessor is unnecessary. Where the principal lease executed between the parties containing a covenant for renewal is renewed in accordance with the said covenant, whether the renewed lease shall also contain similar clause for renewal depends on the facts and circumstances of each case. Regard being had to the intention of the parties as displayed in the original covenant for renewal and the surrounding circumstances. Not stopping here for a moment. That is not our case. It is not our case, nobody's case, that whether the new lease, the renewed lease will have a further extension clause or not, that is not our case. Kindly read on. There is a difference between the extension of lease in accordance with the covenant in that regard contained in the principal lease and renewal of lease, again in accordance with the covenant for renewal contained in the original lease. Ours is a case of renewal, not extension. Now, in case of extension, it is not necessary to have a fresh deed of lease executed, as the extension of lease for the term agreed upon shall be necessary consequence of the clause for extension. However, this is very important. This is the last 3 lines I'm relying upon of Lalji Tandon, which is cited by my learned friend. However, option for renewal consistently with the covenant for renewal has to be exercised consistently with the terms thereof. And if exercised, a fresh deed of lease shall have to be executed between the parties. Failing the execution of a fresh deed of lease, another lease for a fixed term shall not come into existence, though the principal lease, in spite of the expiry of the term thereof, may continue by holding over for year by year or month by month, as the case may be. Now, let us come. This is all that is there to this judgment. And he says, look, this is a case of renewal, not of an extension. Renewal clause was there. The lessee has exercised his option in terms of the renewal, but no lease deed has been executed. We are not joining issue there. Yes, no lease deed has been executed. But I join issue on the last 2 lines of Lalji Tandon, which I have also got to myself. Your Lordship also knows that even if the lease is not executed, but my option is exercised, and my lord, the lessor accepts rent, the lessee continues in terms of the earlier lease by holding over. And in fact, I am in a better case on these facts because A, I exercised the option. B, he accepted the option. And kindly see page, only one document, my lord. Page, my lord, 71 of the writ petition, which is a document of 17th May 2018. I'm just reading, my lord. This is to inform you that the Board of Directors of this corporation in its 355th meeting held on 20th March 2018 has agreed to allow you to renew 3716 square feet building space, first floor, for the further term of long term. No short term lease will be allowed. So not only did I exercise my option of renewal, they have in fact accepted it by way of a specific document dated 17th May 2018. And my lord, in reply, I have annexed from page 101 onwards that after the expiry of the lease in 2018 till date, they are accepting rent, mentioning me as the lessee, and my lord will recall also giving me rebate in terms of clause of the lease. Not without prejudice. No letter that this is without prejudice, acceptance is without prejudice, or anything of that sort, preserving their right. They accept my renewal, they give me a letter, they accept rent, indicating me as the lessee, even giving me rebate under the terms of the old lease. So in terms of Lalji Tandon, my lord, have a right to continue. And the lease stands extended, despite a registered deed not being executed. And in fact, my learned friend's case helps me. My lord, Lalji Tandon, my lord, I don't want to cite any judgments in reply. Your lordship knows I just quoted from that. It quotes the exact line.
Stimulus is to cite Lalji Tandon.
No, the stimulus from the right.
No.
That's why I filtered it. I don't want to complicate things because so my lord, that is the first point he has argued. Then Mr. Kaur has argued, my lord, that he has cited 3 judgments, my lord, where in essence, my lord, what I have understood is, my lord, that these contractual matters, in contractual matters, court should loathe to, my lord, interfere in these kind of matters, specifically rents and these kind of matters, and no writ is maintainable. 3 judgments he has cited. First, kindly takes up 2009, 14 SCC, page 451.
Yes.
My lord, he has cited 2009, 14 SCC, page 451. Para 13, 14, 15, and 16.
So probably 30, 31 were also said. Because
30, 31 of 2009, 14 SCC, 451.
9, 14. But I don't know if I have.
Very well, my lord. I
said might have marked. So that also.
I should, paragraph
14, yes.
13, 14, 15, 16. And my lord, 39, your lordship says. Kindly sees 13, 14, 15, and 16, my lord, first. This is cited by Mr. Kaur. The appellant submit, paragraph 13, my lord, if I may quote.
13, yes.
The appellant submits that the parties are entered into 3 lease agreements dated such and such, such and such, and such and such in regard to periods such and such, such and such, such and such. And all the 3 agreements contain an arbitration clause. Clause 17, providing that any dispute or difference arising between the parties concerning the subject matter of the lease agreements or any covenants, clause or things contained therein otherwise arising out of the shall be referred to an arbitrator to be appointed by the government of India. Then paragraph 40, a careful reading of the arbitration clause in this lease agreement discloses that what is referable to arbitration is any dispute or difference concerning the subject matter of the said 3 lease agreements or any clause thereof or any matter arising out of the
No,
lease
probably not this, Mr.
agreement. My lord,
Not this. I mean, he cited 30,
I know,
31.
no, but this is
Arbitration is neither here nor there.
So I am citing 13, 14, 15, 16 to show what was the occasion for the court to go into that. Then, my lord, it goes on to a recommendation by a body. That's what Mr. Kaur has cited possibly, which your lordship is referring to. I'm trying to distinguish the judgment that this is what was being decided by the Supreme Court. And then, my lord, kindly see paragraph 15, the grievance of the respondent put forward in the writ petition is as under. On such and such, the respondent requested the appellant to fix the rent for a period of 5 years with effect from such and such by referring the matter to hiring committee. The appellant accordingly referred the matter to the hiring committee by letter dated such and such. The hiring committee.
Questions have been formulated in para 12.
Yes.
So
These
are different questions.
really, whether the hiring now, but for my satisfaction, my lord, kindly takes that paragraph which your lordship was referring to and which Mr. Kaur probably has cited.
Yes, yes.
Paragraph 39.
30,
39.
31 and 39. These
Very
three.
well. 30, 31 and 39. I'll
Right.
place all those. My lord, 31.
Yes.
Where a statute governing tenancies and or rent provides for fixation of rent or increase in rent, and such statute is applicable to the tenancy in question, then the rent will have to be determined in accordance with the statutory provisions. But I stop here for a moment. The rent is much above the 10,000 limit of the Premises Tenancy Act, so it will not be covered. Yes. So Transfer of Property Act is silent. So this also does not apply. But kindly comes to paragraph 32, the assessment of
31, if the lease period expires and the parties are not able to agree upon the increase in rent, it is
Only-
open to the landlord.
Yes, then the rent will be determined according to the statutory provisions. Now there is no statutory provision.
That is the first sentence. There are other
Subject
sentences
to the above, any increase can only be by the consent of the parties.
after that. The next
If the
sentence
lease
was-
period expires and the parties are not able to agree upon the increase of rent or terms of renewal, it is open to the landlord to initiate action for evicting the tenant. Who is having any proposition? Don't have any quarrel with this proposition. He may have his, but I will come to the portion where I will join issue. I'll come to that portion. But under this notion, can the landlord require the tenant to pay during the period of a lease a rent higher than what is agreed between them or what is provided for in the statute? Unfortunately, there is no statute in this case.
No. Let us come straight away to the 39.
39.
Yes.
We are therefore of the considered view that in the absence of express contract agreeing to be bound by the recommendations of rent by the hiring committee, his recommendations are neither binding on the hiring department nor on the lessors. Rabindranath Nandi, to the extent it holds to the contrary, in our considered view, is not good law. Well, this is neither here nor there. I'm not saying that. Rather, I'm saying that the recommendation that the board has got from the valuers report appointed by the board should not be taken into consideration. Well, this goes, my lord. Then there is my Mr. Kaur has cited, my lord, 2020 17 SCC, page, my lord, 145.
Yes.
Paragraphs, my lord, he has cited here, if I'm not wrong, is 24, 26, 29, and 33. If I'm not wrong. 24, 26, 29, and 33. 24, my lord, straight away comes to.
Yes.
My lord, the expression premises is defined under section 2C of the Act. Therefore, this is regarding 1997 Act. Therefore, premises can be governed as government. No, I'm sorry. This is under the this, my lord, West Bengal Government Premises Tenancy Regulation Act 1976. My lord, there is no quarrel with the proposition of tenancy here, premises here. My lord, 26 is government premises, whether it's subtracted or not. I don't think that is a question here at all. Paragraph 29, my lord. Thus, when the eviction proceedings were initiated, admittedly, the land in question did not contain any structures.
Probably, Mr. Kaur was submitting something on that they are entitled to evict you under government.
No, I'm not.
That is,
I'm
in
not
fact, I have
joining
not,
issue there.
I have not marked any of the paragraphs here. I don't see any marking here. But it was cited undoubtedly.
I know. That's why it's my duty, my lord, to point out that this is, my lord, I do not find any application in this case, my lord. Then, my lord, kindly, my lord, come to the other judgment Mr. Kaur has cited is that of, my lord. Yes, sir. My lord, 2015 7 SCC, page 728.
Yes.
Now, my lord, before I, my lord, seek to distinguish this, my lord, my lord, quick recapitulation, because this is very important while distinguishing this judgment. My lord recalls at the outset when I was, my lord, I opened my submissions, my lord, I had pointed out to your lordship the object of the respondent number 1 and 2. Kindly, my lord, comes once. I'm sorry, my lord, I have to tell you, lordship, because there's been some gap. My lord, kindly come to page 40 of the writ petition.
40.
It will immediately come back to your lordship when I show you the document. Page 40. This is from their official website of the respondent number 2. Kindly see, the West Bengal Small Industries Development Corporation, WBSIDCL, was established in the year 1961 under the aegis of micro, small, medium enterprises and textiles, such and such. Now, the sole objective of promotion and growth of micro, small, and medium enterprises throughout the state by providing infrastructure and also by extending marketing support to the MSMEs having low investment capacities but high potentiality in respect of employment generation. Thus, over the years, WBSIDCL has been grown as a trusted friend and guide to MSMEs. Now, kindly come to the last paragraph. During the years, WBSIDCL has developed 51 number of industrial and commercial estates widely scattered all over the state. All the estates have been developed in prime location, wherein land and sheds for setting up of the industries are allotted at a subsidized rates with all modern facilities. This is what is important. Then, my lord, page 41, to promote mission is to promote micro, small, medium enterprises by way of land allotment, infrastructure, consultancy services. And page 42.
Yes.
Developed in prime location, land and sheds for setting up of industries are allocated at subsidized rates with all modern infrastructural facilities is probably a repetition. This has helped a large number of MSMEs towards industrial growth as well as generated extensive employment. So this is the objective with which the respondent number 2 has been established. Now, coupled with this, kindly takes our reply once. One very important letter, page 98. I am not the sole crusader in this battle. Kindly come to page 98 of my reply. The Shilpo Bhavan Furniture Dealers Association, there's an association with number of tenants who are occupying this building. Kindly see what they write to the managing director. After this, my lord, the very self-same, my lord, circular which I have challenged in the writ petition was issued. Kindly see, my lord. Monthly tenancy of shops at Shilpo Bhavan complex. Reference board of director meeting dated 22nd July. This is what I have challenged. An alleged circular of 18th August. We are small traders and legally occupying shops in Shilpo Bhavan pursuant to auction and being the highest bidders and having set security deposit and paying monthly rent. Thereafter, since inception, without any default or dispute whatsoever for last so many years. Our and our family's livelihood depends on business generated from our aforesaid shops. We were deeply anguished, surprised, and shocked when we came across your alleged circular dated 18th August 2022, which seems to have been issued and circulated in November-December 2022. We hereby jointly and severally object to the issuance of the alleged circular, which is bad in law, devoid of merits, whimsical, arbitrary, unjustified, unreasonable, untenable in law, and same is also without any basis. Unnatural justice, cause mental agony, stress, harassment to all the shop owners. Amounts to deficiency of service and unfair trade practice. We request you to immediately withdraw the same, or we'll have no option but to bring your inefficiency, high-handedness, and whimsical approach to the knowledge of higher authorities and learned High Court, and hold you liable for damages. We assert our rights as monthly tenant who are legally occupying the shops and legally doing business and earning our livelihood. This is not our place to mention that you are taking any steps against illegal occupant and unauthorized madrasa being run from the premises, but harassing tenants who are paying their rent without any default. Now, kindly see the next paragraph. We could not figure out the logic and reason behind 800% increase in rent and demanding outstanding dues for the months for which we have already paid rent and received receipts. We put on record that we've already paid security deposit at the time of allotment of shops. Your demand for outstanding dues in respect of monthly rent already paid and receipt granted, an 800% increase in rent is absurd, exorbitant, whimsical, arbitrary, devoid of any reason or logic. Without prejudice, we request you to provide us copy of original agreement, statement of account since inception, and let us know about the security deposit. Please let us know the reason, logic, rational basis behind this whimsical, irrational, excessive, unlawful, one-sided demand, and who is responsible for edit circular dated such and such, so that we can take appropriate steps in the matter. So not only me, the entire tenants association has objected to this. It's not that I am the only rogue one out. So this
One
letter,
adjective for each of the members, probably.
no, nobody wants to take up come against this kind of a formidable respondent. Nobody comes and find to lend their name against a writ petition. They said we'll all watch from the fringe. We'll sit on the fence and see. But this is very important. It's not that I am the lone crusader or a rogue tenant which is trying to extract something.
Yes.
Everybody has objected, and this is against your object. Now, kindly takes in this backdrop, 2015 7 SSC page 7 to 8. Paragraphs, Mr. Kaur has cited, in all fairness, 51, 56, 61, 62, 69, 70, and 70.6. But I'll only try to distinguish. Really, the ratio is from 69 onwards, my lord. Your lordship takes it, my lord. Because before that, it is really, my lord, citing of other decisions.
Yes, please.
Paragraph 69. The position thus summarized in the aforesaid principle has to be understood in the context of discussion that preceded, which we have pointed out above. As per this, no doubt there is no absolute bar to the maintainability of the writ petition, even in contractual matters or where there are disputed questions of fact, or even when monetary claim is raised. But let I stop here for a moment. That is his sheet anchor of his argument. This is a contractual matter. There are disputed questions of fact. Your lordship will not entertain. Paragraph 69 itself lays it bare that this differs from case to case and there is no absolute bar. Then, my lord, it's interesting. But at the same time, discretion lies with the High Court, which under certain circumstances, it can refuse to exercise. It also follows that under the following circumstances, normally the court would not exercise such a discretion. Then, my lord, kindly come to the court may not examine the issue unless the action has some public law character attached to it. Wherever a particular mode of settlement dispute is provided in the contract, the High Court would refuse to exercise its discretion under 226 of the Constitution and relegate the party to the said mode of settlement, particularly when the settlement of dispute is to be resorted to through means of arbitration. If there are very serious disputed questions of fact which are of complex nature and require oral evidence for their determination, money claims per se, particularly arising out of contractual obligations, are normally not to be entertained except in exceptional circumstances. Further, the legal position which emerges from various judgments of this court dealing with different situations, aspects relating to contracts entered into by state public authority with private parties can be summarized as under. Then, at the stage of entering into a contract, the state acts purely in its executive capacity and is bound by the obligations of fairness. State in its executive capacity, even in the contractual field, is under obligation to act fairly and cannot practice some discriminations. 3. Even in case where questions is of choice of consideration of competing claims before entering into the field of contract, facts have to be investigated and found before the question of a violation of Article 14 of Constitution could arise. If those facts are disputed and require assessment of evidence, the correctness of which can only be tested satisfactorily by taking detailed evidence involving examination and cross-examination of witnesses, the case could not be conveniently or satisfactorily decided in proceedings under 226. Writ jurisdiction of the High Court under 226 of the Constitution was not intended to facilitate avoidance of obligation voluntarily incurred. 70.5. Writ petition was not maintainable to avoid contractual obligations, occurrence of commercial difficulties, inconvenience, or hardship in performance of the conditions agreed to in the contract, can provide no justification in not complying with the terms of the contract, which the parties has accepted with open eyes. It cannot ever be that a license can work out the licensee if he finds it profitable to do so, and he can challenge the conditions under which he agreed to take the license. if he finds it commercially inexpedient to conduct his business. Now 70.6, ordinarily where a breach of contract is complained of, the party complaining of such breach may sue for specific performance of the contract if contract is capable of being specifically performed. Then writ can be issued where there is executive action unsupported by law, or even in respect of a corporation, there is a denial of equality before law and equal protection law, or if it can be shown that action of public authorities was without giving any hearing and violation of principles of natural justice after holding, then action could not have been taken without observing principles of natural justice. If the contract between the party and the state instrumentality or agency of the state is under the realm of private law and there is no element of public law, the normal course for the aggrieved party is to invoke the remedies provided under ordinary civil law rather than approaching the High Court under Article 226 of the Constitution. The distinction between public law and private law element in the contract and the state is getting blurred. However, it has been totally obliterated. It has not been totally obliterated. And where the matter falls purely in the private field of contract, this court has maintained the position that writ petition is not maintainable. The dichotomy between public law and private law rights and remedies would depend on the factual matrix of each case, and the distinction between public law remedies and private law field cannot be demarcated with precision. In fact, each case has to be examined on the facts whether the contractual relations between the parties bear insignia of public element. Once on the facts of a particular case it is found the nature of activity or controversy involves public law element, then the matter can be examined by the High Court in writ petitions under 226 of the Constitution of India to see whether action of the state or instrumentality or agency of the state is fair, just and equitable, or the relevant factors are taken into consideration, relevant factors have not gone into the decision-making process, or that the decision is not arbitrary.
So you say public law because they are the small scale industries and the
Tenants
objects
Association
also.
letter. And that letter, that not only me, I'm not a rogue tenant. The entire association is objecting that. And my lord, the entire decision says 3 or 4 things in my respectful submission and understanding. One, it is not even contractual matters, it is not an absolute bar. It depends from facts of the case. Here there was an arbitration clause. That's why court has said alternative remedy is already there, which you have agreed under the contract. Why should I allow a discretionary remedy under 226 to be exercised? That was one of the grounds for no arbitration clause, no alternative remedy provided in this lease. And particularly so, kindly bears with me, it is not that I am complaining of any breach under the terms of the lease. Then possibly I could have gone and approached civil court. I am saying they have accepted my extension, but the amount of rent which they are proposing, which has nothing to do with contract. It's as your lordship has said, seen that clause is upon mutual agreement and consideration. Now, in that mutual agreement and consideration, even if I take that nothing is there in the contract, either in the terms of the lease or that allotment letter, then my lord, there is a void as to how a state has to act in proposing terms. And if there is a void, the state has to act as a model litigant with fairness and without being a Shylock, trying to get its pound of flesh as well. And if that is arbitrary, in these facts of case, your lordship has the jurisdiction to enter and, my lord, look into the matter. My lord, so this judgment also, my lord, in effect, my lord, helps me. Now, my lord, stopping here for a moment, I may be wrong, my lord. I was not there. I'm tendering my apology. But my lord, and my learned friends are also here, I don't think Mr. Kaur has distinguished any of the judgments, 3 judgments that I have cited. Subject to correction, my lord, I have cited, my lord, 1997 7 SSC, page 89. My lord, may I give your lordship a copy? I think I only given your lordship the bounded volume at that point of time. I'm giving a copy. 1997 7 SSC, page 89, paragraph 9, 10, and 11. Kindly consider it once. De Baba. 9, 10, and 11, my lord. There is, my lord, if I may.
So were they cited by you at the?
Yes. My lord, I just didn't give you a copy. I'm giving you a copy now.
Yes.
Lord, kindly see what this say. And these 3 judgments, my lord, 1999 7 SCC, page 89, 1975, 1 SCC, page 70, and my lord, 1989, 3 SCC, page 293.
Right.
These are the three decisions I had cited while making my.
Lalji Tandon had actually been cited by you at some stage of the matter.
Yes, before at the time, my lord, when I was addressing your my lord Justice Moushumi Bhattacharya.
Yes, yes, yes.
Yes,
Yes.
that was cited.
Anyway,
Now, my lord, if that is so, with the deepest of respect, my learned senior friend does not distinguish any one of them. Kindly see what, just my lord, just for brief recapitulation, what these say. Now, kindly takes 1999 7 SCC, page 89, my lord, paragraph 9, 10, and 11. Nine, my lord.
Yes.
Says there is no dispute that the capital of Punjab Development and Regulation Act 1952, being Punjab Act of such 1952, is applicable to the city of Chandigarh. The act was enacted at the time when the construction of a new capital of the term such and such. It was considered necessary to vest the state government with a legal authority to regulate the sale of building sites and to promulgate building rules on the lines of municipal bylaws, so long as a properly constituted local body did not make over the administration of the city. Section 3 is then quoted. My lord kindly skips over, and my lord kindly come to my lord paragraph 10.
Yes.
In the absence of the rules, the action of the respondents regarding imposition of terms and conditions of the lease, including the enhancement of rent, is required to be fair and reasonable and not actuated by consideration which could have been termed as arbitrary or discriminatory. The government cannot act like a private individual in imposing the conditions solely with the object of extracting profits from its lessees. Governmental actions are required to be based on standards which are not arbitrary and unauthorized. This quote in Ramanna Dayaram Shetty, Ramanna Dayaram Shetty is quoted. Then, my lord, the same point was made over by this quote in Irrigation Equipment and Chemical versus State of West Bengal, where the question was whether a blacklisting of a person without giving him an opportunity. This is also not very important, my lord. My lord, this is not very important. Well, kindly come to paragraph 11. Even the administrative orders are not only quasi-judicial orders are required to be made in a manner in consonance with the rules of natural justice when they affect the rights of the citizens to the property or the attributes of the property. While exercising the powers of judicial review, the court can look into the reasons given by the government in support of its action, but cannot substitute its own reasons. The court can strike down an executive order if it finds that the reasons assigning were irrelevant and extraneous. The courts are more concerned with the decision-making process than the decision itself.
10 is the most relevant.
10 and 11, my lord, also.
11, this is not exactly an executive order.
No, my lord, the board,
decision-making.
my lord,
Oh, yes.
what has happened, the board has approved
Right,
it.
right.
That's why I'm saying.
Yes.
And even if your lordship does not mention a particular rent, my lord, your lordship can strike it down and send it back for reconsideration. But this has not been distinguished. No my lord, arguments have been forwarded on this. Then, my lord, the next is 1975, 1 SSC, page 70. This is the Eurasian equipment's case, my lord. Kindly give me 1 moment's time, my lord.
Fair and equal treatment, para 19.
Yes, my lord.
But this was blacklisting.
Yes, that's why your lordship said don't cite it, so I have not.
Anyway, I formally have cited it.
Yes. Now the last one, most important, 1989 3 SCC 293. This is the most relevant, my lord. This is where exactly the same issue was before with regard to the port trust. But kindly see what has been, my lord, held. Paragraph below. But kindly allows me my
17, 21, 23, 24, 27.
37 होने का क्या मतलब kindly. Lord, my lord,
you can start from 17, sir.
17, my lord, yes.
Because you cited only this part. 17, 21, 24, and 27 are actually very vital. Yes.
Yes. 17, right? Therefore follows that public authorities which enjoy this benefit without being hidebound by the requirements of the Rent Act must act for public benefit. Hence, to that extent, this is exactly joining back to my point. There is no legislation which is governing this. Hence, to that extent, this is liable to be gone into and can be the subject matter of adjudication. Then, my lord,
21, the second sentence, being a public body.
yes, we are unable to accept the seven being a public body, even in respect of his dealing with his tenant. It must act in public interest, and an infraction of that duty is amenable to examination either in civil court or in writ jurisdiction. Then, my lord, Radhakrishnan has been quoted.
Yes.
Then 24, the field of letting and eviction of tenants is normally governed by the Rent Act. The Port Trust is statutorily exempted from the operations of the Rent Act on the basis of public governmental character. The legislative assumption of expectation, as noted in the observation of Chagla, Chief Justice Chagla in Ram Pratap Jayadal's case, cannot make such conduct of a matter of contract pure and simple. These corporations must act in accordance with certain constitutional conscience.
This
and
is your
yes, constitutional conscience, and whether they have so acted must be discernible from the conduct of such corporation. In this connection, reference may be made to the observations made in this court in Somprakash Rekhi versus Union of India. It is dangerous to exonerate corporations from the need to have constitutional conscience, and so that the interpretation language permitting, which makes governmental agencies whatever their amenable constitutional limitations must be adopted by this court as against the alternative of permitting them to flourish as an imperium in imperio.
27 is also a very good paragraph for your proposition.
Yes.
27. You cited that also. Yes.
Yes. We are inclined to accept the submissions that every activity of a public authority, especially in the background of the assumption on which such authority enjoys immunity from the rigors of the Rent Act, must be informed by reason and guided by the public interest. All exercise of discretion of power by public authorities as a respondent in respect of dealing with tenants in respect of which they have been treated separately and distinctly from other landlords on the assumption that they would not act as private landlord, but must be judged by that standard. If a governmental policy or action, even in contractual matters, fails to satisfy the test of reasonableness, it would be unconstitutional. See the observations by this court in Kasturilal Lakshmi Reddy versus R.D. Shetty. Then, my lord, kindly see paragraph 37. As we look upon the facts of this case, there was an implied obligation in respect of dealings with the tenants, occupants of the Port Trust Authority to act in public interest purpose. That requirement is fulfilled if it is demonstrated that the Port Trust authorities have acted in pursuance of a policy which is referable to public purpose. Once that norm is established, whether that policy is the best policy or whether another policy was possible is not relevant for consideration. It is therefore not necessary for our present purposes to dwell on the question whether the obligation of the Port Trust authorities to act in pursuance of a public purpose was a public law purpose or a private law purpose. Under the constitutional scheme of this country, the Port Trust authorities were required by relevant law to act in pursuance of public purpose. We are satisfied that they have proceeded to so act. Then, my lord, it goes on to the facts of the case. Now, if these are to be looked, these are the salutary provisions which one has to, my lord, be guided when a public authority is to be guided by. In particularly so, there is no statute. There is no contract between the parties as to what would be the rent. But there has to be a policy in place. Merely by getting a, my lord, a tailor-made report from a valuer and the board blindly accepting it and proposing a 800% increase in the rent, where your objective is to be a friend of small-time investors and to give them very affordable infrastructure in, my lord, very high rented or high income places in the city.
Do you have any idea when you entered in as a lessee in this matter?
Yes.
First,
my lord, that letter of allotment.
give me the date. Yes.
My
The
lord,
year at least.
Yes, my lord. That is there, my lord, at, my lord, September 2, 2003, page 43.
Great.
September 2003. And there, my lord, will recall, there is clause 7, which says, my lord, clause, my lord, 11, which says, my lord, that, sorry, not clause 11, 12, which says monthly rent as above is subject to upward revision, but not less than 5% of existing rent every 3 years. And my lord, I remember Mr. Kaur had argued that this has come to an end by, my lord, the lease being executed. But once that lease has come to an end, this also is there. This is my stepping stone into the property. And if at all there is any provision in the entire dealing between the parties with regard to raising of rent or increase of rent, this is clause 12.
And you also said that this is being adhered to by them now also.
Even now,
Even after the expiry.
even after expiry, and they are issuing rent receipts without reserving their right to be as without prejudice and giving me a 10% rebate, being a good tenant. And all that is after expiry, which my lord also brings me within the fold of Lalji Tandem. So my lord, this act that now coming to the last portion, this act which Mr. Kaur has so harped upon, I have no issues to join there. If you have to institute a proceedings under that, they are free to. I am not asking any orders in respect thereof. I am saying by your conduct and in view of the law, the lease stands extended and are renewed. And even if without a registered deed of lease, by your conduct, there is holding over. And you have accepted that by a specific letter that the lease stands extended. Number 2, you have provided a rent which has no basis whatsoever. Absolutely arbitrary, 800% increase from the existing rent. All the tenants, all the association, the entire association has objected to. No basis has been disclosed, neither in the affidavit nor before your lordship. No, my lord, argument has been put forward by Mr. Kaur justifying why the government, my lord, the valuations which I have annexed to the reply, which is from the government of West Bengal side for short-term leases, both for 2018 and 23 are bad, which shows a premium less than what I'm paying. That is 14 point something. I'm paying 16 currently. No argument is addressed before your lordship. I have showed you that the valuation report that they have relied on is relying on things like I have inquired from the public in general, from the people around the area, from magic bricks, giving false particulars, which anyway would take the valuation there to the astronomical rate which they have proposed. I am saying this is a way of arm twisting the tenants, and this goes against the very object for which the respondent number 2 has been established. This cannot be allowed.
As per your valuation, it becomes lower than what you're paying now.
No, exactly. 14 point something it comes, but that's a government valuation. And my lord, most importantly, their valuation proceeds on the basis of sale of the property. This is not sale.
Yes, you said that. Yes.
It's not sale. The heaven and hell difference between sale and my lord short-term lease. But those are my submissions, my lord.
I'll close arguments. Heard learned counsel for the parties, judgment reserved. Yes. What is the
My lord, does your lordship, I don't know, my lord, does your lordship require a note of what we have argued? No.
I've taken my notes. Yes.
Item number 6, Pathat.
I was given 15 minutes, so I think I shall not be able to keep to the time.
Mr. Shah, take your time. Yes.
থাক
কোনটা রেফার করুন You may not finish today also, Mr. Shah, because
I think I will.
No, you may not finish also because I have already reserved 3 judgments after finishing my previous ones yesterday. Now, 2 of those I'm undecided. That's why the other one was pretty longish, so I did not. So that's why you can take your time in this. Yes.
I'm grateful, Malik.
Yes.
My lord, I was, my lord, on page 94 for a considerable period of time. Permit me, my lord, to engage your lordship for a further 5 minutes at page 94.
Yes.
Now, my lord, at page 94, your lordship has in the second line a date, my lord, 17th January 2020. Now, my lord, it says the account of Otibir Industries Company Limited has been running irregular since 17 January 2020. Now, my lord, there are other portions also, my lord, which I've shown to your lordship. I'll put it in my note if required. Where my lord, 17 January 2020, my lord, his account had become irregular. It's indicated in this letter as well. Yes. And while, my lord, he says, my lord, that the date of NPA is incorrect, this date, my lord, is not under challenge, 17 January 2020. Now, my lord, the moratorium circulars of the RBI, my lord, are from 1st March 2020. So, my lord, from 17th January 2020 to, my lord, March 2020 is 44 days. So, 44 days out of order. Then, my lord, assuming that, my lord, the period comes, the moratorium comes, assuming, my lord, the moratorium, my lord, arrests the NPA date from running, arrests the NPA date from running. My lord, I will try to, my lord, show to your lordship that, my lord, this moratorium date continued, my lord, not till November, which is, my lord, the impression that was being given to your lordship. It continued, my lord, till the end of, my lord, August, 31st August. Not beyond that. Now, my lord, if your lordship again, my lord, looks at, my lord, this document at page 94, your lordship will see I have declared him NPA with effect from 16th October 2020. Now, my lord, I want to explain to your lordship how I get this 16th October 2020 date, date. So, my lord, if I am able to demonstrate to your lordship that the moratorium, if at all, continued only up to the end of August, then, my lord, from 1st September 2020 to 16th October 2020 is the balance 46 days. Altogether, my lord, making 90 days. So, my lord, just, my lord, for the sake of, my lord, emphasis, if I may just, my lord, repeat myself. My lord, 17th January 2020 is the date when it becomes irregular. That appears to be, my lord, uncontested. Till 1st March, my lord, is 44 days. Then, my lord, I am excluding, my lord, from 1st March to 30th August. Then starting again from 1st September. From 1st September to 26th October is 46 days. Altogether, my lord, 90 days. Now, my lord, having provided some sort of a justification, my lord, for this 16th October 2020, which I was bound to do, my lord, because after all, my lord, if, my lord, a date has been given, my lord, then the bank should be able to explain the date. Now, my lord, kindly, my lord, for a moment, kindly, my lord, come back to the RBI circulars. The RBI circulars, my lord. কোন পাতা থেকে শুরু করছি বলো? No, it's in his application. Give it to me from his application. Yes, my lord, kindly have it from, my lord, page, my lord, 60. No, my lord, from page 61. No, not from page 61, my lord. It is from, my lord. Kindly have it from page 58, 58.
Yes, I have that.
Page 58. My lord, this is the first circular, 27th March. Now, my lord, this circular 27 March, last 4-5 lines from the bottom, my lord, falling due between 1st March to 31st May. The lordship has that. So this is, my lord, moratorium. My lord, I am not repeating, my lord, my submissions on moratorium, my lord, and how it must, my lord, pertain to a coercive action and doesn't really relate to the period. So, my lord, page 58, 27th March circular is 1st March to 31st May. Next circular, my lord, is at page 61, 17th April. My lord, 17th April circular also. My lord, your lordship will, my lord, kindly see at page 61. They repeat the 1st March 2020 to 31st March. Then, my lord, at the next page, page 62, my lord, in paragraph 5, your lordship sees my lord, quarter ended 31st March 2020 to quarter ending 30th June 2020. So, my lord, not less than 5%. So, my lord, your lordship will see page 62, my lord, at the top, from 1st May to 1st March to 31st May, such deferment period wherever granted in terms of facilities, including SMA, as on 29th February 2020, shall be excluded for determination. And, my lord, it goes on provisioning. So, my lord, if your lordship, my lord, really scans, my lord, this circular at page 61, my lord, your lordship will find that, my lord, this circular at page 61, my lord, first refers to the earlier circular.
Yes.
And thereafter goes on to say, even if overdue, last 3 lines, even if overdue, the moratorium period wherever granted shall be excluded by the lending institutions for the number of days past due for the purpose of asset classification under IRAC.
Classification is whether NPA or.
So, my lord, the asset classification is whether it will be NPA or it will not be NPA. Then, my lord, kindly, my lord, have the my lord,
Page 64, yes.
page, my lord, 64.
Right.
This is, my lord, the circular of May. Now, my lord, in the May circular, my lord, in the last paragraph at page 64,
yes,
you will see, my lord, for another 3 months, from 1st June to 31st August.
Right. Yes.
From 1st June to 31st August. So, my lord, this is where, my lord, the time stops running. So, my lord, it is not that, my lord, really speaking, the time stops running in November. It stops running, my lord, in August, 31st August.
So they say
Because,
that
my lord,
90
this-
days would be over from this date on November 30th.
No, my lord, I am coming to that. But, my lord, the moratorium period
Moratorium period ends on 31st of August.
31st of October. That is why, my lord, I told your lordship, recalculating again, my lord, from 1st September.
That is what they're, yes.
Then, my lord, on 16th October, which is, my lord, the date of NPA that I have now classified, it is another 46 days added to the earlier 44 days is 90 days. So, my lord, if I may, my lord, put my submission in this form, that, my lord, Mr. Bachawat's, my lord, sheet anchor being the fact, my lord, that the declaration of the NPA date is incorrect.
Yes.
My lord, there is, my lord, a very solid justification with regard to, my lord, the NPA date. So, even, my lord, after the moratorium period ends, I have not proceeded, my lord, to classify him as an NPA, my lord, till, my lord, 16th October. Therefore, my lord, I have taken care to, my lord, exclude that 90-day period. 44 and 46. Now, my lord, may I just show your lordship, my lord, one judgment of the Supreme Court, which, my lord, will go to, my lord, re-emphasize that, my lord, the moratorium ended when I say, my lord, it did. There was no moratorium thereafter. My lord, kindly have.
So after that, there cannot be any question of moratorium.
My lord, in any event,
unless
my lord,
that judgment is for the purpose of NPA declaration specifically, that's
yes,
obvious.
yes, and my lord, it is, my lord, whether, my lord, the moratorium should have been extended or not. My lord, a slew of applications were filed
No,
in
definitely.
the Honorable Supreme Court. And my lord, the Honorable Supreme Court says, my lord, that my lord, the moratorium has stopped on such and such date.
Yes, yes.
And you're not entitled to any further moratorium and banks can proceed.
No doubt on that.
So, my lord, that, my lord, is, my lord, I'll just, my lord, tell your lordship, my lord, small scale industry manufacturers, my lord, about 50, 60 writ petitions had been taken up together and disposed. Sir, interim order nahi bota. না দেখো interim order টা আছে এতে interim order যেটা হয়েছিল
Lord, may I just take 1 minute, my lord? My lord, what had happened, my lord, when my lord there was, my lord, writ petition, my lord, was filed, my lord, in the Supreme Court.
Yes.
My lord, with regard to, my lord, all these circulars, my lord, for their extension, etc. Now, my lord, there, my lord, where moratorium, my lord, the exclusion for the purpose of calculating NPA period, my lord, which was coterminous with moratorium, my lord, was also, my lord, an extension was sought. Now, my lord, by way of an interim order, in my lord, the final order, my lord, what they said was, my lord, that if there is, my lord, anything is NPA, don't declare it till the disposal.
Same
Oh,
order.
sorry, my lord, my lord, I was arguing before a
825, 826, probably two matters. One
yes,
is
my lord, there were several, my lord.
Yes, yes, but the order will be the same.
Yes. The order is now, my lord, kindly see at the request of so-and-so, matter is adjourned. Mr. Harish Salve, Lanet, submitted that no account shall become NPA at least for a period of 2 months. In view of the above, the accounts which were not declared NPA till 31st August, that is what fell, my lord, within, my lord, the period, my lord, where, my lord, the period for calculation of NPA was also excluded, shall not be declared NPA till further orders. Then, my lord, at the final disposal, my lord, which is the judgment my learned friend is citing, my lord, all of those, my lord, were, my lord, actually, my lord, all claims were negated. All that was said was that there will be no penal interest charged in respect of those loans. Which is why, my lord, the bank's letter, my lord, last time when my learned friend was arguing, my lord, I remembered this interim order, which I wanted to, my lord, point out, because they had become NPA by virtue of, my lord, the court order, my lord, the declaration didn't happen. So, my lord, 44 days, my lord, earlier, then 46 days, 90 days, my lord, it falls in October. That's when, my lord, it became, my lord, the account became an NPA. And there's no dispute, my lord, with regard to that. Because of court order, it wasn't declared. But, my lord, once the court order went, my lord, naturally, my lord, the effect was, my lord. And that's the judgment my learned friend is citing. It's, of course, reported as well. No.
My lord, having regard.
Yes.
My lord, having regard to the reference, my lord, to, my lord, NPA in this interim order shown by, my lord, Mr. Mukherjee. My lord, may I just, my lord, place this once again? Mr. Harish Salve, learned senior advocate, submitted that no account shall become NPA for a period of 2 months. So, my lord, really speaking, my lord, this was why, my lord, there was no classification. Now, my lord, your lordship will see this is only an interim order. It, my lord, contains no reasons. So, my lord, it doesn't really say, my lord, whether this was a concession made that no account shall be classified as NPA. But whether, my lord, the time stops running or not, my lord, we do not know, my lord, from this order. Therefore, my lord, kindly, my lord, permit me just to point out 2-3 paragraphs of this order, because, my lord, first of all, it makes no comment, my lord, on the, my lord, extension of the NPA date. And secondly, my lord, it refers, my lord, to the 23rd May circular, which is the last circular which I showed your lordship at page 64. My lord, kindly just have a few paragraphs. My lord, first, my lord, page 4, paragraph 1B.
Yes.
By way of writ petition number so-and-so preferred under Article 32, petitioner, practicing advocate has paid for appropriate writ direction so-and-so to extend the moratorium period till 31st December, which was lastly extended vide notification dated 23rd May. 23rd May, my lord, I showed to your lordship. It takes it up to 31st August. Next, my lord, kindly have Kindly, my lord, now have page 97, paragraph 3.2.
8.2.
My lord, it's
If
either
it's 97, it's
8.2. I'm so
Yes,
sorry.
yes, yes.
Now, so far as the prayer for extension of moratorium period beyond 31st August 2020 is concerned, it is submitted that the moratorium was permitted as a part of immediate regulatory response aimed at providing temporary reprieve to borrowers affected by the pandemic, while attempting to preserve the resilience of the financial system. It entails significant costs to the lenders, and a balance needs to be maintained in the overall consideration. A long moratorium extending 6 months can also impact credit behavior of borrowers and increase the risk of delinquencies. Post resumption of scheduled payments, it may result in vitiating the overall credit discipline, which will have a debilitating impact on the process of credit creation in the economy. It will be the small borrowers which may end up bearing the brunt of the impact. So, and so, my lord, this is, my lord, it says, my lord, so, my lord, the discussion is whether, my lord, the extension will be beyond 31st August 2020. Now, my lord, kindly have, my lord, paragraph 12 at page 113. Now, these are, my lord, the reliefs. Having heard learned counsel appearing on behalf of respective petitioners and
I'm sorry, this is page?
my lord, 113.
113.
113.
Yes, sir. Yes, sir.
Having heard learned counsel appearing on behalf of the respective petitioners and the relief sought in the respective petitions, the relief stroke submissions on behalf of the petitions can be summarized. So, my lord, these were the reliefs, my lord, that were being sought. Kindly take, my lord, relief, my lord, 6, relief 4, Roman 4. Extension of moratorium beyond 31st August. That was, my lord, one of the issues, my lord, under consideration. And now, my lord, kindly come to, my lord, the release granted at page 130. My lord, paragraph 27, my lord, at the bottom.
Yes.
Or, my lord, paragraph 27, if I may please. Similarly, the relief sought that the moratorium period should be extended and or the last date for invocation of the resolution mechanism, namely 31st December 2020, provided under the 6th August 2020 circular, should be extended to all, are in the realm of policy decisions. Even otherwise, almost 5 months were available to eligible borrowers when the circular dated 6th August 2020 was notified dated so and so. Therefore, sufficient time was given. Therefore, the petitioners shall not be entitled to any relief, namely total waiver of interest during the moratorium period. So they'll have to pay to extend the period of moratorium. So, my lord, this is, my lord, a relief that was specifically refused, and therefore, my lord, they remain restricted to 31st August 2020.
31.1.
This does not alter the scenario that the last date was 31st of August.
Lordship.
Does not shed any light on NPA classification.
My lord, it does not. And my lord, this is, my lord, your lordship will kindly read that in the light of, my lord, the interim order. Because in the interim order, my lord, assurance was given that no account will be marked as NPA. But there is no comment on that. Therefore, my lord, this was untouched.
Last line is the order.
Yes, my lord, your lordship will kindly, my lord, take paragraph 31.1 at page 146.
Yes.
Even otherwise, it is required to be noted that compound interest, interest on interest shall be chargeable on deliberate willful default by the borrower to pay the installments due and payable. Therefore, it is in the nature of penal interest by notification dated so and so. The government has provided the deferment of installments due and payable during the moratorium period. Once the payment of installment is deferred as per circular dated so and so, 27th March, non-payment of the installment during the moratorium period cannot be said to be willful, and therefore there is no justification to charge interest on interest, compound interest, penal interest for the period during the moratorium. Therefore, we are of the opinion that there shall not be any charge of interest on interest on interest, stroke compound interest, penal interest for the period during moratorium from any of the borrowers, and whatever the amount is recovered by way of interest on interest, compound interest, penal interest for the period during the moratorium, the same shall be refunded and or be adjusted. Now, my lord, kindly have paragraph 32, the last, my lord, 2 lines. My lord, at page 147, last 2 lines.
Yes.
All these petitions are partly allowed to the aforesaid extent only and observed for the reliefs. The petitioners, and as observed for reliefs, the petitions are dismissed. Interim relief granted earlier, not to declare the account of respective borrowers as NPA stands vacated, there will be no orders.
What is the insinuation, Mr. Shah?
Malad, the insinuation is, Malad, that
Your
Malad,
tones and dramatic.
Malad, I'll tell your lordship.
Does not alter the situation at all. I mean,
No, Malad,
whatever was there remains.
Malad, may I
This
just,
order is the refusal of further extension of the moratorium.
Malad, may I just add, Malad, the
The
probable,
148-page judgment.
may I just, Malad, add the probable 2 bits? Just the probable 2 bits in 2
Probable
minutes,
two-
2 seconds.
Yes.
Malad, the implication would be thus. Now, Malad, firstly, Malad, your lordship was, Malad, considering whether, Malad, the NPA date, Malad, there's a pause or arrest on that.
Yes.
So, Malad, the pause and arrest on that was by reason of the interim order which Mr. Mukherjee showed to your lordship. It was not by operation of the statute, and that, Malad, is the last line. It vacates, Malad, the interim order.
Do you mean to say the interim order implies that there could be an NPA declaration even during the
Yes,
moratorium?
yes, because, Malad, that was, Malad, a concession
lang-
given because the matter was being heard.
The language is the accounts which were not declared NPA till 31st of August,
Yes.
not till the first date of the moratorium. I mean, if it was said, I'm speaking in your favor for the timing. I mean,
Yes, yes, yes.
if it
For a change.
the accounts were not declared NPA till 31st of August 2020. So it could have been declared on, say, 30th of August 2020 also, apparently, as per this. So if
Yes.
that is deduced, then if Mr. Bachawat's view was taken, probably it would be not declared, I mean, which were not declared NPA till 1st of March 2020.
Malad, may I just,
I mean-
Malad, may I just point this out further? Malad,
Probably I'm
kindly,
not clear on this, Mr. Shah. I mean to say that this says which were not declared till 31st of August 2020. Now, 31st of August 2020 is the last date of the moratorium.
yes,
Now, if the language was the accounts which are not declared NPA till 1st of March 2020, which is the starting point of that moratorium, then probably their argument would be more valid, because then it would be the entire interregnum would be
Off.
obliterated, off, yes, off,
yes.
and it would start afresh. But as per this, maybe your logic is sounder in a sense, in the sense that which are not, they could have been declared till 31st of August.
Lordship.
They could have been declared even on 29th, in a sense, I mean.
Which were not declared
The issue
LPA.
has been laid down in this, but we'll consider this. This is a stray comment, and that too on a
Accounts which were
semi-concession.
not declared NPA till 31st August shall not be
But this
declared
is on a
NPA.
semi-concession by Mr. Salve.
Now, Malad, your lordship will kindly see.
Yes.
Malad, your lordship, Malad, as Malad, it's fallen from your lordship. Your lordship says, Malad, accounts which were not declared NPA. He does not say that accounts could not have been declared NPA after, Malad. So, Malad, it is on the basis of, Malad, even if your lordship takes it, Malad, as the basis of, Malad, any concession, whatever, Malad, the case may be, Malad, there it says that it could not. Now, accounts which have not been declared for further 2 months, for the further.
It is not even an obiter for any proposition, Mr. Shah. Not even an obiter for any proposition. Not even a non-obiter for any proposition. It is not a proposition at all. I mean, yes, that was the understanding on that particular date on the basis of.
Malad, all that I'm saying is, Malad, that your lordship will kindly see that, Malad, so far as the NPA is concerned, matter is concerned, Malad, there is absolutely, Malad, no, Malad, observation, either, Malad, direct, Malad, observation in the circular itself,
Yes.
or, Malad, in the Supreme
No,
Court
no,
order, to the effect, Malad, that, Malad, the NPA date will be, Malad, arrested upon the commencement. Because, Malad, everything is running, interest is running, everything is running.
Yes, yes.
Penal interest, Malad, has been struck down. Interest on interest has been struck down. But
And interest
otherwise,
was not running in that sense.
no.
Because Justice Shah's this paragraph 32 or some other
Yes.
that says no interest on interest. It was
No
not
in-
running apparently.
No interest on interest, but the interest that is, Malad, going to run regularly. The Malad, if you, my lord, the interest that is payable, my lord, on the loan is continuing to run. It is, my lord, supposing there is an installment due
That's
on
postponed.
that date. That is postponed.
That is postponed, but there cannot be any overdue then, Mr. Shah.
My lord, the overdue in this case, my lord, is already in 17 January 2020.
All right, that logic comes in your argument regarding that
Yes.
44 plus 46. So that remains.
Lordship.
That is the soundest logic actually.
Lordship.
These judgments do not say anything on NPA basically.
Lordship. Lordship.
Thank you. So I'll close arguments. Heard, learned counsel. Oh, I'm sorry. Yes. Very well, we'll continue tomorrow.
Tomorrow it would be Monday.
Monday is the comment. Original said not too many matters. Very well. This will appear at fairly at the top on Monday. Part heard for further hearing on August 7, 2023. Fairly at the top of the list. Common list open to have fairly one at the original series are top nature. This will be the top matter probably.
Yes. If the lordship will kindly permit me to join over the virtual mode, my lord,
Yes,
if I may.
Thanks.
Thank you.